Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention to a trial out of Massachusetts. This is Kelsey Fitzsimmons. She is an officer. She was shot by a fellow officer. And we're going to do a deep dive today into this trial that is starting. Let me just make sure my audio is okay. Let me turn myself up a little bit. Yeah, it's a trial that's starting tomorrow. So we're doing our deep dive today. So let's get to it. All right. Welcome in, everybody. How's everybody doing today? We are going to be doing a pretrial prep deep dive into this Kelsey Fitzsimmons case that's coming up, trial, I should say. So before we get started, everybody get comfortable. Texas Cat, thank you for the food. I thanked you, I think, on Friday. I'm not sure if you were in the stream, but thank you for the food. And Debbie, I know I thanked you. Thank you again for the food. Kitties love it. So, Aussie Gardner, Jenny G, Lily Wayne, Elaine, good to see you guys. Happy Sunday to you all. Debbie, Shirley, Crazy Mary Jo. You've seen several bench trials. Swear they seem more squirrely than jury trials. We'll find out. The one other one we watched was Jose Ibarra. Oh, no, wait. There was one, Nixon was his name, out of Cleveland. Can't remember his first name, but he was pro se as well. That was really interesting. All right, let's see. Richard in the kitchen. How are you? Oh, I made lemon pound cake. Richard, I can't wait to see your version. Wizard, good morning to you. I videoed it. I filmed it. I just have to record it. I just have to put it together. I'd probably be working on that now, but we're doing this stream instead, which is fine. Allison, good morning to you. Good afternoon at this point if you're on the East Coast. Joy, good to see you. Thank you for joining us. Christy, Katrina. So you guys are saying the poll is gone. The poll is still up. How much do you know about this case? I'm still seeing it. Maybe refresh. Try refreshing, you guys. See if that helps. Hey, Selena, cleaned out your garage. You sat down. First time you're sitting down. Let's see. Lily Wayne, hello. Let's see. I think I got everybody. Horse welfare. Let's see. I think I caught everybody. Let me just make sure that I see everybody coming in. Linda, there's the poll. Yep, Lori. Barry, good morning. Just Shamrock, good to see you. Well, now it's afternoon for us, but let's see. Texas, you heard about from Turtle Boy? Yeah, he's been all over it again. Melanie Little as well. She's been covering it, I think, for a while now. So we've heard about it, but we haven't really. Now we're going to really dive deep into it. Hey, Joan, you know nothing about it. Looking forward to hearing more. Awesome. Dream Horse, good to see you. Dina, BFM, looking forward to learning more about it. Fantastic. Nanar, good to see you. Katie, hello, hello, welcome in. All right. So let me give you a quick teaser. I'll give you a quick tease. I'll give you a quick tease. All right, here's my, oops. All right, here's my effort. So that's without, all right, let me just, all right, so that's without the drizzle. And Richard, I screwed it up. When I do the video, you'll understand. I mixed a bunch of ingredients I shouldn't have, and then there's it with the drizzle. So I mixed. When I do the video, you guys will see what I'm saying. It turned out really good. For some reason, it turned out really good. So whatever I did, it actually worked. So anyway, there's my ode to Afro Man and his lemon pound cake. It's good. It's not his mom's version, but it's a version I found. All right. So let's get into Massachusetts versus Kelsey Fitzsimmons. All right, this is a really, really bizarre, twisted case. All right, so Kelsey Fitzsimmons, she's the defendant, but she's also the victim because she got shot. Right? She got shot by her partner. All right, so it gets really odd. All right, so she's 29 years old. So this happened last year, June 30th, 2025. She was initially charged with more charges, but then once it went to a grand jury, and we'll get into that, it went back to, and essentially it ended with assault with a dangerous weapon. All right. So the judge is Jeffrey Karp. We have prosecutors Marina Moriarty and James Gubitos. And then we have defense Timothy Bradle, who is private, and he is Turtle Boy. He has represented Turtle Boy. So if you guys know that name, that is, he's a representative. He's represented Turtle Boy before. So again, you may know that name. All right. So this is a bench trial. It takes place in North Andover, Massachusetts, and she was a police officer. She has since resigned, but she was shot by her fellow officer, who ends up, it was her partner, right? And there was three of them, and we have surveillance video from her home, not of her actually getting shot, but her letting the officers in. So they were coming to serve a restraining order on her on June 30th. All right, so this incident stems from a restraining order obtained by her fiancé and the father, right? So she's about to get married to this guy. She's engaged to get married to Justin, and I'm going to butcher his name, sorry, but Aylaian. I have to hear his name, but anyway, I'll just call him Justin for now. So he's 32. So he alleged that Fitzsimmons posed a danger to both himself and their infant. And that's a son. We'll get into that. Baby C, they're calling their son. Now, while officers were serving this order, a confrontation occurred that ended with Fitzsimmons being shot, right? And she was off duty, okay? Prosecutors allege that Fitzsimmons pulled a firearm during this encounter while her defense team disputes that claim. So it all boils down to this. Now, she's saying that she was trying to take her life, okay? So we'll get into that further. So the two conflicting accounts have emerged about this. The officer who fired, a one-time partner of Fitzsimmons, says he feared for his life after Fitzsimmons suddenly produced a firearm and attempted to shoot him. Fitzsimmons, however, maintains that she drew the weapon with the intent to harm herself and never pointed it at another officer. Now, sadly, there's no body cam. Okay, that's what's really going to be the bummer here. There's no body cam. So she's saying that she pulled it and she was pointing it at herself. That her partner thought that she was pointing the firearm at him. So as a result of that, she was hospitalized for 53 days. She suffered a collapsed lung and broken ribs. So he shot her basically, I think, right here in the upper part of the chest. She's lucky she's still alive, to be quite honest. Now, apparently intoxicated at the time, Fitzsimmons was ordered not to consume alcohol and must comply with alcohol breath testing used at in-home device. Now, this alcohol testing requirement complicated her release for months, and we'll show video of that. She was briefly released in September of 2025 under similar conditions, including mandatory breath testing, but was returned to custody just days later. 3 days later, right? 3 days. Her legal team told the court that her injuries made it impossible for her to use the device, stating attempting to blow into the device caused severe pain and dizziness. And we have a pretrial hearing. We're going to show that. We'll show that hearing. Now, she appealed the lower court's decision in the Massachusetts Supreme Judicial Court, arguing that alternate forms of alcohol testing should be permitted. That, however, was denied. Mallory, welcome in. Thank you for your $4.99. Thank you so much, Mallory. Appreciate it. Good seeing you. Hola, good to see you. Dennis, hello. Welcome in. Granny Debbie, welcome in. Welcome in. She was not intoxicated, you're saying? Okay. Jedi Jen, good to see you. CJ says. Gretchen, good to see you. Mal. Oh, there's Mal. Yep. Mallory. Downey Lynn, good morning. Good morning. Welcome in. All right. However, during a subsequent hearing, Fitzsimmons and her attorneys presented updated medical evidence showing she had sealed significantly to safely complete the breath tests. An Essex Superior Court judge then granted her release. So I think she was then staying with her mom, and then they said, no, you can go stay on your own. So again, we'll get into all of this. This is just real high level right now for us, just to kind of wrap our heads around what's going on. Now, in recent developments, a judge has allowed her to move out of her mother's home, as I just stated, and removed an order barring her from seeing her son, though she remains under conditions including GPS monitoring, house arrest, and no alcohol consumption. Now, earlier in 2025, Fitzsimmons had been diagnosed with postpartum depression, having given birth February 16th, 2025, to her son, baby C, but had been medically cleared to return to duty prior to this incident. So she gave birth to her child February 16th. This happened June 30th. Okay. So Fitzsimmons filed a motion outlining a series of allegations against Justin, a North Andover firefighter. All right. So she's an officer. He's a firefighter, including claims that he broke into her home on July 3rd of 2025 after he had already moved out. In an affidavit dated June 28th, he listed his residence as being in Stowe. I'm sorry, this happened July. I misspoke. No, it did happen. Happened June 30th. Okay. So since the incident, Fitzsimmons has resigned from her job with the North Andover Police Department. She has been charged with 1 count of assault with a dangerous weapon. If convicted, she could face up to 5 years in prison and probably will never see her child again, or it'll be very, very difficult. Now, here's a little bit of the timeline of their relationship and some background. So, November 23rd to March 24th. Kelsey Fitzsimmons begins a relationship with Justin. He moves into her North Andover home. And in May of 2024, she graduates from the police academy and becomes a North Andover police officer. Now, like I said, this is a really interesting, interwoven, not necessarily twisted. I suppose you could say twisted, but it's really like the players are really woven together. So she just graduated in May of 2024. So August of 2024, just a few short months later, she responds with Officer Noonan. So keep that name, Patrick Noonan, Officer Noonan. They respond to a deletion, murder suicide involving a mother and an infant. So keep that in mind, right? That's really, really huge, right? So she's a newborn, or a new mother, if you will. She's got an infant, just a couple months old. Oh, no, wait, I'm sorry. She's pregnant at this point. Yes, you're right. She's pregnant. I'm still wrapping my head around this, so please forgive me, you guys. Don't jump on me. I'm still wrapping my head around this. So she gives birth in February of 2025. So she's pregnant with her child at this point. So she responds to this. So she was approximately 20 to 22 weeks pregnant. So she later describes this call as deeply traumatic, and we'll read her statement. I'm going to read her statement in a little bit, and she describes this with her partner. She identifies it as a catalyst for later mental health struggles. Now, critical relationship details. This experience brought her closer to Officer Patrick Noonan. Okay, that's her partner. They formed a bond after going through that scene together. Trauma brings people together. We see that all the time. If you experience any kind of traumatic, if you experience something traumatic together, that's a shared experience. You're gonna become closer. I've thought that. I've thought that for years and years and years, decades even. All right, so full circle significance. Noonan is later the officer who shoots her. All right, so Patrick Noonan is the one who responds to giving her, responds to that call to serve her a restraining order, and then he ends up shooting her. All right, so phase 2, mental health context. So then March 2025, about 3 weeks, she's diagnosed with postpartum depression. So she begins treatment immediately, and she remains in active care. Now, here comes the relationship breakdown. So May of 2025, this is around Mother's Day. So there's an incident captured on home surveillance. Justin, allegedly, he's intoxicated. He falls in the shower. He's seen smoking marijuana inside the home. Now, he's a firefighter, right? So he's drinking, he's smoking. Apparently, she's drinking, so she has to be monitored. So I'm guessing that these guys, they like to drink. Now, Justin's a firefighter. We already talked about that. Now, this raises questions about his judgment, his credibility, custodial fitness, right? So he's trying to take baby C away from Kelsey, and then he's acting like this. So they go to Maine, June 27th, 24th. They have a significant argument. They return home. Justin moves out of the shared residence, and then the final breakdown before legal action. Now, there was some talk that Kelsey punched him 3 times with a closed fist, and that I think his a family member was there, and they were in the other room. So maybe that trip, I'm not sure. But there was an incident where she punched him 3 times with a closed fist. Now, phase 4, the trigger event. Now, here's where the conflicting narratives begin. So June 30th, right? So this is the day she shot. This is in the morning. So Kelsey says that Justin called her to meet at a park with their baby. So she waits about 3 hours, and Justin never shows up. So she goes home, and she's feeding baby C. And this is when Patrick Noonan, Officer Noonan, and 2 other officers arrive. And she's told they have a restraining order, and the baby will be taken from her. Her firearms will be revoked, and her career is at risk. Can you imagine? You're just sitting there. You got a newborn, a couple months old. You're having problems with your fiancé, the father of your baby, and all of a sudden, 3 officers knock on your door, and you know one of them. You went through this traumatic incident with them, and they're saying, guess what? You have a restraining order filed against you. We're going to take your kid. Your fire weapons license is going to be revoked, and you may lose your career. And she had just started a year before, and she's already going through postpartum. I mean, just think about that. That's pretty heavy for anybody to take, but especially somebody who's 29 and just all of a sudden your world just collapses. So that's her account. Now, Justin says, he took a restraining order ex parte, which means it was just him, and he has temporary custodial custody of baby C. So he went into a judge. He said, Judge, I have reason to believe that this person is not fit to take care of this child. I want temporary custody of this child. And the judge granted. And I think it was that I guess hearing or what, I don't even know if it was a hearing. I think you just go in front of a judge. That's when Justin said that she struck him 3 times with a fist, and they were behind a closed door, and it made so much commotion that his family members came in or something like that to see what happened. So the judge didn't look into any of that. They didn't send CPS. They did nothing. They just said, okay, we're going to give you temporary custody. Again, can you imagine? Kelsey's world just exploded. All right, so immediate emotional collapse. Now, Kelsey says, after learning of this, after these officers and her partner come and say, we're taking your kid away, so she goes and she packs up items for her baby. She hands the baby over to an officer, and she goes into her bedroom. Now, she says she felt her life was turned upside down. Understandably so. She no longer wanted to live, right? That's what she's saying. Now, here's where this is where the rubber hits the road. This is the core dispute. She gets her firearm and she points it. Now, they're saying she gets her firearm and she points it at the officers and creates a deadly threat. She's saying she was suicidal and she only wanted to harm herself. She said she never pointed the firearm at her officers. She said the firearm was directed at her head, right? So she just hands off her baby, and then she gets her gun and she's going to point it. She points it at her head. She said she pulled the trigger. She actually pulled the trigger, but it did not fire. So that would have been it. She would have been gone, right? Then, because a firearm was brandished and Officer Noonan thought, who knows what's going through his head? He sees somebody with a gun doing whatever, so he shoots her in the chest. He fires 2 shots, and she's struck in the chest, and then she's med-flighted to Mass General. And then, of course, Justin takes immediate custody of baby C. So again, there's no body cam. There's no body cam to determine what happened. She's pulling out a gun, and her partner shoots her because that's what you're trained to do, whether that's your mom or whether that's your brother or whether that's your partner or your wife or your husband or whatever. I mean, I guess if it was, you would have thought that maybe he could have done something different, and I'm sure they're going to get into that in the trial. But his first reaction was, wow, here she pulled a gun and he shoots her. Now, post-incident controversy. So surveillance allegedly shows Justin and 3 others entering the house. Now, we don't have that yet. And removing items, accessing property. So this is after. This is a couple days after. Happened June 30th. This is July 3rd. So the defense is saying, hey, you're tampering with evidence and you're contaminating the scene, right? Prosecution disputes that significance. Now, July 4th, Justin's mother requests police protection. So here's where mom comes in. So here's where the mom comes in. So I know Barry has been saying, is this a Donna Adelson, Wendy Adelson thing where they just wanted the baby? So is Mama Aylaian, is she Donna? We're gonna have to find this out. So anyway, she files a police protection request for police protection. So August 7th. Kelsey's arraigned from the hospital, right? She spent 53 days in the hospital, don't forget. So she was initially charged with armed assault with intent to murder, and then 2 assaults with a dangerous weapon. So August 25th, however, that grand jury reduced it to just 1 count assault with a dangerous weapon. Now, August 28th, she pled not guilty, and she's released with strict conditions. And we'll show all of this. We have video. We're going to show all of this. So here, then we get into the custody and control battle. So September 8th through September 12th. So she's released with multiple conditions. The defense filed a motion to modify the scram conditions to another method that she can blow into the device. So scram, and we're going to show this. Aaron put together this really great video. Scram is essentially just to check your level of alcohol. So it's basically it involves a lot of things. It's not just blowing into a device. It checks your identification. You can have GPS monitoring, but essentially just real high level for now. It's basically people that, instead of going into drug court like we heard with Carmen Lubner and doing a urinalysis, you just blow into this thing and this device, and it uploads it, and it says you're not intoxicated, and then you can continue on. So that's basically what it is. So this Judge McCarthy Nayland, she denied it, and she sends her back to jail. Right? She sends her back to jail. So again, we're going to watch this. And you guys tell me what you think about this judge. She's not the trial judge. It's another trial judge. But you guys tell me what you think about her. Just again, keep that in mind when we watch it. September 16th of last year, Justin files a motion to attach real estate for the payment of child support. October 2025, defense files appeal for reincarceration. So they want to put her back into jail. Now, phase 10, the fallout. So November 2025, Kelsey sells her home to fund her defense, and she adds $50,000 to a fund in child support. So don't forget. Justin files a motion to attach real estate for payment of child support in September. So then in November, she added $50,000. Kelsey added $50,000 for child support. So it sounds like she's doing the right thing, right? Seems like she's trying to do the right thing here. And her appeal for reincarceration was denied. So she's sending child support to Justin. A lot of it too. $50,000 is a lot, I think. Especially if that's only going to be for a couple months or a year. Who knows how long that's going to be. So now January. So now we go to January. So Judge Kathleen McCarthy Nyman, was reassigned by the chief judge, so she's no longer on the case. Now keep that in mind because we're going to hear her. We're going to hear from her, and you guys tell me what you think about her. So she is replaced by Jeffrey Karp. Now we're going to find out what his deal is too. So January 16th, baby C is baptized, but only Kelsey's stepsister is the only one allowed to the ceremony. So pretrial escalation, February 26th, just a couple of weeks ago, like a month or so ago, the DA declines criminal charges against Justin. So the DA is not going to charge Justin. So that seems, right, that's a little interesting. March 7th, Justin gives an interview defending his actions of breaking into the home. March 13th, we have the new judge. Bail conditions are eased. March 19th, which is just now just a few days ago, that's when she waived, Kelsey waived a jury and she wants a bench trial. And then, of course, the trial is going to start the 23rd, and then we have the family court hearing is on April 14th. So, Snowcat, how are you? Let's see, Just Shamrock. I think there are many complexities in this case. To be fair, I know my comment may be unpopular. Kelsey's background and previous arrests are also a valid piece of the puzzle to be aware of. That's good to know. I did not know that. Yes, it's a portable breathalyzer, face recognition. That's pretty much sums it up. Selena K, yeah, there's a lot of twists and turns in this. There are a lot of twists and turns. Mamala, hello, welcome in, welcome in. All right, we got a full day ahead for you guys. Hey, Missy, we like different opinions. It can help us think a bit more. Lori, the new judge seems very fair, and I agree with the bench trial. All right, we have a full day ahead. We got like 7 hours of video to watch, so let's get to it. All right, so we're going to start with the press conference. This is the press conference from July 1st. So this happened June 30th. So this is July 1st. This was a press conference. All right, so let's get to it.
District Attorney for Essex County. I'm here with Chief Gray and members of his command staff. First, let me say thank you all for your patience last evening. As you can imagine, when an event takes place at 6 p.m. and we're all looking for answers, I know you had lots of questions last night, the public had lots of questions, but we thought that everyone would be better served by getting as many preliminary facts as we could and then putting it out today, obviously with an eye toward being as transparent as we can given the circumstances. Last evening, shortly after 6 p.m., 3 North Andover police officers went to 125 Phillips Brook Road in North Andover. The purpose of going there was to serve a court-approved restraining order. The subject of the restraining order was 28-year-old Kelsey Fitzsimmons. Ms. Fitzsimmons was an off-duty North Andover police officer. She has approximately a year and a half on the job here with NAPD. 3 North Andover police officers were on the scene, one of whom was a supervisor. When one of the officers was escorting Ms. Fitzsimmons during the service of the court order, an armed confrontation took place. As a result of that armed confrontation, one of the responding officers discharged their weapon, which struck Ms. Fitzsimmons once. She was immediately given medical care. She was med-flighted to a Boston hospital, and as of this morning, we're told she is in stable condition. The officer that discharged the firearm is a veteran officer, having served over 20 years with the department. Now, as you can imagine, we're only about 16 hours out from this incident. There are still lots of questions. There's an ongoing investigation. Currently, the investigation is being done by Massachusetts State Police detectives assigned to my office at the Essex DA's office, under the direction of Captain John Costa and Detective Lieutenant Robert DeMeo. There are lots of interviews to be done. There are lots of pieces to be put together. There's lots of things that remain unanswered, but for now, we want to make sure that the people of North Andover and across the Commonwealth know as much as we can give out at this time, being as transparent as we can. We also know that serving restraining orders, court-approved restraining orders, are sometimes some of the most dangerous duties that police officers uncover, no matter who the object of that order is. Chief Gray has been a great partner with us, not only through this investigation, but through many others. I wanted to make sure we give the chief an opportunity to speak, particularly about his officers, and sometimes we worry deeply about the wellness of our police officers as well, particularly in difficult circumstances, so they're in our thoughts. Chief Gray.
Thank you, sir. Thank you. Just some quick words on what happened. It's an ongoing investigation, like the DA said. There's not much we can talk about. We're concerned for all the officers on duty and off duty, and we're just going to monitor and hopefully get some results.
Okay. We will be able to take some questions, and to the extent that the chief and I are able to answer them, we will. As you can imagine, over the next few days, we'll probably be getting more answers. There are lots of interviews being done. State police detectives worked well into the night last night. We spoke with them this morning. They're already at it this morning. So to the extent that we can answer some questions, we will. Some we may have to defer for a little bit more time. We're going to make sure that what we do give you is accurate information rather than speculation. I know you all appreciate that as well. So having said that, we can take some questions and we'll do the best we can to answer.
Was the off-duty officer armed, and what precipitated the on-duty officer to fire at her?
So what we're saying is accurately that there was an armed confrontation. In terms of the details of that and how that came to be, it was during the service of the court-approved restraining order. But the very granular details we're waiting to speak on until we get the interviews back from our state police detectives who are speaking with the North Andover officers that were involved.
How about the restraining order? Can you tell us what all the nature of that, who was it for, et cetera?
So I can't comment on who the plaintiff was, but I can tell you that a court order, there are check boxes. Oftentimes it's stay away from, no contact, and turn over all firearms. So the restraining order was a standard 209A filed by the plaintiff and served by the North Andover officers.
Were the officers going to retrieve her weapon?
Pursuant to the court order, one of the standard boxes to check is retrieval of any firearms in the home. That's standard operating.
Can you say where she was struck?
No, I'm not going to comment on the medical condition at all.
Can you say how many people were in the house at the time, including Ms. Fitzsimmons?
I can tell you that there were 3 North Andover police officers. In terms of other people in the house, until I get the full reports back, I won't be able to tell you how many and who they were.
Is there any body camera footage of what happened?
We're actually looking to see what camera footage is available. I have not seen any, and I don't have any reports on any.
Do North Andover police officers typically have body cameras on when they're executing these court orders?
No, the North Andover Police Department does not use body cameras at this time.
Can you speak at all to her mental health, and also was this related at all to her efforts to have her weapon was taken away from her, and then she had sought relief in the courts, and I think it was Friday she dismissed that. Is this related to that at all?
So the scope of our investigation right now is the actual armed confrontation. I'm sure that there'll be further information coming out. I'm sure that North Andover PD will be looking at that as well. But in terms of commentary on her mental health, I'm not comfortable speaking on that at this time.
Can you talk at all about the efforts that she sought to have her weapon given back to her? Can you speak to that at all? What that situation was and why?
So, Chief of Personnel Matter?
Personnel matter,
Yeah.
yes.
Okay.
Chief, sorry, go ahead.
Yeah, it is a personnel matter, so we aren't going to speak about anything like that. Yes, ma'am.
I know you guys are pros, but can you speak about how you're all feeling today? Not just the 3 responding officers, how you're feeling? What's the mood?
I mean, it's a critical incident, and like a lot of critical incidents the police officers deal with, we all have our own way of getting through it, whether together or by ourselves, and this is no different.
Chief, she was a member of the department. Did she know the officers who were coming to her home? Did everyone know each other?
I would assume so, yes.
Can you talk about her as an officer on the department, what she was like, why she wanted to become a police officer?
At this time, I'm not comfortable talking about that sort of thing.
How about in terms of charges? I mean, will there be some charges at some point? I mean, I would ask you just one other thing. That we have reports that she may have been involved in an incident in Maine at an Airbnb over the weekend and then was involved in an accident on the Maine Turnpike. Is there any truth to that? Can you speak to that at all?
Not specifically as to what occurred prior to what we've spoken about already, but what the lead up to it certainly would be something that would be part of the investigation. And you had a first part.
I just wondered about charges. At what point in time would she be charged? Would you wait till she came out of the hospital? Do you know how long she might be there?
So we don't know how long she'll be treated. The good news is that she's in stable condition. In terms of charging, there will be meetings between our state police detectives and our senior trial team. We've already met this morning. As of right now, I can't tell you what those charges will be, except to say that our senior trial team will be working with the detectives, and to the extent that charges will come forward, they will fit what took place here.
Well, I'm sorry, but in terms of what's her status with the department right now? She's suspended, administrative, etc.
Right now, it's on administrative leave.
How about the other officers? Are they on leave?
Again, this is like the DA said, they're 16 hours old, so we're assessing the other officers, and we're going through our policies and determining what sort of action is going to be taken as far as time off or any sort of other methods.
Are you able to say how long she's been on administrative leave?
I think we'll just leave it that she was on administrative leave. And I also
At
just...
the time of the incident, she was on administrative leave?
She was, we'll just say she was on administrative leave, and that leave obviously is now going to be extended. So we'll just leave it at that. I do want to make a comment, though. There's been 3 questions, and I think that all of them are very good questions when it comes to officers' mental health. And think about the things that police officers have to face. Now you take a look at the circumstances that are known to us that occurred in this particular incident. We worry deeply about the mental health of our officers. I know Chief Gray does worry greatly about his officers, as do I. I was a 32-year police officer myself. I know the struggles that the officers have, and I appreciate the questions, and I just don't want it to be lost in the swirl of the headlines that these are humans. These are police officers that have to make quick decisions, that use of potentially using deadly force. This is something that should not go unnoticed or unappreciated by the public. So I appreciate your questions on that.
Is she under guard at the hospital?
So we never comment on if somebody's under guard or what the security is at the hospital. That's just something that we routinely do not comment on.
I sort of asked this question before, and you may have said that you couldn't answer it, but related to her weapon, did she have it in possession at the time of this or not? I know you said that the boxes are checked, and
yep.
Did she have? Has her weapon been returned?
So we're not commenting on the weapons. All I can tell you is that on the order there was a check box if there were weapons home to retrieve them, which we would have done if they were there. So, all right. All right. Well, thanks, everybody. Again, I appreciate your patience last night and coming back today. I know this is a matter of great public interest, and we wanted to make sure that rather than come out last night and not really have much for you, we'd rather than be expeditious about it, we wanted to make sure that we were accurate and factual. So to that extent, I want to thank all of you for coming back. So I appreciate it.
All right, so that was a press conference from the day before. The day after, so 16 hours. So that happened June 30th. So she gets shot June 30th, and I'm going to show the surveillance. It doesn't show her getting shot, but here let me show this, and then I'm going to read her statement of what happened before we get into all the other news and the pretrial. So that was 16 hours after she got shot. So that was from last year. She got shot June 30th of 2025, and this that was July 1st. All right. So this is her home. Again, we're not going to see her actually getting shot. So this is just the officers coming to serve her with the restraining order, and one of these officers is her partner, Officer Noonan. And this is only 30 seconds. It's real quick. But there are the officers at the door. Now, again, there is no body cam. There's no body camera. So this was at 5 o'clock. It's 10 minutes to, it's 4:49. So basically right before 10 minutes to 5 o'clock. So here she is letting him in. So she knows one of these is her partner, or was her partner. I'm not sure which one is Officer Noonan, but I'm sure we'll find that out. So that's all we get. So that's that. All right. So next I want to read her. This is her statement. All right. So this is her statement. All right. So this was July 17th. She released this, right? So this happened June 30th. And then this is July 17th. So this was a press release that she put out. This is from Timothy Bradle, or Bradle. Is it Bradle? I'll go with Bradle for now. Please direct all inquiries to Attorney Bradle. Please do not attempt to contact the Fitzsimmons family. All right, so this is in regards. Rafa had his paw. He's so funny. He goes to scratch on the chair over there, and then he gets himself caught. He does that all the time. Jenny, no, her officer, professional. It was her partner, not her lover, not her spouse. No, it was her professional partner, Officer Noonan. They remember at the top of the stream we went through that. It was she was a rookie, and they went to investigate a murder-suicide. A mother, I guess, killed her infant as well, and they were on that call together. So they shared that experience together. So that's her professional partner. Roger's doing fine. Roger's doing fine. Thank you for asking. Yeah. No, he's fine. He was fine. Like the next day, he was fine. So appreciate you asking. All right, let's read through this. All right, so North Andover police officer Kelsey Fitzsimmons releases a statement to set the record straight. It's time to end the PR war on North Andover police officer Kelsey Fitzsimmons. As Kelsey recovers from her life-threatening injuries, she cannot sit idle any longer. In our first press release, we were honored to speak for Kelsey when she was fighting for her life and could not speak for herself. As stated, we would have preferred to address the facts of the matter in court, but Kelsey believes it is imperative that since she has been battered with leaks from negative and false allegations, she speak out now to set the record straight. So, statement from Ms. Fitzsimmons. Okay, that's terrible. I'm not going to do that. My name is Kelsey Fitzsimmons, and as I recover in my hospital bed, I am ready to speak about the incident that took place on June 30th, 2025 in my own home, where I almost lost my life and was diagnosed with postpartum depression in March. Where I almost lost my life. I was diagnosed with postpartum depression in March of 2025, approximately 3 weeks after giving birth to my beautiful baby boy. I have actively been in treatment since the day of my diagnosis and was eager to heal and feel like myself again. Unfortunately, healing a sickness does not happen overnight. However, what can happen overnight is my life turning upside down into something so horrible, my mind wouldn't even be able to imagine it if it weren't my current reality. Someone who I thought understood my diagnosis, loved me in sickness and in health, and was in my corner for the journey of my active treatment to get better, turned their back on me. Said person is legally bullying me to get what they want, slandering my character, and using my diagnosis against me to make me seem like I am a monster. There are more false allegations than I can even comment on. The deep love I have for my baby boy sustains me and keeps me strong. I haven't spent more than a night away from him since I delivered him, and I adore every moment I spend with him. He's my best friend, my miracle, my little man, my sweet boy, and most importantly, a gentle, a giant piece of my heart. Right now, that piece of my heart is missing when I need it at the most. I am 5 months postpartum without my baby boy who needs me as much as I need him. I would never put that angel of a child in harm's way. My job as his mama is to protect him, and that is what I have always done, and I will continue to do for the rest of my life. Becoming a mother has always been my dream, and I never made any threats towards my baby. That allegation specifically makes me sick to my stomach. I was alone with my baby day in and day out for months, caring for him as my fiancé frequently worked 24 to 48-hour shifts, but conveniently, there were never any concerns up until now. On June 30th, 2025, I received a phone call from my fiancé to meet him at the park to go for a walk with my baby boy together. After almost 3 hours of waiting for him at the park and no communication from him, I went home very confused as he never showed up. About an hour later, I was sitting on my couch feeding my baby boy when I got a knock on my front door. Very confused to see 3 of my colleagues. I opened the door and I am told the following. Your fiancé has filed a restraining order against you and will be taking your son away. He will be taking your son away with no contact allowed. Your firearms license that was just returned is gone again. And oh yeah, that career you worked so hard for and love that you were just cleared to return to, that will be taken away too. Following this interaction, I packed bags containing baby food, clothing, diapers, toys, etc. for my... seriously? Dude. I just stepped on my thing. Sorry, guys. Houdini just stepped on my keyboard. Sorry. All right, stop. All right. Let's see. Let me just start over. Very confused to see. I opened the door and I'm told the following. Your fiancé has filed a restraining order against you. He will be taking your son away with no contact allowed. Your firearms license that was just returned is gone again. And oh yeah, that career you worked so hard for and love that you were just cleared to return to, that will be taken away too. Following this interaction, I packed bags containing baby food, clothes, diapers, toys, etc. for my son to be taken away from me. Oh, stop it. Sorry, you guys. Following this interaction, I packed bags containing baby food, clothes, diapers, toys, etc. for my son to be taken away from me. I passed my son off to a fellow police officer and went into my bedroom. In that horrible moment, I didn't want to live after my whole world was turned upside down in the matter of a 10-second conversation due to someone alleging horrible, untrue things. We have a broken legal system where someone can walk into a courthouse, write anything that self-serves them on an affidavit, and as a result, a brand new mother suffering from postpartum depression gets her baby taken away. We are calling on the legislation and the governor to reform this abomination of a statute where the first person to get to court and fill out a form can take a mother's newborn away from her if they can sneak in front of a judge without the mother's notice or opportunity to be heard. If there is an immediate issue, someone can call 911. The courts are not equipped for proper on-the-spot decision-making in this context without hearing from both sides. As a police officer, I am trained to know what to do if I encounter a self-deleting individual who is only displaying a threat to themselves. So, as a police officer, I am trained to know what to do if I encounter an individual who is displaying a threat to themselves. I certainly was not trained to shoot that said person in the chest, but here I am today, 2 surgeries later, bedridden and trying really hard to heal from these significant injuries. I am facing felony charges for a half-hearted attempt to take my own life. Let me say that again. I am in trouble and having a gunshot wound to my chest because in that awful, isolated moment, I no longer had the will to live. So she's trying to take her own life, and then she gets shot. I mean, I guess people do that, right? where they wave a gun at an officer. You know, it's like, what's that? By cop shot or whatever, getting shot by a cop, shot by an officer. I never pointed my firearm at the officer. All bold. I never pointed my firearm at the officer. That officer was not just a colleague, he was my friend. All right, here's where we get to find out about Officer Noonan. That officer and I experienced a very difficult and sad call for service together last summer. That call for service that day was a true tragedy and caused this officer and I to build a friendship due to experiencing it together. We entered the home and walked into something no human should ever see, a murder-suicide. Mother and her infant. Right? So mother and an infant. Mother took out her infant. As a rookie police officer, this was devastating to me. At the time, I was 20 weeks pregnant. The officer that shot me experienced this call with me. To this day, his support during that hard time is something I am still grateful for, regardless of this recent incident that occurred. This traumatic self-deletion, taking out child, was the catalyst for my mental health complications. Right? That's pretty intense. As a police officer myself, I would never even think to intentionally hurt another police officer. I see everyone in uniform as my brothers and sisters. I especially would never hurt my friend who has a loving wife and children. I just would never. My firearm was never pointed in any direction other than my temple. When I pulled the trigger, my gun did not fire. However, I immediately got shot in the chest by my colleague and friend. I am extremely grateful for two things: that God protected me from my attempt at taking my own life and protecting me by millimeters from dying from the gunshot wound in my chest. I will survive and thrive. I know I need to be on this earth for many reasons, but most importantly, my beautiful son. This is my covenant with God and my son. I would also like to note that from the very beginning, I acknowledged my diagnosis of postpartum depression and immediately sought help from medical professionals. I was failed by so many. The narrative that has been released by the NAPD is vague and non-committal for a reason. If body cameras were worn by my department, I would not be in a position where I am wrongfully accused of pointing my gun at this officer. I know the truth will prevail. Kelsey Fitzsimmons. All right, so that's a lot, right? So that's her side of the story. All right, so that's her side of the story. So that's a lot. Ludley Wayne, maybe she had PTSD as well. It sounds like it, right? It certainly sounds like she's saying that that incident formed something. What'd she say? It sounds like, here, let me go back to that. From the very beginning, I announced my diagnosis, immediately sought help. Yeah, here, this traumatic call was the catalyst for my mental health complications. So yeah, it does sound like she's definitely dealing with some PTSD. Debbie, cops doing a cover-up? We'll find out. We're going to find out. We'll see. We'll see what the defense brings. All right. So let us get to. All right. Let's now move into. This is from August 14th. So this is a clip from August 14th. Let's check this out.
Andover police officer who was shot.
All right, this is her appearing for her arraignment while she's still in the hospital.
Andover police officer who was shot by fellow members of the force appeared in a courtroom Zoom today as her defense attorney argued that she should be released. He also says investigators are not telling the truth about what happened. WBZ's Beth Germano is live in Salem. And Beth, I know we are also learning more about what happened before this shooting. Well, it's a case with many layers and now accusations of lies on both sides. Kelsey Fitzsimmons is charged with armed assault to murder in a confrontation with fellow police officers, but her attorneys say there are two sides to the story as a judge considers if she is a danger. It's the first time seeing 28-year-old Kelsey Fitzsimmons. Her attorneys in court fighting for her to be let out on bail, calling the case against her a he said, she said situation, not a criminal case, when she allegedly pointed a gun and attempted to shoot a fellow officer inside her North Andover home. Her family there to support her.
We just hope she gets home soon. We don't believe that Kelsey pointed her gun at anyone except herself.
It started June 30th when 3 officers arrived at the home to issue a restraining order that had been taken out by Fitzsimmons' fiancé, worried she could harm their baby born in February and him. Fitzsimmons has admitted to postpartum depression after the birth, voluntarily undergoing a mental health evaluation, according to her attorney, who says the condition is not a permanent one.
This was a transient episode that was brought on by an unimaginable confluence of events for Kelsey, and it's over and it's gone and she's fine. And that's what the court needs to understand.
That June night, attorneys say Fitzsimmons went to a second-floor bedroom to get clothes for her baby who was being removed from the home. One of the 3 officers following her upstairs, who claims she suddenly grabbed her service weapon and fired with an empty chamber.
She racked the gun to load a round into the chamber. When she did that, he fired 1 shot, missed, and fired another shot.
There's no body camera. There was no other officer up there. There's 3 different stories, versions of what exactly was said in the reports before.
Her attorneys say Fitzsimmons, who was shot in the chest, has been slowly recovering and has never been heard in this case, while she's also fighting a custody battle. Former Attorney General Martha Coakley has become a co-defense counsel.
Our real goal is to make sure that she is heard, that the truth comes out about what really happened here, and our client is innocent.
Now, prosecutors say all of this allegedly happened after Fitzsimmons was cleared to return to the force and that she remains a danger to herself and others. Her attorneys say if bail is granted, there is a plan for her release and that these are untested allegations. Reporting live from outside Salem Superior Courthouse, I'm Beth Germano, WBZ News.
All right, Beth, thank
you. All right, so that's her appearing in court. Now here's this is her lawyer speaks after this arraignment. So this is hold on. All right, so this is August 28th.
Delay there, but we'll get to everybody, so don't worry.
This is her lawyer. This is
the delay there.
Bradel speaking out after her arraignment on August 28th.
But we'll get to everybody, so don't worry. Who wants to go first?
I think we all agree. One of the main things we were interested in is you said something about the wrecking ball to the case. The grand jury only came back with a very less significant charge.
Yes, they initially, the theory of the government's case here was that Kelsey intended to murder a cop, which is outrageous and completely ridiculous of an assertion. And here, thankfully, the Essex County Grand Jury, and Kelsey's extremely grateful to that body for looking at the case in a realistic way. They found that their appropriate charge here was 1 count of assault with a dangerous weapon, which involves the apparent display of a weapon to cause someone to be placed in fear. A very, very low bar, and that's all they came back with, was that one charge. And if you look at the sentencing guidelines, she's in a position where she could very likely get a probationary sentence on this if she were guilty of it, which she is not. But the playing field has been radically shaved down. It's just really a totally different case now.
It seems like we're seeing a lot of these cases in recent times with the postpartum. Is she just having some issues that, you made the argument today so she can continue on trying to get some resolve to that?
Yeah, I mean, postpartum depression, one of the most common afflictions that a woman could have, giving birth, having a baby. It's a transient condition. That's the biggest word of the day on that, is that our experts and the Mass General experts recognize that postpartum depression is a transient condition. That's gone. She's fine. She needs her baby back. She's never been heard in a court. The only body that's heard any evidence is the grand jury. And even there was no cross-examination. And they still put the brakes on this. They still said this is at best, as a matter of probable cause, the lowest standard in the law, the lowest hanging fruit, that at best this is an assault. And it's just a completely different case. And like I said, the grand jury took a wrecking ball and destroyed the Commonwealth's case and completely rejected their theory that this was any sort of an attempted murder type scenario. This is a woman who was suffering from an affliction, who, based on words on a piece of paper, had 3 policemen come to her house and take her 5-month-old baby. A woman who's in the grips of postpartum depression, who was just scheduled to go back to work at the police department, was cleared, had her firearms given back, and her whole world was taken away from her because a guy went to the probate court right over there, filled out a piece of paper full of self-serving allegations, and got her baby. So that's what we're dealing with here.
And
unimaginable.
What do you make of the judge's order today? Obviously, she's going to be able to go home, get out of prison, get out of jail. Is that sort of a step in the right direction? Yes, the case is going in the right direction, and we appreciate Judge McCarthy's attention to the case. I think that she is being extremely cautious with the amount of conditions that she put on the case, but we will endeavor to comply with every condition she wishes, and we're committed. Kelsey is very committed to showing this court, showing the judge that she's fine, that she's in control, that she's not a danger. The only thing that's been aggravating her postpartum is having her baby taken away, being on the receiving end of these self-serving allegations, and then being charged with a heinous crime that ultimately was rejected by the grand jury. So we're now going in the right direction here. We're very optimistic that this case is going to get dealt with in the appropriate way. And for the short term, we respect the judge's ruling. We're happy to get these conditions in place, and we're going to show the court that this is not a problem for Kelsey Fitzsimmons. She's a cop. She's a CO, former CO. She's not some criminal who needs to be clamped down. And she's going to show that to the court, that she's going to handle these conditions, and she's going to do just fine.
When will Kelsey be released to her family?
Well, I think that through some Herculean efforts to get the court to get all these things in place, I think it's going to be tomorrow. So we're going to be very happy about that date.
Well, parents put a lot on the line, and the judge had them swearing. Do they want to say anything about their daughter?
Mom and dad and stepdad are wonderful, and they have put so much into this, and the families put so much effort into this. And I was just saying to them inside that when you have a great family behind you in court, literally they're behind you in court, that makes my job so much easier to say, Your Honor, look at this great family that's going to step up and make this right. And I think Judge McCarthy would agree that, it makes a huge difference that she
can see this family, and they stepped up in every way she asked, and they're going to make sure this is a success. We're not in any way concerned about that.
And there is a hearing coming up on the restraining order. What are you hoping happens there?
So we're going to assess our options on that. We have to look at that hearing in light of this order today, and we haven't made any decisions yet, but we're going to do everything we can to reunite Kelsey with her baby when we can get the judge here to look at the case anew and figure out that issue. So it's in the works.
And it sounds like you were trying to fight her on that 58A dangerousness finding. Why was that an important
well, you know,
step?
it's just a step that we felt the judge didn't need to go that far. There are other provisions in the bail statute where someone can agree to terms of release. The court is empowered to make certain terms of release on its own. So we just felt that it wasn't necessary to go to that level of making such a declaration, and we'll have to see where that goes in the future. But we're optimistic that all those issues will be ironed out in the short term. And for now, obviously, we're going to do everything we can to comply with all these provisions.
Thank you.
Thanks, guys.
Thank you.
All right, some of you are asking about who actually has baby C. I'm assuming it's Justin. Again, I don't know. We're kind of walking this path together. So let's. I don't know if we will find that out in our deep dive or not. But I'm assuming it's Justin because he filed for custody. So I'm assuming it's him for now. But we'll find out as we go through it. All right. So here's another clip. So here's another clip. Now that was from August 28th. This is from September 8th of 2025. This is her released from the jail just months after being shot.
So I bet you thought we went out the back door.
We had faith.
Yeah. Come on over here, guys. So thanks for sticking around. First of all, I wanted to say how happy we are that Kelsey's out, but I wanted to introduce Martha Coakley, who brings such a wealth of experience to this case and advocacy over the years on both sides that has been incredible, and we're just so proud and happy to have her with us on the case, and so we're going to hand it over to Martha to go first.
So Kelsey Fitzsimmons is going home today. She's very happy about that, as are we. She knows, as we do, that the court always has to balance a lot of things, and we appreciate that the court did that today. Kelsey and her family have agreed to all of the conditions that the court has imposed. She looks very much forward to going home to recover, to prepare for what's ahead in this case, because she is innocent, and we believe that, and she knows that. And she looks forward to that recovery and her day in court.
Absolutely. So thanks a lot, guys. Does anyone have any questions?
Yeah, just how much can you say about sort of what happened between the arraignment and today in terms of why the bail order was paused?
So I think the judge took a very careful approach, which we respect. It wasn't what we wanted, but, you know, we got Kelsey out of jail, and we're thrilled about that. She doesn't belong in jail. We want to fight this case from the street. This case is going to be resolved down the road, and you know, we're going to do everything we can in this matter. We also have to focus on Kelsey being reunited with her baby and get into probate court a few doors down here. So we have a lot on the plate. But for now, we just want to get Kelsey home with mom and dad and stepdad and family, and it's where she should be. We're all thrilled about that, and we're really happy. So, Mike?
How's the family doing? I know there's a lot of family members here today.
Yeah. Well, I always say Kelsey has a great family. I always feel like I'm halfway down the field in court when I have a great family sitting behind me in the front row, ready to do whatever they can do. And in this case, more than most, if not all, the family here has gone to extraordinary lengths to make sure that they can show the court that Kelsey is safe and protected and is where she needs to be.
Yeah, I'll just add, look, this young woman has faced a lot in becoming an officer of the court, a police officer. She's faced a lot since that day. She is committed to her family and friends, and she is committed to listening to the court and doing what she needs to do to get back on track. But in the end, we believe that when we have that day in court, she will be innocent, and so we look forward to that day.
Kelsey, want to say anything about just how it feels?
What do you think, Kelsey?
The truth will come out.
Thank you. We want to get her home and relaxed.
Okay, so that was from September. Now we're going to fast forward a little bit. Well, actually, just a month. We're going to go to October. Another news clip.
Only NBC 10 ball.
All right, so this is, she's back in court. This is October 23rd.
Austin was in the courtroom as a North Andover police officer faced a judge today. Kelsey Fitzsimmons is accused of aiming a gun at her fellow officers before she was shot by one of them back in June.
Today, Fitzsimmons was fighting for custody of her child. NBC 10's Robert Goulston was the only TV reporter there. He's live in Salem now with what happened today. Robert.
Glenn and JC, yes, this was the first time since the shooting that she was in the same room as her ex-fiancé. And as you recall, he was the one who requested and was granted that restraining order that set off the events on June 30th when she was nearly killed. Kelsey Fitzsimmons appeared in Essex Probate and Family Court as she continues to fight to be reconnected with her infant son. She appeared with both her family and criminal attorneys.
It's a tough atmosphere, but, she's going to be fine.
Fitzsimmons, who remains in custody, is working to resolve child custody and visitation issues.
I will say that the provisions that are in the stipulation are moving toward a reconnection with her and her son. It's positive steps, and I'm happy to say that both sides were on the same page for that.
Fitzsimmons is charged with assault with a dangerous weapon. North Andover police say they were serving a restraining order taken out by her fiancé at the time when Fitzsimmons, who was off duty, pointed the gun at an officer. Fitzsimmons and her attorneys contend the gun was never pointed at the officers when she was shot. Her attorneys are petitioning the state's highest court to reassess her release.
She's up. She's encouraged that things are moving along. She's very happy to hear that we're going to be getting we're going to be heard in the Supreme Judicial Court very soon.
Fitzsimmons was initially released after her arrest, but was taken back into custody for not submitting a required breathalyzer test for alcohol. Her attorneys argue she could not do the test because she continues to deal with lung and chest issues from the shooting. Her attorney says family and supporters have been keeping her focused.
Kelsey's devoted her entire life to two things: her baby and her law enforcement career, and she's going to keep her eye on the ball, and we're going to get her there.
And back on the criminal side, she will be back in court later this month for that matter on the 25th. We're live tonight in Salem. Robert Goulston, NBC 10 Boston.
All right, so you heard him tease that she's back in jail, right? So she was free, then she went back So now we're going to listen to this. Now we're going to listen to this. Now Aaron put this together. So hope you guys appreciate it. This is just audio. All right, this is audio only. This is from October. All right, so this is a hearing from October 24th, 2025. And this is about 30 minutes. Wait, hold on. Let me put it over here so I can pin it. Hold on a sec. Sorry, guys. Give me a moment. All right. So you guys be prepared. You are not going to like this. Well, let me retract that. This is audio only. This is audio only, and I want to hear your impressions. I teased it at the top of the broadcast. And tell me what you guys think about this judge. Again, this is audio only. So audio only.
We're back in session. You may be seated, silence all self.
All right, good afternoon. Calling Cromwell versus Kelsey Fitzsimmons. This is docket number 2025-311 before the court in the defendant's motion. If the parties will please identify themselves for the record.
Good afternoon, James Gubitoski on behalf of the Commonwealth.
Good afternoon. Good afternoon, Brandon Moyer for the Commonwealth. Good afternoon. Good afternoon, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons. Good afternoon.
Hello, Your Honor. Timothy Brado for Kelsey Fitzsimmons. She's present in the courtroom today for the record tonight.
Good afternoon, Mr. Good afternoon, everybody in the courtroom.
Thank you.
So I received the defendant's emergency motion for immediate release from this grant order.
Thank you so much, Your Honor. Judge, this is an issue that causes Ms. Fitzsimmons a lot of pain, and I don't want to conflate her being able to pass the test, because she's been passing them, but she has about 4 hours of pain and dizziness afterwards, and you know, I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, you know, we're not trying to get any sort of advantage over anything. We just want her to not be in pain for hours after these tests, and B, you know, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, you know, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, you know, I think that says it all. That's someone that has no bias or interest in, you know, probation enforces court orders, and that's that. And he is telling the court this is a problem. And, you know, this is something that should be addressed. Okay. So I see this as a simple adjustment of terms. I
don't see it that way, just so you understand where I'm coming from. I don't see it that way.
Okay, can I? Okay. I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol-free. She doesn't wish to be alcohol-free. It's just a means of determining that is the adjustment. That's what I mean when I say this is an adjustment. That
well, a scram is what was ordered. Now, was she unable, when you said that there was a knock on the door, explain that to me. What happened?
Judge, that we don't want to have a knock on the door. She's living in fear of there being a knock on the door because of these tests. It's just not, between the physical and then the mental anxiety, this is a very significant issue for her. Okay. And that, you know, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And just, that's something that I just want to ask the court to adjust somehow.
Okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it?
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email. It's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put anybody on the spot, but we have a person who sent that email here.
Okay. So you have a burden. It's your motion. What do you want to do?
Well, Judge, I don't think that is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother of the physical observations of what happened. I think that's, the more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother, you have an affidavit from Ms. Fitzsimmons, and the other day we were here, I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I would just argue that it's somewhat self-evident as well. And that, she's having great difficulty. It's been observed by probation, it's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her that luckily she has passed the test, but then she's got hours of pain afterward. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo, and we were informed that they may issue a warrant. And
so I want to hear about the one she had difficulty with. When was that?
Just a moment. Well, so that's what I was saying, Judge. I don't want to conflate passing with not having difficulty. She has difficulty with every single test. And so she passes them in great pain. So she's had difficulty in every single one, it's in the affidavit. So she has difficulty on every single one. So that's a different issue than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to was 9/9/25 at 3:09 p.m., I guess.
And was that a required test that she was to do?
Yes.
And she was unable to perform it?
Correct.
Okay. Was she unable to perform it?
No.
What happened?
No. So since she's been released,
yes, where in office?
Do you solemnly swear you will make true answers to such questions that may be put to you by the court or upon its direction, so help you God?
I do. Or if I could just pass this up. This is information pertaining to all of her experiences.
And is that being submitted, Attorney Braille, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Nora.
Okay, so
it just says that she passed the test, so which is not an issue. The issue is that she's in extreme pain while doing it. Whether she passes it.
Okay, so there's one Officer January that says incomplete at 9/10/25 at 3:09 p.m. Is that right?
Yes, that's correct.
So what does that mean?
Yes. So what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test, and that happens. And so initially she answers the alert and attempts to take the test, but is unable to complete the test. And based on my information, my conversations with Elmo, is that is when she has difficulty either blowing as hard or as long, or a combination of both, into the machine to complete the test. So what happens after that is there are additional attempts to complete the tests, which she tries, and then ultimately on that particular day, she successfully completes and passes the test on September 10th at 3:50 p.m.
Okay, what I have in front of me is an incomplete test at 9:10:25 at 3:09 p.m.
That's correct. And then if you just look
and then it says
that,
passed at 9:10:25 at 9:30 a.m.
Okay, so you're looking, I'm referring to this second document, multiple pages.
I think if you just go up instead of the one above it,
okay.
Incomplete is the 9.
So it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes?
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th.
Again, at 3 o'clock.
She passed, but
the test is initially incomplete.
At 3:09, and then it's complete at 4:21.
4:20, 4:21.
So there were 2 times that she had an incomplete test. Is that correct?
Incomplete.
And what's the procedure of the probation department when somebody who has a condition of release to have a scram and to pass the scram test in a very serious case if they're incomplete? And I have 2 incomplete tests and I was not made aware of either one of them.
So my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Almo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of an hour and 20 minutes.
That's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, and actually doesn't really matter to me, but when I was doing the installation process and observed what was genuine pain, genuine pain. So
any objection to any of the terms used by the probation officer? Okay.
So we have all that information. We don't deem that non-compliant. She's attempting to take the test, and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance, and with her obstacles.
I'm getting confused. What do you mean compliant? As far as when she was initially...
that's compliant with scram testing. She was ordered...
When she initially was started to be monitored by scram and you went through the preparations, is that right?
That's correct.
Okay. So when something is incomplete, you typically bring it to the attention of the court.
No, that's not what we do. So if something is incomplete, as in this case, at 3 on September 9th at 3:09, we have an incomplete test, which is a scheduled test.
Mm-hmm.
And then we have, that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not actual non-compliance. If someone missed a test because they were down in the basement doing laundry and then came up and realized that they had a test, took an on-demand test 20 minutes later and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond, or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notices, notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with this scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
well, that's your position that's non-compliant. Well, it's really up to the court to decide whether somebody's compliant or not with conditions of release. What you're saying is those situations you described is what you deem as appropriate to bring before the court.
It would. So I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation from our end, because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and we don't deem that non-compliance. We never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so the schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered someone to be alcohol free.
What do you mean we discussed? So she knows when she's going to be tested?
With Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule, because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court. It was 4 times a day, 3 times a day. None of that was ordered. She was ordered. It was random screens.
Excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule, as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials, for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I can clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with scram testing, we always default to creating this testing schedule, and up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. And the tests to be done randomly. And at that point in time, we would take her off a schedule, and then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case, and it's done on every case.
Okay. Attorney Bradel, do you have anything else to submit?
Judge, I would just offer, I respect and I heard Your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also...
Caldwell, do you have a position as to the admission of the email?
I think we just heard with the email.
All right, so the email's excluded. Anything else, Attorney Bradel?
No, my objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, that says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Just, I just want to clarify something. My email, and I know but it's important that the court knows I didn't make a recommendation that a scram condition be vacated. I never did that. I never suggested. Is all that email was...
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
If the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose only, and that's for the motion to vacate the scram device. So, do you have anything else to submit, Attorney Bradel?
No, Your Honor.
Okay, Caldwell, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is, in light of the court releasing the defendant, that testing be done.
Okay. Attorney Bradel, first of all, I do have a question. So, Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
That depends on whether the court is willing to tolerate that the material represented in the
affidavit. The court is not tolerating anything, okay? Let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it.
Okay.
Under the terms that are laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all, so I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for alcohol compliance, lack of alcohol, that's completely fine with the defense. But just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Oh, okay. But it is not this court's intention to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, there's probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that she would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol.
That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes and I'll be right back.
Court will rise. Court will rise. Goes back attention,
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I'll state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws Chapter 276, Section 58A-2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the SCRAM installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by SCRAM. The court concludes that Fitzsimmons cannot abide by the condition of being monitored by SCRAM. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will follow. That's the court's order. Thank you.
All right, Jack. I ask you to stay your order pending the SJC. And there are other alternatives, Your Honor, can come.
Like after judge gives her ruling, I can just hear Mr. Bradel, like she goes, I just envision her walking off the bench and he's like chasing after her. Your Honor, no. All right. So I didn't hear Mr. Bradel specifically say, why don't we do this? Why don't we do that? Because this whole thing with the testing, with the SCRAM, is that you can do GPS monitoring. You can do testing other than just blowing into that device. So that's where I'm like, I thought he kind of dropped the ball a little bit by not offering specifically, Judge, we could do this, we could do that, we could have her, we could take her in to do urinalysis, we could take her in to do this, we could do that. And even SCRAM, I think, offers, as we saw through that, they offer different forms of testing, not just blowing. So that's where I thought Mr. Bradel could have been more specific. You guys said, there it is. I think one of you said, there it is right there. He offered it, but I didn't. I'm just saying. You said that right there. He offered it. I didn't hear specifically. Did you hear specifically? Hey, Sharon, good to see you. Thank you for joining us. Yes, use other alternatives to check. I didn't hear him say specifically. I wish that he had said very, very specific, because it seems like this judge, she didn't get any medical records. I don't know why they didn't have medical records provided for her, because, that seems like a no-brainer, even though she knows this case and she knows Kelsey got shot in the chest. Of course, she's going to have trouble going, there's just no way that you're going to be able to do that, right? Without serious pain. So I wish that they had gotten, that's where I'm saying, I wish Mr. Bradel had just given that judge like really, really concrete, boom, here's what this medical provider is saying, here's a solution, blah, instead of leaving. It seems like he left it with the judge just a little bit. They were submitted under seal. Okay. Barry's saying they were submitted under seal. So she did have them. But she's saying that she didn't have them. Didn't she say that she didn't have them? Am I confused? I thought she said she didn't have them. And Barry, you were saying that they were submitted under seal, but that she didn't have them, right? All right, I found another thing while I was watching that. So remember this whole body cam thing? I'm going to pivot just a little bit. Excuse me. So July 29th of 2024. This happened June 30th of 2025. So a year before, a solid year before, 4 Western Massachusetts police stations awarded funds for body-worn camera. The Healey-Driscoll administration has awarded more than $3 million in grant funds to police departments across the state to begin or expand the use of body-worn camera. This was a year before. Guess how much Norwood got? Norwood Police Department got $250,000. Now, I don't know how much body cam costs. I don't know the full deal. I don't know how many officers are there, but a full year before, they were awarded $250,000 to specifically get body-worn camera. Why didn't they have it? Why didn't they have it? That's a huge question. Not that that's going to, make or break the case, although I guess it really could make or break the case, because if we actually saw what happened, then that might help us. But a year before, they were awarded $250,000. So what happened to that $250,000, I wonder? All right, so now we're going to get into 2026. So this was in January. So we're only in March, right? March 22nd. This is from, I think I can take this pin down. All right. I'm gonna end the poll as well. I'm gonna end the poll because we've been going for a while now. I'm gonna end the poll. Thank you for voting, you guys. Really appreciate it. Let's just end the poll and maybe we'll get another poll going. All right, so 239 votes. Appreciate that, guys. How much do you know about this case? I know nothing. Help me understand. 51%. Cool. That's what we're doing today. I know a bit. Want more info? 27%. I know most. Ask me anything. 15%. I know it all. You could represent. Awesome. 7%. All right. So most of us don't really know it. I should say not understand it, but don't really know it. All right. So yeah, that Judge Noonan, is not on the case. It's another case. She got, what was it? She got rehomed, as Barry says. So Jeffrey Karp is on the case now. So Judge Noonan, I think it was Noonan. She has been rehomed. All right. Ola, yeah, they look such a great couple. I know. Right? Richard, at my department, we got grants for our body cam. Yeah, I would think that's what happens, right? $250,000, you would think. And it was specific for that. It was specifically for it. It wasn't just, oh, here's $250,000. Go ahead and do whatever you want with it. Paint the exterior, get new cars, get some new uniforms, buy some body armor. I don't know, whatever. That was specifically to go to body cam. So that's a little, I don't know. Not quite sure what the word would be, but all right, here's another press conference. All right, this is from January. So she speaks out after her trial was delayed. All right, so this is her trial being delayed. Then we do have some court. We're going to get to some court. We'll get to some court. Don't worry. This is just some few more news clips, and then we'll get to court.
Kelsey, want to come up here? So today was not unexpected. We knew the prosecutor had a few things on his plate. We're more concerned right now about getting the discovery. That's a back and forth process. We're all pretty experienced attorneys, so we don't really need to involve the court at this point in fighting about anything. I think that the prosecutors are trying to get us everything you can get us. That will determine what moves we make after we get all of their discovery. And so it goes. So moving along. There's a lot of avenues to explore, and that's about it. Anybody have any questions?
You had first said, I remember, a 2-day trial estimate. Today I heard 3 days.
Maybe, yeah, 2 or 3 days, plus or minus. We have to decide a lot of things, and it depends on what discovery we get. It depends on what they're saying, what they're not saying, how they say it. So.
Too early to think about witnesses? How many witnesses, or who's going to be a witness?
We have a pretty good idea, I think, both sides, about who the principal witnesses are. You know, there's 4 or 5 officers that are of concern here. You know, we have some people, we're looking at some potential experts. Nothing we want to really disclose just yet, but we really need to get everything from the Commonwealth before we make those decisions. And under the rules, we don't have to disclose anything until they've given us all their cards.
Do you anticipate any issues? I know there's going to be a follow-up date on the 9th, which was the original trial date.
You know, you gotta leave everything on the table. We have to see what we have. We just got 10 gigabytes of not even sure what it is, video photography today. There's been a few files of training records we're going to look at. So it's a process. We're going through it right now, and it'll dictate what our next move is.
You indicated you were going to be filing some Rule 17 motions. Anything you can say about what
Charlie,
those would be?
So we're looking at the prior department, the Lawrence Police Department, and we may have some information we're going to be seeking from there in terms of the departure of the officer at issue and some of the training. We want to know what kind of training these officers received relative to the use of force, relative to de-escalation, things like that are going to be a serious issue.
Quick question for Kelsey, if you don't mind. Just wondering how you feel one way or another, or if you feel one way or another about the trial being delayed, if you were kind of hoping to get it over with in February, or if you're saying you're more of the mind that it takes however long it takes.
I would love to get it over with. I want to put it behind me, because as soon as I do that, it's one step closer to be reunited with my son. So that's how I feel about that. But I do know that it's a process, and that if it has to get extended, it's probably for a good reason too.
And then anything else you want people watching this to know about your situation, about your case in general, that you might feel wasn't represented properly, or just something that you want people to, anything you want people to know in general?
I think there's been a lot of misrepresentations, and it will all be very clear once I get my day.
Kelsey, how do you feel about today versus the other appearances you've made? Quite a different feeling.
I get nervous every time I come here because of past times, so I get nervous.
She's under a lot of restrictions, and you know, kind of an unprecedented number of restrictions that each one carries with it all sorts of sub-issues that we have to be very concerned about. So I don't blame her one bit for being concerned about, you know, every little aspect of her release terms. So it's an ongoing issue. The government increasingly puts defendants under the grip of various technologies like the scram, the bracelet, and we get, any practitioner will tell you that it's not infallible. We get calls from our clients that, you know, they're being accused of being outside the bracelet range when they're laying at home asleep in bed at 2 o'clock in the morning. You know, the technology is not great, and there's often a presumption on the part of probation or the courts that if the technology says you did something or didn't do it, that's gospel, and that's not the case at all. So I don't blame Kelsey one bit for being concerned about this stuff. We're trying to keep a close eye on it. We're trying to work with these technology providers are pretty cooperative, but you know, in the end, if the bracelet's saying you're doing something wrong, that's all of us immediately. The defense is in a hole that they have to crawl out of. It's not fair. So,
Kelsey, how are you feeling? How's your health?
I'm okay.
Getting better?
Yeah. I also have a question for Kelsey. How's Maverick? Maverick's great. Was she excited to see you when you came home? Yes. Very excited. instead of being home. It was a really weird adjustment, and I think I'm still adjusting, but I'm okay.
So as always, guys, we want to thank everybody for being here. You know, the supporters mean the world to us. You know, the sunshine, Martha and I were talking before she came out here, that the sunshine on this case from the media is really important. And we are really gratified that you're all here paying attention to this. It means the world to us.
Thank you for supporting me.
Thanks, guys.
Thank you.
So interesting. All right, so we found out that he's thinking it's only going to take a couple days. They're going to call a couple witnesses. They're going to specifically talk about training, officer training. What are you trained to do in a situation like that? So I'm sure we're going to hear from, well, that's what Mr. Bradel is saying, that we're going to hear from, specifically, we're going to hear about officer training when you're put in that situation. So, all right, let's go on to the next one. Now this is, okay. They asked for Judge Noonan to be recused. So let's check this out real quick. This is a report about defense asking for a judge to be recused.
You gotta keep her warm.
So you filed a motion to recuse the judge this morning. Can you speak a little bit to why you decided that was a step you wanted to take?
Sure. Martha, why don't you go right ahead?
Look, this issue of fairness, not having a conflict, and in fact not even appearing to have a conflict, is just bedrock in our society. It happens all the time, by the way. State court, federal court, judges, lawyers know each other, family members, financial interests. There's a million reasons why some judge might decide he or she shouldn't sit on a case because they have an actual conflict or because it appears that way to the public. And we felt that in this case there were lots of reasons why, and we've raised this before, and even the SJC in their last decision said it is up to the judge, him or herself, to decide whether or not there's an appearance of conflict or there's an actual conflict. And so no one should be surprised by this motion, given this case. It's a complicated case. It's had lots of twists and turns. It is unusual, but that also raises some unusual conflicts and appearances in this case. And so we're hopeful that the judge will look at this motion and realize that. It's obviously her call to make that decision. She was not here today, but she'll see the motion and she'll make a decision based on what we filed today. This is for fairness, by the way, in every case, but in this case, this is fairness for Kelsey.
And so there's a hearing set for March 9th. Trial is March 23rd. How likely do you think it is that this case actually goes to trial on that date, given the hearing and then the judge deciding the motion, and then maybe you get an evidentiary hearing?
We're not moving this thing. We want this addressed. We want a jury to hear this case. Kelsey has a lot of work to do in terms of getting her baby back, and that's number one. That's the number one priority here, and we don't want this to interfere any more than it already has. It's been horrible for her, and we need a judge that doesn't have appearances of a lack of impartiality on this case. We want to have that done immediately, as soon as we can. We moved up the date a little bit as best as schedules would allow. So we're eager to get that handled. We're working behind the scenes without court involvement right now anyway on the discovery. We're trying to get the last few bits of discovery, and we're not obligated to provide any discovery to the Commonwealth until they've certified and it's actually true that they've given us all the discovery. So that's the way the system works. We're very confident in this motion that there's no way that this judge could sit on the case in terms of without demonstrating an appearance of a lack of impartiality. So we want to just get a different judge on the case and move forward as soon as we can.
So the Commonwealth said they were going to file a certificate of compliance either today or this week. You sounded maybe a little less certain that they had actually met their...
Yes, as I said, I was trying to be nice, a little too optimistic. optimistic, I think, today. But, we're working together. We'll try to get it done. And technically, they're not fully in compliance yet. But we're working on it. And I know these things take a little bit of time. But it's time to get it together, get it done.
And last time we were here, you talked about filing some Rule 17 motions. Is that still the plan?
So we're looking at that. We think some of that was covered by the discovery that's already been given, so we might reassess that. We might also just send some trial subpoenas for items as well. And I know the Commonwealth is probably going to do that as well for some things too. So there's different ways we can address it. Anyone else?
Yeah. What do you think the likelihood of Judge McCarthy Nyman being recused is?
Well, the motion's very comprehensive, Josie. We think that it's a very strong motion, and it's gonna be handled by her on its merits, and we're very confident in it. I don't want to really speculate on the odds of it, but it looks good, and we're very confident with it. Put a lot of time into it, and there's a lot of issues in there that need to be addressed.
All right, just one more because I know it's cold and I want Kelsey to get warm. Is there any chance that there's going to be a ruling before the trial, or do you think they're going to drag it out?
Yeah, no, I think that the 9th is a realistic date, and we're going to do everything we can behind the scenes to make sure that date is set up for a hearing. If they in fact want an evidentiary hearing, as opposed to just recusing, if the judge wants to just have a hearing, that we're going to work hard to make sure it's on the 9th.
And that motion would have to be decided before trial, one way or the other.
Delay is not a factor in whether a judge should recuse himself. It takes priority, and it's a constitutional right to have an impartial judge, and it's nothing that's going to be moving for any sort of scheduling or logistical concerns.
And in watching you argue, it's not something that you always file in every case. It's a
right. It's rare. It's usually Martha and I were just discussing this a little while ago. Usually, a judge just will see things in the record that would cause someone to question their impartiality and just step off the case on their own. For whatever reason, that didn't happen here. And, sometimes lawyers have to file motions pointing things out to the court, and that's fine. And we've done so, but we fully expect that this will be taken care of, and that we'll have a fair, impartial judge on the case.
Thank you, everybody.
Thank you.
Thanks, guys.
All right, so they tried to recuse the judge, but the judge was ultimately rehomed, as you guys are saying. She was rotated out. All right, so now let's get to hoping for a fair trial from new judge. All right, so a new judge. So that was from February 10th, and now here we are, February 27th. Sorry about that. I wonder what that squeaking is. Oh, you know what's going to be a really interesting thing, and is I wonder if Kelsey will take the stand. What do you guys think about that? You think Kelsey should take the stand? I would think that we'd hear from Officer Noonan, and then I think we would hear from her. So it will kind of boil down to a he said, she said kind of thing. It's like, hey, this was what was going through my mind, and then Officer Noonan's going to be like, well, this is what was going through my mind. And he may very well be saying, I acted the way I acted, and he's remembering it like that to just kind of, like when something happens and you convince yourself that it happened a certain way, and then if you're able to look back on it, or somebody's able to show you proof, and it's like, well, it didn't really happen that way. Like our minds work in certain ways, and I would think being her partner, I'm thinking right now, I'm giving him the benefit of the doubt. Excuse me, that he didn't shoot her out of malice. Again, I don't know what the relationship was. I'm hoping that he didn't shoot her out of malice, or a nefarious reason. I hope that it was quote unquote innocent, where he truly felt like, wow, she's unstable and she's waving this gun around, so I've got to take her out. It would be really interesting. Like he's making his brain or his memory say, hey, you know what? I can't comprehend that I would actually shoot my partner other than, she was going to shoot me. So I had to take her out. So, yeah. I hope that she does take the stand. I'd like to hear from her. I'd like to hear her side of the story. All right. So this is another, they're hoping, so they have a new judge. So this is a press conference of them getting a new judge.
Then I'll jump in.
Yeah, so Attorney Bradle did all the working for it, as you can see. I just had to sit there. But representing Kelsey Fitzsimmons, as everybody knows, has been a privilege of ours and an honor. And I think today we saw a new day. We had a new judge. We had a different attitude. We had an approach to what we wanted in this case, which was everybody's entitled to a fair trial. Kelsey Fitzsimmons is innocent until she's proven guilty. We believe she's innocent. And we look forward to, in a very short period of time, bringing this case before the court on the merits. I think we made a lot of progress today. We appreciate that this judge was willing to listen, to try and resolve questions, to resolve problems, not create problems. And so I think on balance, given where we were a while ago, we made a lot of progress today. And we have a lot of work to do, but we will do it, and we look forward to our day in court, as does our client, Kelsey.
Attorney Coakley, when's the last time that Kelsey was able to see her son, and what kind of impact is that having on her in this case?
I'm going to let Attorney Bradle address that.
I mean, Christina, just in a very general sense, it's been a long road. It's been a rough road. We're coming to the end of it, and we have two jobs here: is reunification, number one, and to address this case, number two. We really need to get this thing done so we can focus on family court, and it's coming soon. So we're optimistic, and we're going to do everything we can to get this case heard on the 23rd and get it done.
Are you representing Kelsey in family court as well?
So it's a group effort. Yeah, she's got a great team over there. Julie has his lead counsel in family court, and we're supporting her. And she's sort of been hamstrung because of these orders from this court, basically saying, thwarting the family court from doing their job. So we expect that to be addressed soon, and we're optimistic, and we're very happy to have Judge Karp on the case, and we think we're going to get a fair shake, and I think he's going to address it very soon. And that's, Kelsey's number one priority.
Kelsey, are you able to talk a little bit about, are you more hopeful with the judge that you saw today? Are you able to comment on that?
Yeah, I am.
Are you able to step up?
I am more hopeful with this judge.
Why is that?
It just seems reasonable and fair the way a judge is supposed to act.
What are you looking forward to with trial?
We're all encouraged by that, and Kelsey wants to kind of let us take the wheel today in terms of talking to you guys, but that's something that we feel has not been present in this case, and it is going forward, and we're going to address things on the merits, and we feel like we're going to be heard. We feel like we're going to get heard by the court, and things are going to be okay.
Obviously, a big part of the hearing today was focusing on that video and what actually happened there. What do you want the court to take into consideration now moving forward?
In terms of what?
In terms of that video, do you think that there should be a conflict of interest ruled by either the court or the district attorney's office?
Yes, we believe there's a conflict of interest and that it can be addressed by the court, but, Judge Karp's got to make his rulings, and we respect his rulings wherever they are, and if it has to go that way, then we'll take another route. But we feel that, we believe that the DA's office here has an interest in propping up that witness, and the alleged crimes there should be evaluated by an independent prosecutor.
What is their interest in propping him up, as you said? Like what,
Disclosure from the prosecution. Can you tell us what that disclosure was?
So we're asking for a disclosure. This is a standard request that we want promises, rewards, inducements that have been granted or implicit in any witness's relationship with the prosecution. And it's very standard discovery. We wanted to push the Commonwealth and push the judge to really provide something meaningful, in the sense that we want all the communication surrounding that, if any, and we want something in writing from the Commonwealth about what they're doing with these witnesses that are apparently getting a pass on alleged criminal activity.
And I think because the judge has asked us, and counsel have agreed to do a witness list, we will see who all those witnesses are going to be. And then if we need to move further on any of those questions, we can do that. You heard the judge say he does not want this to be a trial by ambush. It shouldn't. So both sides should really know what we are going to be arguing about going forward. And that's the work we have to do in the next few days. And the judge, as you see, is going to look at that, reconsider some requests on the bail on March 12th, which we think is a good sign in terms of getting ready for trial and making sure we're ready. But we feel confident that he understands that both sides deserve a fair trial. And we're looking forward to working with him and moving forward.
Tim, after the sidebar...
Guys, wait, how about let's go our left to right, and we'll get everybody. I promise we'll get everybody. Don't worry.
Yeah, after the sidebar, it sounded almost like there was some admission that there was an inducement as it related to... Can you explain that a little bit?
Well, I think given the exhibits that we filed and the motion we filed, it's pretty obvious that there's some potential exposure there, to put it politely, and the government is acknowledging that it's implicit in the situation. I think that they're looking the other way, and they need to put something in writing to that effect.
So, well, didn't they say that they looked at the evidence, they looked at what you submitted, they considered the whole context of the case, and they decided no charges were warranted? Why do you feel like they weren't in a position to make that decision, and why do you feel like they have an interest in propping him up? The prosecutor said he's actually not that important a witness for us.
Well, it's not a question of whether they're important or not. And this is the first we heard of it today. This is the first time that we kind of flushed them out to actually say that they're, we kind of flushed them out today, that they finally said for the first time that, we'll give you the notice that we're not prosecuting him. We don't think it's a criminal case. I think the fact finder will have that ultimate decision in terms of whether or not, there's a behavior that's relevant to their determination.
I did want to ask on the North Andover police officer, you're planning to file a Rule 17 motion to get what do you think there is there?
Good question, Charlie. So we don't know. The way the discovery works is the courts always ask the defense, well, what do you want, counsel? I'm like, I want what the rule says. I don't know what's out there. It's the prosecutor's job to go figure out what's out there. And so we investigate our case, we get bits and pieces of information, and we use that information to point the prosecution to certain relevant evidence, certain specific evidence that we said that we can say to them, go look here, go look there. It's not incumbent on us to know exactly what it is. They have a legal duty to go find it, especially if we say, look in this particular location. So that's all we're doing.
You said today you're on the fence about whether Dr. Zeisel will testify. Does that mean you're on the fence about whether to pursue a mental health defense, or have you made a decision on that?
So everything's still on the table. Everything's up in the air and everything's still on the table. We don't. I guess it can't be up in the air and on the table. You get what I'm saying.
Kelsey, can you just tell us how difficult it's been to prepare for a trial while not being able to see your son at this point?
I don't want to comment on it.
I mean, as you can imagine, she's pulled in a million different directions here, and we have to get down to business, and that's hard for somebody in her position. And I have immense respect for her perseverance in this case, as all of us do.
So, Tim, on the motion about the bail, what else are you prioritizing? Obviously, you got the time requirement.
So we just want to get Kelsey some freedom and some access. There's these repetitive conditions that are just incredibly onerous in a case where someone doesn't even face jail time on the other end of it under the sentencing guidelines. So it's a unique situation where I've never had a case where the likely outcome in the sense of a conviction would have been probation, and then that person gets locked up pre-trial is unprecedented in my 30 years. So we want to get her in an appropriate bail situation from a fair judge. That's what we're here for.
And we should know she's been in compliance with all of these conditions, onerous as they are, and I think asking today for the court to reconsider them in light of that, in light of where we are, and his willingness to do so. He said he would entertain other issues that we brought up on March 12th when we come back.
And he's got to get up to speed on it.
The 12th is kind of late. It's like a week out, right?
Well, we'll take what we can get, you know. We have to take what we can get.
Kelsey, are there any misconceptions you'd like to clear up? Anything you'd be comfortable saying?
I don't want her to kind of just start pontificating about a lot of things, but you know, she's been through a lot, and you know, she just wants us to kind of go through it. Mike,
Special prosecutor, the judge seemed like he wasn't going to do anything about it. What can you do about it? Because it looks like this guy did some criminal stuff. I mean, just looking at it, it seems like it.
He's the judge, you know. He's the judge is focused on the notion of separation of powers. The way I see it, you know, I've read many cases where the court decides, they say, hey, this person has a conflict of interest. They reverse convictions. They do all sorts of things. So I don't see how this is any different. You know, but I respect Judge Karp immensely, and you know, he sees it as a separation of powers issue. We're going to have to grapple with it in another way. You know, we could file a request for a clerk's hearing. We may do that. We don't know. We have to think about it and react to, you know, the situation. And we just got that information today, so we'll have to see.
Can we talk a little bit about where does the motion to recuse McCarthy, where does that stand right now?
So it was denied as moved, and Judge Ricciuti, the chief judge of the Superior Court, he took it over and he made that ruling, and he took Judge McCarthy out of the case. And as far as we're concerned, that means that Judge Karp is the judge. You know, we can't have it halfway where he doesn't want to make any rulings and defer to a judge that's not considered the case. So,
how confident are you that he's rule that Judge Karp will be overseeing this whole case in its entirety?
I think very confident. I think that makes sense. I don't think
Judge Karp said he was going to ask him,
yes,
and he felt confident that would occur. It makes sense to have the same judge now make all the decisions that are applicable pre-trial or the trial, including whatever and so we're hopeful that, as Judge Karp noted, he will be in charge of this case going forward through trial, whatever comes out.
Can I ask one more question? I was surprised to hear that this whole time Kelsey's been able to drive. I know that you spoke about her being apprehensive, having trauma, after being, you know, incarcerated after that last bail hearing. Is this something that you either overlooked or you were just out of an abundance of caution? She wasn't transporting herself. You know, it seems like it came out of this discussion today that she's been able to do it all along, or at least Judge Karp's interpretation of the order is that she could be doing this.
So there were all sorts of verbal pronouncements from the prior judge, and you know, given what happened to Kelsey, we have to be extremely careful. And you know, there were all sorts of verbal restrictions that apparently didn't get into the contract. But we were certainly in no position to take any liberties with everything she said, especially given her inclination to put Kelsey in jail. So we had to go with everything verbal that was put out there as well, and that was definitely put out there.
So Judge Karp said, "Good to see you again." What's your experience arguing about that?
Judge Karp, I haven't seen Judge Karp in probably over a decade. And, you know, Judge Karp's been a very respected jurist for I think about a decade. And probably 25 years ago, we were both in the Suffolk DA's office. Different reasons.
I did want to...
So good question, Justin. So we got the surveillance system back today from the House. And so now, you know, it's been gone through with a prosecutor's eye, and now we get to go through it with a defense eye. So to be determined. Stay tuned on that one.
Hey, Tim, we learned today for the first time that the Commonwealth decided, hey, we're not going to prosecute based on what you advised them of back in August.
Yes.
Have the federal authorities been informed of potential issues, bank fraud, wire fraud, anything like that?
So one of the predicates for pursuing that is that you have to file a complaint with it's an FBI-sponsored agency, and we're going to look at that, and we're going to talk to Kelsey about that as well. So that may be an avenue as well.
What if you did go before the clerk magistrate, and they go forward with the DA's office now prosecuting?
Well, Mike, wouldn't that put them in an awkward position? So if the clerk magistrate finds probable cause and issues complaints, then I think it would be something that would put their feet to the fire about whether they prosecute it or whether they pass it along to an independent prosecutor. So let's see what happens.
Or to another county. They have the option of going to another DA's office as well.
Can I ask Kelsey how you feel about some new freedom? It's bittersweet. It's only to Tim's office, but you're able to leave your home. You're able to drive. How does that feel knowing that you have that freedom today?
I think it's a step in the right direction. Only a few weeks away from trial. This is definitely the hardest thing I've ever gone through in my life, and we're just gonna keep standing strong and make it to trial.
Thank you.
Everybody good?
I saw Hank Brennan in the elevator today when you mentioned any interest, special prosecutor.
I would love for Hank to get his hands on this, and
I don't think
somebody
he was here for that.
We'll take anybody, but I think he had some other business today. He's still a defense lawyer as well.
Thank you all.
I was hoping we could make it through this trial without Hank Brennan's name being mentioned. Of course, Hank Brennan. Hank Brennan was in the elevator. All right. Now I want to jump over to the court, to the hearing, or this was from the same day. So this may be, let me check this out. I haven't actually seen this. This may be from inside the court. That could have been outside the court. This is inside the court. Issues related
to that. That's my agenda. I don't know if you folks had other things that you were anticipating or wanted to raise. Anything? No? Did I miss anything?
No, I think you covered it.
All right.
I do have a few things.
Sure.
So we have a long list of things that we consider to be outstanding discovery. So I think we have a Rule 14 issue, and counsel and I have been going back and forth on it, but I don't think that there's been enough digging, frankly, about some of the stuff we're looking for.
All right, so I'll tell you what. So that will be part of our discovery agenda. All right, we'll do that. I'm not cutting you off. I'm just trying to get an idea of what lays ahead. But yes, I do want to get out in front of the anticipated discovery issues, including the motions. There was motions that were filed. But,
sure. And Judge, on that bail motion, I certainly want to give the Commonwealth time to look at it and react.
On the what?
The bail motion that I requested.
I saw something. I have not read it. I don't know if Mr. Gubitosi shared. I had a charge conference this morning in a trial that's been before me for 5 weeks. It's going to the jury on Monday, and I just haven't had time.
Sure, I understand.
So if there was something filed this morning, I didn't see it.
Sure.
We can talk about that. But you said it's bail related?
It is, Judge. It just whenever you're ready to address it, but there's just some pressing aspects of her terms of release that are really hindering our trial prep.
Okay, I think, so I'll tell you this, I have read the materials that are in the file. I don't know anything else about the case other than what's in the file. But my memory is that, wasn't there a 58A order?
Yes, Your Honor.
And so if there's any changes that need to be made to that order, I believe the law requires it to go before the judge that imposed the conditions. Is the defendant out on conditions of release?
She is, Your Honor. That's correct.
Okay. So,
So that's going to trigger a recusal hearing, Your Honor. We have a request for an evidentiary hearing that Judge Ricciuti, the Chief Justice of the Superior Court, took over, and he ruled that my motion to recuse the prior judge was moot because she was not going to be around in the sessions. So this is a...
Let me first get this that you're talking about.
Sure.
Mr. Ruane, let me get the motion. So this is paper 54, defendant's renewed motion for bail determination under Section 5787 of Chapter 276. So when you say...
So we're asking for a revised bail determination. That's correct, Your Honor.
Okay. In other words, a change in the conditions of release or something?
Yes, that's correct. The document 51 in the docket, Your Honor, is our just filed. The prior substantive motion we filed was a motion to recuse Judge McCarthy Noonan from the case.
Okay. So let me first see if there's even an issue. So, sure. Mr. Gubitosi, you presumably have seen this motion?
Yes, I got it late this morning.
All right. Leaving aside whether today is the appropriate time for it to be heard or not, what is the Commonwealth's position? Should it be heard by Judge McCarthy? Or?
Well, yes. At the end of the day, there was a number of hearings in front of Judge McCarthy. The defendant appealed her decision to the SJC. The SJC denied the appeal, saying she did not abuse her discretion. That's where it stands now. Defense counsel did file a motion to recuse Judge McCarthy. As counsel said, I can't remember the name of the judge.
Ricciuti. Okay.
Yes, deemed it moot because he asked her to get off the case. Not anything else, just to get off the case. That's what the defense counsel was asking for. Because she wasn't in the trial session, she wasn't going to be the trial judge, so none of that was acted upon. And so, but there's been an extensive history that the judge has dealt with, and frankly, I don't see a change in circumstances anyway. So,
well,
I would point to document 51 for a change in circumstances, Your Honor, about the true nature of what's been going on in this case.
Okay, so let me say this. I like to have practical results and be pragmatic as pragmatic as the rules and the law allow me to. So I don't. Is it something that you would object to me hearing or something? If I have the legal authority, if you folks agree that I have the legal authority to weigh in on it, I don't know that today would be the appropriate day to do it or not, but we can talk about that.
I appreciate you being open to that, Judge, and I can narrow it, in terms of what I want to impose a little bit on the court and the counsel today to deal with is, some of these terms are duplicative and they're just bureaucratic. They're just onerous. And, 48 hours notice to make an appointment to come to my office. I don't know when I'm going to be in my office within 48 hours, And I need to have Ms. Fitzsimmons more at when I need her to prep. And so the idea of giving 48 hours notice to probation, to leave house arrest, to come to my office in Boston is just extremely onerous. Also, she's in the custody.
Because there's a couple different issues. One is whether because I don't want to waste your time if it in the sense that if it's something that does need to go to Judge McCarthy. So I guess what is the Commonwealth's position? Presumably the defense position is that I can hear it.
Yes.
And I should hear it.
You should. Well, our position is that she should be recused. We're more than willing, ready, willing, and able, and happy to have an evidentiary hearing on it. I don't think the Superior Court wants that on her recusal. And we think that the entire framework of this case has been an absolute circus from the beginning. And I'm glad you're here, frankly. And I have a pending motion to recuse. Well, not pending, but I filed a motion to recuse, Judge. And I am very unhappy with the way this thing has unfolded since arraignment. And we have moved to recuse. Judge Ricciuti, I think wisely, has made it a non-issue. And I want to forge ahead with Your Honor. And I want to go ahead with the case on all aspects with Your Honor. And I don't think it's in the Superior Court's best interest. I don't think it's in Kelsey's best interest. I don't think it's in anybody's best interest to kick this back to where it just came out. And I just want to ask for a few things today. And I know that, the court can say no, you got to wait. The Commonwealth can say no, you got to wait. But I think these things are not unreasonable. I just want to get rid of the 48-hour notice. I want her to be able to come to my office, get in a car and drive there on her own, like a grown-up. Her mom is the custodian of Ms. Fitzsimmons. Her mom works full time. This has been an incredible hardship on her. She's got to drive her to my office and sit around for 3 hours. It's really unfair.
Let's do this. Before we end today, we will address whether I will address it or not. And the reason why is because I like to read it. When attorneys take the time, either side, take the time to write something and file it, I like to read it. And I haven't read it, and I
appreciate it.
Completely at a loss without knowing. So we'll need probation up here if we get to that point. But in any event, we'll circle back. I don't want to start on something that. Let's just start looking forward instead of back.
I love the idea, Your Honor.
We'll do that. So in any event, all right. So let's talk about legal and evidentiary issues, and just in the sense of deadlines. What I would like is a joint witness list, I'd like a joint witness list because what I intend to do is treat this case like any other criminal case I preside over, and that is there will be individual voir dire, there will be attorney-conducted voir dire, and there will be a questionnaire. That's kind of my standard procedure. I won't try the case in front of me, but I know your staff has. So I have. Oh, you have? Yes. Oh, okay. All right. So I guess you must have done such a good job that I don't remember. But in any event, so that's where we're going, so the reason why I bring that up is because one of the questions that will be on that case-specific juror questionnaire will be, do you know any of these potential witnesses? And what I like to do is just attach some Word document or something that has both of your witness lists, both of your witnesses on, both sides' witnesses on there. Also, on there we should list, the way it will be phrased is it will be potential witnesses and anyone possibly associated with the case. So if there's names of folks that their names may be prominent during the trial, some business may be prominent, I have no idea. Just things of that nature should be just, the mechanism to do that is to put them on this, potential witness list so that folks can flag it in their answer to the questionnaire. All right, so that's, and then also, frankly, I need to see a witness list sooner than later to make sure that I don't have any conflicts as well. And while I'm thinking of it, I will say this: it's not a conflict in my view, but I will raise. I did see in the file. I thought I saw a report from Dr. Zeisel. And was that on the defense side, right? Because you're
yes, sir. We have him.
54, right?
And that name didn't sound familiar.
No, okay. So I don't know if he's going to be a trial witness or not. But I will tell you, folks, Mr. Gubitosi may know this. I don't know. I used him a lot when I was a defense attorney. I've been on the bench 8.5 years, and I don't know if he's testified before me. I did keep in touch with him professionally for it felt like the first year or two I was on the bench, just because I still had cases. There were still cases pending that I had been counsel on. But I don't believe I've spoken to him in 7 years or something. But I did want to disclose that. Again, I don't see a conflict at all. But you folks can think about it. And do you expect that he'd be a witness?
So, Judge, we're sort of on the fence about it, actually. That's the number one area that we're on the fence about. But if you don't have a problem with it, we certainly don't have a problem with it.
I don't, but you folks will let me know. So, on the legal evidence what motions, what unusual trial motions should I expect, if any?
I don't think there are really any unusual ones, like bad act motions, things like that.
Yeah.
Nothing unusual from the Commonwealth side. With the caveat that I don't know who their witnesses are or whether they're going to be calling an expert, and that's one of the things I think we need to address today. So.
Okay, yeah, that is a good point. So, because if there's going to be a mental health defense, so I want to keep this case on target for March 23 because.
Agreed.
From my perspective, and I'm sure everyone agrees, if it's not March 23, then that's the to the extent that the case is assigned to me, and I don't know if that's been formally done or not done, then I'll be off to a civil session for 3 months, and we'll be waiting. So we've cleared the deck, so to speak, for March 23. So I'd like to make sure that we're on target to do that. But things like mental health defense could slow things up if the Commonwealth wants to hire their own expert, et cetera. So
I understand, Your Honor. So I think the Commonwealth has Rule 14 problems, though. They've got to comply under Rule 14 before we have to do anything. And I have a list of and I know Commonwealth's been trying to kind of work with me, without bothering the court, which is always the best way to go on these things. And, we're sort of getting there, but it's going very slow. And I have a list of about 8 things here that, make their certificate of final discovery compliance really not accurate.
So can I ask, I thought I did see, Mr. Kubatosi, from your perspective, is it the Commonwealth's position that you folks have complied, or are there still outstanding discovery issues?
I think the only outstanding discovery issue, and I did reply to defendant's request for his 8 items the other day. I hope he got my reply. It is the ones that we're going to talk about this afternoon.
Okay.
So other than that, there is maybe an issue with I have to provide him a link to something. But other than that.
Okay. All right. Well, I'll tell you what. I put it on the agenda. Let's get right to it. What are the discovery issues?
So, Judge, today...
and did you say that there was a certificate of compliance filed? Because I should...
The last date, Judge, right. And,
Mr. Wayne, do you have any idea what... I'm sorry, 50? I'll just get that up. Okay, go ahead, Mr. Brito.
Thank you, Your Honor. So, Judge, today the Commonwealth is giving me a surveillance system that was taken out of the house. So I appreciate that. We've been looking for that. There's some video.
What do you mean?
So
they produced the actual.
They took the actual system, right? And we need it for some other cases as well. And we've gotten that taken care of today. The Commonwealth's going to give me that system today. Expert notice. Okay, so under Rule 14, I don't think we have the proper expert notice in terms of the CV and who's testifying as an expert and what's the opinion going to be. I don't know that I have everything or on that. And I'll elaborate on that a little bit as well.
Well, let's just take them one at a time. Sure. So, what kind of experts would there be unless there was a mental health defense? You're talking about ballistics or something?
Yes, ballistics.
Okay.
I turned over the CV to defense counsel. It's on Axon. He has the report of the ballistician who analyzed 3 guns and says that 1 gun matches the shell casings that were found on the scene. Other than that, I don't see any other.
But this isn't the defendant's not charged with a firearm offense, right? It's ADW. Is that
so? Here's where I'm going with this, Judge. We're sort of talking about 2 separate things. The Commonwealth has given us a 7-page report, and the report concerns the guns that the responding officers had. It lists 3 Glocks, and they're all the service weapons of the responding officers.
Okay.
So that's great. I'm not interested.
No, that's incorrect. And if defendant, I sent an email to him, February 6th, because we had talked about this. I hate to interrupt, but he's just wasting his time.
Go ahead. I'd like to hear it. Go ahead.
And in the email, I talked about which gun was which gun. There was 2 officers who were on the scene. One, the shooter, one Officer Noonan, who discharged his firearm, another officer who did not discharge his firearm, and the gun that the defendant is alleged to have. Yes, who is alleged to have used. And that was her service weapon. And I detailed for that to defense counsel. And so the analysis that was done on the gun that was involved in the shooting. So that's all.
So this would have been, what was the officer's name?
Noonan.
This would have been Officer Noonan's service weapon?
Yes, and so I had sent an email because we had been talking about that on February 6th concerning that exact issue to clarify for defense counsel.
Okay.
So,
go ahead.
I appreciate counsel interjecting with that. And if it's, I'll go back and look at it, but I read it to be the 3 officers that were at the scene and that their guns were taken pursuant to protocol. But if the Commonwealth is saying that that's the gun that was used, then that's fine. And I'm satisfied with that. I didn't read it that way, but if that's how the Commonwealth has it, I'll go back and look at it, and that's fine. So that's we can take that one off the list.
Okay.
Body-worn cameras, Your Honor. There were an officer visited Ms. Fitzsimmons early on when she was at Mass General Hospital. She spent 53 days at Mass General. An officer visited her there, and I don't know if there's a report that emanated from that or a body camera that emanated from that. And then,
so when you say body camera footage, it's very narrow. You're saying, like, right. There's a specific event or
right. It was one officer that visited her at the hospital. Right.
Okay. And was this a social visit or something?
That's a good question. It might have been half and half. I'm not sure.
And, would this have been a North Andover officer?
Yes.
State police. Okay. So, yes. And have you told the Commonwealth the identity of the officer and the service?
It actually might be the trooper. If I could just have one moment. Sure. Detective Dan Furman.
And I don't know, who is that?
So he visited Ms. Fitzsimmons at the hospital, and if there's any...
I'm sorry, I meant when I said who's that, I meant what police agency?
So there's a visit from someone who might be a social visit or a police visit. I don't know what it is, but I'd like to know if there's any documentation of it.
All right, so this, but again, this person's name, this officer, detective's name?
Furman, F-U-H-R-M-A-N.
Okay, and what police agency does he work for?
North Andover.
All right. And so this should be, well, and you're saying that you don't know if it was a social visit or not?
All I know is the North Andover police officer visited her, and is there any documentation of it, or is there a report? Is there a text message from it? Is there anything from it? I just want to know.
I'm not expecting any answers right now. I'm just, do you want to weigh in on this?
No, this is the first I've heard of it, and I think the defendant would know if it was a social visit or anything more than that. I don't believe North Andover has body-worn cameras, but I will certainly make an inquiry. This is the first I've heard of that. So.
All right. And then there's also office wanting to move the case along and get her arraigned, and there should be body camera from the state police from that.
All right, so is it...
And I believe that's true for strong.
Is this request from... Are you familiar with this, Mr.
It's my understanding that defense counsel called me and asked that there not be body-worn camera when the state police went to her. So, but I will double check that. So.
Okay.
Well, my client tells me that there was body-worn camera that was activated, and that she was informed that there was body-worn camera.
Okay. Well, if there was, then it sounds like it wouldn't have been North Andover. So
no, that's state police.
State police.
Yes, Trooper is here today. I'll ask him.
Okay. All right, and you know what? Excellent, because if the trooper's here, to the extent that we can put any of these issues to bed today, that would be great. So what else?
Promises, rewards, inducements, Your Honor. That's the subject of an entire filing today.
Okay. So we will. Do you want to do that now, or do you want to? What else is? What else is on your list? We'll circle back.
That's the list, Your Honor.
Okay. All right, but I want to make sure I'm not missing anything, because didn't you say that you had 8 things and I only have 4?
So So I'd like a witness list from the Commonwealth. I'd like to move to strike the certificate of discovery compliance to the extent that it triggers our obligations when their discovery obligations are not satisfied.
And by the way, Attorney Coakley, I don't have these rules about. I have a case in front of me now where there's 3 DAs and three assistant DAs and 1 defense attorney. They're all welcome to speak. So to the extent that I'm not, I don't have rules against more than 1 attorney speaking. So
I appreciate that, Your Honor. I'm not afraid to speak. Attorney Brill knows that.
No, you're not afraid at all. But I don't want you to anyone to think that to the extent that you want to be heard, you can be heard.
Thank you. I appreciate that.
What else?
Judge, there's also some OneDrive links that I know that I think the council referred to that. There's some OneDrive links for some discovery that we don't have. That we got some Axon discovery that had OneDrive links in it, and it was not communicating very well with our computer. So council is going to get me OneDrive links for, I believe, 37 more. So I'm actually at a loss to say what's on these OneDrive links because I can't open them.
Okay, all right. Well, that's Mr. Because you want to. Do you know anything about?
Yeah, as I had said just a few minutes ago, I understand what he's looking for. I understand, and we'll send him the link on Monday.
Okay. All right. What else?
I believe there were some redactions in the grand jury minutes that were given, Your Honor. And if there are any redacted grand jury minutes, we need the unredacted grand jury minutes.
I've never heard of that. But
right. Yeah, it was strange.
No, and I tried to explain this to him when he got a redacted exhibit that I used in grand jury. And it was an interview with some of the officers that talked about things that I thought were too prejudicial to the defendant. And so I submitted to the grand jury for their consideration the redacted exhibits.
Okay.
However, he has the full exhibit also, meaning a full unredacted version of those recordings.
Okay.
So the grand jury minutes themselves, I'm sorry to interrupt, are not redacted. So.
Okay. If I have it, I'd like to have it. And,
yep.
Okay. So yeah, I mean, it sounds as though Mr. Gubitosi has produced them, and I'm sure will, if not, both the redacted and the unredacted version. So you'll have a record of what exactly the grand jury saw, if you don't already.
Thank you.
What else?
The rest is the promises, rewards, inducements motion, Your Honor. There's 2 cases here that are.
All right. So we're ready to go to the motion. All right. So let me just cue that up. Where's my notes? So it's paper. It's been docketed as paper 53. Defendant's motion for disclosure, promises, rewards, and inducements. And I have read it. I've read the attachments, and I don't know if this is an issue for Mr. Gubitosi or not. But I'll say that the problem that I saw with the motion is that it's not supported by affidavit. And I don't know, again, if that's something that the Commonwealth would raises or not. But to the extent that you're relying on statements of your client and your client's father, I typically would see that in an affidavit form. Is that it?
Well, Judge, I do have an attorney's affidavit, and I do at the end of the motion, but I do view it more as like what we're doing here from the defense side is we're pointing the Commonwealth to specific exculpatory evidence.
Right.
So, how far we have to go with affirmative, averments of that, I don't think it's not like a motion to suppress where we're asking for the court to, make significant rulings. This is a notice to the government that says, hey, look at all this stuff that has happened, and you need to figure this out. And I think that the government in this case, with respect to this Aylaian guy, has rose-colored glasses on, where they're like, they don't want this guy to be harmed. They think this is a probate court issue. They think this is, just focus on Kelsey. Let's not worry about this guy. Don't look over here. Don't look behind the curtain. So this is an incredibly egregious thing this guy did. Ms. Fitzsimmons was in the hospital fighting for her life. That was her home. He had gone and gotten a restraining order in which he swore in the affidavit, I don't live there. I live in Stowe with my parents. He's now a plaintiff against Ms. Fitzsimmons as a defendant in a restraining order matter. He has no rights to that house whatsoever. 3 days later, her dad, who's a security expert and owns a security business, changed the locks, updated the security system, made his daughter's home secure again after this thing happened to her.
And after the shooting.
After the shooting, and she's in the hospital. She's away from her house. And this guy takes advantage of that to commit all sorts of serious crimes. He's on video breaking into the place with 3 other friends, 3 other accomplices. Bust down the door, come in, it's on video, it's in an exhibit that you have, and he commits all sorts of serious crimes. The most serious one for purposes of this case is that he stole evidence. He stole evidence off the refrigerator. It's a felony.
Can I ask you something?
Yes.
Assuming everything that you say is true, the motion is for promises, inducements, or rewards. So your theory is what? That the Commonwealth promised to not charge this guy or something?
Yes. That's exactly what we think. And he's a precipitated witness. He's at the scene of this shooting, Your Honor. He's at the scene of the shooting. This isn't about, 3 days earlier he did this order. It's that he's a precipitated witness at the shooting. He's there. He and his sister are there.
At the end of the day, the motion is for promises, inducements, or rewards. So
yes.
As those terms are understood, has the Commonwealth made any of those or offered any of that to this gentleman?
I think I can answer it this way. Okay. As far as him being a recipient witness, and you don't know very little about this case, the 2 people who were there in the room when the shooting occurred, when the allegations against the defendant pointing the gun at Officer Noonan and pulling the trigger, and him shooting her in self-defense, the 2 of them were out there. That's in a top floor bedroom. Mr. Aylaian was in the basement at the time of the house. He's on surveillance video in the basement. He hears it, he leaves. So he's not a recipient witness. I'd just like to put this up there. That the case does not rise and fall on him. He might be a background witness. He heard the shots, but as far as what happened in the bedroom, he has no idea. So to say he's a critical recipient witness, I would suggest is a little misleading.
But whether he's critical or not, there's either.
And I agree.
Okay.
And but I just have to correct the record.
Sure.
Now, defense counsel sent my office a packet of information, including, and we had the video of, oh no, we didn't have the video. He sent video of Mr. Aylaian, I'm going to call him Justin, I apologize. I'm having trouble with his name. Entering the house on a specific day. And the Commonwealth, and what is omitted from the defendant's argument, and he has this, and he knows that the day before this happened, Justin called the North Andover police and asked if he could enter the apartment. He told them that the defendant was on the deed, but he had property there. And they told him he could go in. On the next day, where this video is, he calls again and says, I need to go into the apartment to get my stuff. He asked for a police escort because he's afraid of what the defendant and the defendant's family would do if he went in there. He was worried about his in his words, vengeance. Okay? And so he does go in. He does push the door open. He goes in to retrieve his items.
With the police escort?
No, the police didn't come. At that point, the alarm went off because I'm assuming there was some surveillance video in there and an alarm system.
Sure.
When the alarm goes off, he calls the police and he says, can you come here, please? The alarm went off. I'm worried that the family of the defendant will come, and I'm worried what will happen because they're very vengeful about the whole situation.
Okay.
And they said, we're not coming, but if he shows up, let us know and we'll come and keep the peace. He then gathers his belongings and left.
Okay.
So we can't look at a crime. The Commonwealth, in any case, does not look at a crime in isolation. We have to make determinations when we're looking at cases. Okay. Justin has also filed an affidavit in court.
In this court or in the...
No, in the probate court, as the restraining order, which 3 judges have been found credible. And the defendant has yet to litigate that motion. And so we have information from the defense about what happened, about this breaking and entering and this supposed theft of evidence, and that's the first I heard of it was evidence. And we had that packet. We reviewed it in an abundance of caution. We asked Middlesex to look at it, and they were going to take a look at it. At that point, Attorney Copley called Middlesex, the first assistant, about that. Middlesex then called us and said, we can't do it. We don't want to take a look at it. We think we have a conflict now. So our office then looked at it, and we determined that we are not going to charge Mr. Aylaian for these crimes. I don't know if he even knows that this is out there. I don't know if he even understands that there are charges that the defendant is alleging occurred. I haven't talked to him about that. If I do, and if he has a concern, I'll tell him that we're not charging him with that, based on the entire circumstances of this case. The Commonwealth is often in the position of analyzing cases when there are dueling issues and dueling statements, and we have an obligation to parse those out, and if we don't believe there's probable cause, we don't charge. That's what we have here. The Commonwealth has made the determination, not in isolation, but in the whole circumstances of this case, that we are not going to charge him. If at some point during the case, Your Honor thinks he has a fifth, we'll immunize him. But we haven't told him that. Defense counsel is now on notice that that is our position. So is it a promise, award, and inducement? It is what it is right now.
Okay.
So they're on notice of that.
All right. So, Mr. Bradle,
yes.
Let me see this. So the whole idea of discovery, obviously, disclosure. It sounds like perhaps this is the first time you've heard the full version from the Commonwealth's perspective. But to the extent, now probably isn't the time to determine whether it's a promise, inducement, or reward. I think now is the time to determine the sufficiency of, assuming that it is one of those 3 things, the sufficiency of the notice provided to you.
Absolutely. That's what we're interested in, Judge.
All right. So
communications.
All right. So it sounds as though, so what is it further that you're looking for? You want something in writing that they're not going to...
So just a couple of quick things, Judge, as far as what Cromwell said. I have the call that he made to North Andover, to one of the sergeants up there, I believe Sergeant Gerke. I may not be saying her name right, but we have the call. And in the call, he's committing another felony called misleading police. He's saying to her that he still lives there and that he wants to get in there, and he's looking for a dispensation from them to let him get in there. And he lies to her, and he says that he still lives there. completely contradicts what he already swore to the probate court judge, family court judge, to get the restraining order. And so the sergeant, I think, does the right thing and says, well, if you have a key, or, if that's your house, I can't stop you from going in your house. But she doesn't say, yeah, you go right ahead and go in the house. She's deflecting and saying, well, you're telling me you live there, I can't do anything about it. So it's this sort of round and round conversation where he's trying to get dispensation from them, and she wisely just says, well, if it's your house, go ahead, but I don't have anything to do with it. That to me is the gist of the conversation that I have. So there's yet another crime that they're looking the other way on for this guy. But in any event,
Mr. Brito,
so I'm sorry, Judge, I'll tell you what I'm looking for. Okay? That's it, please. All right, I'm sorry. So I'm looking for text messages, emails, notes to what is the police, what is the DA's office, what are they saying about this incident that they know about? Are they saying, don't worry about it, we're not going to prosecute you? I want the communications. What are they saying? I can't, it's always hard from a defense perspective to, guess what's out there. They should be giving me, here's all the communications about Aylaian and him breaking into the house and why we're not prosecuting him. And this whole business about that, he checked with the police, he lied to the police. So he didn't check with the police. So their facts are all wrong. And, he should be prosecuted, and they're in a conflict of interest, and the court should direct them to appoint a special prosecutor because they clearly have a conflict of interest in trying to prop this guy up for their own case. And so they ought to be ordered by the court as a matter of ethics, as a matter of appropriate behavior as an attorney to appoint a special prosecutor. And I want to ask the court to take a serious look at that.
Let's do this. Can you, can Ms. Fitzsimmons as well, come on over to the sidebar for a moment.
Yikes with the white noise. So I had to go back and watch the closed caption again. So Justin was there. He was in the basement the day of the shootings. They say he hears it, but then he also broke in a couple days later. Well, whatever you want to say, he entered again. And he's messing with evidence. He's tampering with evidence. It's a crime scene. All right. We'll continue on. Oh, actually, is that it? That's going to be it. Looks like, yeah, that's it. All right, I guess that's it. All right, I guess that's it for that one. Okay, so then we saw that news conference. So I played that news conference first, and then now that was the actual trial, or the hearing, I should say, hearing. All right, so now I want to get to... okay, here's one from March 12th. Actually, okay. All right, so here's an overview of what we're going to watch next. So this is a news clip, quick little news clip, like a minute or so of the next hearing. In court today. And then we're going to watch the actual hearing. All right, so here's the news clip, and then we'll watch the hearing.
The North Andover police officer who was shot by her coworkers, Kelsey Fitzsimmons, is awaiting trial on charges that she pulled a gun on those officers. As WBZ's Christina Rex reports, the judge granted her some additional freedoms today.
I'm going to allow the change.
11 days away from her criminal trial, North Andover police officer Kelsey Fitzsimmons has a small victory in court. A judge ruled that she can now live on her own out of her parents' supervision and start the process of fighting for custody of her 1-year-old son, who she hasn't been allowed to see since last June. Fitzsimmons is charged with assault with a dangerous weapon. Prosecutors claim that on June 30th, North Andover police officers showed up to serve her with a restraining order from her fiancé and take her son. son. They say she pointed her service weapon at them, and an officer then shot her in self-defense. Fitzsimmons claims she pulled the gun on herself in a mental health crisis. Until now, she has not driven herself, has lived under her parents' supervision, and has been tested for alcohol use 4 times a day with a Scram device.
It's a total red herring, and it never should have happened. And I am furious about it. It is absolutely beyond the pale that she was tortured with that Scram device, Your Honor, and I'm furious about it.
In the pretrial hearing, Fitzsimmons failed to get this video admitted into evidence, which she says shows her ex-fiancé, a North Andover firefighter and witness in the case, repeatedly smoking marijuana. But the judge said it's not relevant.
Marijuana is legal, right, in Massachusetts.
Jury selection starts on March 23rd. In Lawrence, Christina Rex, WBZ News.
All right, so we heard about that, and when at the top of the coverage, top of the stream, we talked about that he was seen on video, smoking or whatever, and it's legal, sure, it's legal. All right, so now we're going to watch the hearing. Let's watch that hearing that we just heard about. So that gives you it's like Cliff Notes, if you will. So that teases what we're going to watch. So let's check this out. All right. Hold on a sec. Hold on, just have to give it a moment. There we go. Okay. All right, here we go. All right, so this is from March 12th. So this one is from hearing from March 12th. Hearing from March 12th, 2026. All right, so this is a hearing from March 12th, 2026. Yes, he is a firefighter. But he was placed on leave. He was placed on leave. Yeah, the 12th. Well, you have the article. Yeah, okay. So this is from March 12th.
Mr. Aylaian.
Aylaian, that's correct.
Aylaian, is that right? Okay. And let me just say, I did have a couple of questions for you folks before I turn it over to you, Mr. Brado.
Sure.
Does the Commonwealth intend to call Mr. Aylaian at the trial?
Yes.
Okay. All right, so I guess a couple of observations, Mr. Brado, then I'll turn it over to you. One is that your affidavit in support doesn't mention Mr. Aylaian at all, so I'll just point that out to you. Also, the proposed order doesn't mention him either, or who the subject of the records would be that would be ordered to be produced. And also, essentially, if I understand this correctly, and I did review, there was video footage that you folks dropped off last night, or at the end of the day. I couldn't get the other phone drive to open, but I did review the video footage. But if I understand, generally speaking, that there's these multiple instances, if I remember correctly, in April or in May of 2025, where Mr. Aylaian is observed on this video, I assume at their residence at the time, smoking marijuana or something.
Yes, Your Honor, that's what we would allege.
And so, and your argument is somehow this would be relevant to Mr. Aylaian's ability to perceive the events and hear the events accurately and then relay them. So, but how was, let me ask you this, marijuana is legal, right, in Massachusetts, as is beer. So if the video displayed him, Mr. Aylaian, drinking a glass of whiskey or beer the number of times that you saw him,
what's the difference?
Right. What is the difference?
Happy to answer, Judge. So in this case, the state of the evidence is that we gave you 4 or 5 clips as a representative sample of over 200 clips that we have that are similar over a long period of time. And
in other words, 200 instances.
Maybe 270. I'm being a little conservative, but over 200, let's say.
All right, over 200 instances of
what you see in the representative sample.
Okay, and what was the time period?
So the time period would go back probably a few months, Judge.
A few months before the June 30 incident?
Correct.
Okay.
Correct.
All right. And this is something that has been produced to the Commonwealth?
Yes, we sent them, and actually we got it from the surveillance that the Commonwealth had that they returned to us recently. Okay. So they definitely have everything. And so, Judge, it's fair to say that there's a pervasive marijuana use by this guy. Okay. And I understand, your point that marijuana is legal in Massachusetts. It's illegal under federal law, number 1. Pages 37 and 38 of the town of North Andover policy and procedures have a very comprehensive anti-drug policy for all town employees, which my brother and I were just discussing. It's a public document, and it prohibits any drug use on town property, prohibits any showing up to work under the influence of any drugs, no smoking. There's also a statute.
But what's the evidence? I get all this. I certainly understand. And I certainly understand that there's plenty of legal substances, including alcohol and marijuana, that would absolutely affect a person's ability to perceive and recall and et cetera, and testify credibly. But what is the evidence that on June 30th, at whatever time in the morning it was when this incident happened, that Mr. Aylaian was under the influence of something at that time?
So, Judge, it was the afternoon, and the idea is that the pervasiveness of the usage raises a legitimate question, and this is a discovery question. We're not talking about an admissibility question at this point. We're just talking about a discovery question. And I would venture to say that the standard there is that it's something.
I'm sorry,
yes, sir.
But the case law is clear is that this can't be. I think it's. I just was reading Commonwealth versus Jones, I think, which is clear that this can't be. Rule 17 can't be used as a discovery tool. It's a tool to make the trial more efficient. In other words, you have to show that the evidence would be admissible.
Yes.
Right? So.
Well, I mean, it sort of is a discovery tool in the sense that we get the documents early, and in order to get the documents early, we have to make a showing. And I think the showing is made, Judge, in terms of relevancy of his ability to perceive and recollect. That's something that's always relevant. And so we have documented video of him smoking marijuana all over his home all the time for months, over 200 times. And so the pervasiveness of it, I would suggest, points to that there's a problem, number 1. Certainly the problem with this guy. But number 2, Your Honor, that there's likely to be overlap with his work schedule as a firefighter, where it would certainly come into contravention of town policy, which is page 37, 38 of the town policy, which prohibit showing up to work under the influence of marijuana. And that would trigger the further town policy, which is that if there's an incident, there should be random testing of town employees. And so we think there's a good faith basis to say, give us this early, Your Honor, that if he's been tested at work and he tests positive at work, he's been given breaks at work, he's been put in rehab at work.
But how would that be admissible? So let's assume he even 2 days before, on the 28th, his screening came back at his employer for positive for THC.
Sure.
Okay, so then what?
So I have a good faith basis to ask him on the stand, were you smoking on when this happened? Do you remember these events accurately? Do you even know what you were doing when you were in that a basement, you're taking your baby under the influence of marijuana.
You don't think you have that good faith basis to ask that question now?
Well, there's always
200.
I don't need to tell you, Your Honor. Trial lawyers are worried about when the guy says no. And that's why it's a discovery matter in terms of, ultimately it would be a discovery matter to get the stuff. But, the lawyer is always at the mercy of someone saying no. And then if you have the backup, we can, as we say, we can prove it up. So it is relevant in that respect of us needing to know how pervasive his marijuana problem is. And we have pretty good evidence, times 200 and whatever, that it's a pretty pervasive problem. And so I think it's probably meets the relevant standard. The lack of fishing expedition, we can't get this material anywhere else. This is something that is important to make sure the cross-examination is appropriate and can be proven up. So I think my good faith basis kind of comes from being able to prove it up. And that's one way I can do that. I always have in mind, Judge.
Again, the balls and strikes that I'm being asked to call in this narrow instance under Rule 17 is keeping in mind that you're asking for me to order production of records, of employment records. Again, I'm not seeing how that has any materiality or relevance to what his state of mind was, Mr. Aylaian's state of mind was at the time of this incident.
Well, I think you gave me my answer. When, maybe there is something in there just right up against this incident. Maybe he was under monitoring. Maybe he was reprimanded for coming in smelling like marijuana. Maybe he, had some marijuana at the fire department. We have to look at the records. I don't have a magic wand when I say, exactly what they might have, but I can point to relevancy and materiality and lack of fishing expedition by saying we have 200-something instances of him doing it over a few months. That creates the likelihood that there's some overlap with work. And then, so then we have town policies, and then there's also another law, Judge, that's Chapter 40, Section 101A. It prohibits hiring of firefighters who smoke for pension purposes. The Commonwealth doesn't want to get into smoke or firemen.
Mr. Brady, all of these statutes that, again, I don't take issue at all with. I asked that rhetorical question to start with, but I don't take issue at all with the notion that marijuana can, and especially something that's smoked off, it can affect someone's ability to perceive and then relate what they saw and heard on the stand. It's the idea of getting records that you are fishing for, arguably. No, because hold on. Okay. Again, I'm constrained because the case law says that this is not to be used as a discovery tool. Now, let me say this: I've been there before, and I know that you're between a rock and a hard place because you have some information, like you do, about the possibility that they'll be in the records, but the SJC has made it clear that they need more, I believe.
So you're the judge, and I respect your ruling, but I should just say...
Well, I haven't ruled yet, so
I appreciate it. My thought is that whole business about it not being a fishing expedition, I think that what they mean there is that you can't be held, the defense can't be held to the standard of knowing what the other people have without getting to it. It would be easy if we could say, I know they have 16 reports from 16 days that he showed up smelling like marijuana and stumbling around. But, that's never the case because this is adversarial litigation. And so we don't know, and we never do know. So the courts can't put the defense in this catch-22. We have to ask for the records, and it can't be a situation where you have a time machine, you have a magic wand, whatever you want to call it. We don't know. Defense counsels never know, and that it can't mean that Rule 17 means nothing. So you have to interpret this fishing expedition thing as meaning just completely throwing darts. And so what I'd answer to say why we don't have a fishing expedition here is because, excuse me, we have this incredible number of video documentation. And we know that he's a full-time firefighter in the town. And so the likelihood of an overlap is pretty substantial. So that's really all we have. And that's all the defense counsel can ever have, is kind of skirting around the edges. And
in fact, arguably, you have more than we often see, right?
I think so. I think so, Judge. So, this is just, this is asking for records that will potentially be able to give me the ability to prove up a denial, I think, if you will. And, who knows what he's going to say? I don't know, because he's an adversary. So I'm just trying to get the record as populated as possible. And if I have information, I'll know the parameters of what he's saying is truthful and what is not truthful. And I think it would make for a better cross-examination and a more economic cross-examination if I'm not dancing all around without the benefit of these records. So that would be my argument, Judge. Thank you.
Well, I think I just echo much of what you said, and so I hate to do that, and echo what he said. He said, maybe, we don't know. That's the definition of a fishing expedition. That's the definition of a discovery tool, and that's what he's looking for, and he admitted it. He has a basis to ask that question. He could ask the witness on the stand, were you under the influence, or had you smoked, or anything like that. He has a good faith basis to do that. I wouldn't object to that question. I think it's a fair question based on the landscape that we have here. And the answer is what the answer is. And that's often the case. So I would suggest to you he has not met his burden, and the court should deny the motion.
Mr. Bridge, anything else?
No, Your Honor. Thank you.
No, on that.
No, that's all I have for that, yes.
So I'm going to issue a more formal ruling later, but the motion is denied because the defendant has not met her threshold requirement under the Lampron protocol. And as I said, I'll be more specific in my written ruling later. All right, now that moves us to all right, so I thought we would then go to the defendant's motion in limine, which has various requests. Let me just get it from the paper 67. Now, I meant to point this out even before we started on the Rule 17 motions, but I think it's worth saying. So, Mr. Gubitosi, at the last hearing, you said this is something to the effect, and probably more eloquently than I can remember, but something to the effect of that this is a very simple case, straightforward about what happened in the bedroom. And I'm glad to see that the defense seems to agree, because in this particular motion, Mr. Bradle, you wrote, the narrow issue here is whether Ms. Fitzsimmons committed an assault with a dangerous weapon against Patrick Noonan on June 30, 2025 in the bedroom, et cetera, et cetera. So I point out that you folks agree. So that's my thinking here in trying to keep things simple when I'm addressing all of your motions and your trial motions and your requests. So I agree that we at least have an agreement on a starting place. But let me hear you, let me ask the Commonwealth on the defendant's motion. So, as for sequestration, So let me say this. I typically don't issue secret restoration orders like formally. In other words, I would, and I'll ask the Commonwealth, I would just rely on if there's an order in place for you folks, both sides, to tell your witnesses that how it works. So does the Commonwealth object to a reciprocal sequestration? In other words, yes. Okay. So I'm going to allow the request that the trial witnesses be sequestered as that term is used in your motion, and it will apply to both sides. So I would, you'll be responsible in conveying to your witnesses that particular order, that they're not going to discuss their testimony with other witnesses. All right, and on number 2, the opinion terms. So I almost always use people's names, their surname. It's very possible, if not probable, that I would use a term like alleged victim, who I believe would theoretically be, not theoretically, would be Officer Noonan. Thoughts?
The Commonwealth has no objection to number 2, so long as it also is binding on defense counsel.
Meaning what?
He also will refer to anyone as victim, suspect, target.
Right. So are both sides okay with alleged victim? Yes.
Of course, yes.
Okay. All right. So I'll allow that, and I'll write this up later so that we're not. And number 3 is basically a motion to preclude prior bad acts or other acts. And let me say this: it probably makes sense to hold off on this because I view this as an opposition to a couple of the Commonwealth's motions, I think. So just remind me straight on and circle back if I haven't addressed everything. Certainly. In there. Number 4 is voir dire. Let me hold off on that for a moment because the Commonwealth also has voir dire, proposed voir dire. But let's go to number 5, which is the last. So number 5 is that the court exclude. There's a lot there. Commonwealth.
I mean, I think most of it is not really applicable to the facts of this case. So insofar as, the defendant is known to other members of the North Andover Police Department because she was a North Andover police officer, I think that's kind of unavoidable.
They're not a repeat offender. That's what I'm.
Certainly not a repeat offender. Okay. And I think the defendant never fled anywhere. She was never a target of any broader investigation. So I think as this is somewhat boilerplate, it doesn't really apply to the case. So there's no objection.
All right. So that will be marked as allowed objection. And we really should at some point talk about, and this may arise during the hearing on one of your Commonwealth's motions, but talk about the scope of what the evidence will be as it relates to this 209A work, right? And I think we need to flesh that out, or maybe it doesn't need to be fleshed out. But we'll get to that in a moment. So that leaves paragraph 4 in the defendant's motion, which is request for voir dire. And while I'm addressing the defendant's request for voir dire questions of jurors, let me get the Commonwealth's out. Paper 63 is the Commonwealth's request for jury questions. So let's just go back for a moment. As I said, I intend to handle this impanelment like I do all impanelments, and that is to use a case-specific juror questionnaire in addition to the single-page questionnaire that the jury commissioner issues with the summons. So my philosophy is, and also you folks will have, we will conduct an individual voir dire of every juror, whether they answer yes to question any of the questions or not. You folks will have permission to ask reasonable questions as part of attorney-conducted voir dire. My philosophy is to put as much of the questions you folks think are relevant in the questionnaire, so that it just will speed up the process. Obviously, you'll have your own things that you'll want to maybe ask personally, which means that the questions have to be formulated in a yes or no, in a manner that calls for a yes or no answer. So when I look at the defendant's request, I mean, I definitely can include something like A and B, C, mental health issues in general, and yeah, D will be in there, E will be in there. Yeah, F I don't ask. I'm not saying that you can't, but same thing with G. I mean, there's obviously versions of F and G when they're asked whether they can obey the idea of the presumption of innocence and reasonable doubt, etc. Same thing with H and I and J. So all of those things are kind of covered, but you'll be free to ask follow-up questions or questions that pertain to that. Now, so on the K, I'll formulate something. Does it make sense to have some kind of question related to groups such as, I don't know if this is still pertinent, this is from years ago, fathers' rights groups, groups that may advocate for Second Amendment issues. I don't know, things of that nature. They could be grouped together, but I think K is just too broad. So I'd be amenable to, again, asking for, if they've ever, if a juror, potential juror has ever donated to or volunteered for a domestic violence related organization, or if that's what folks think, or some kind of a shared parenting organization related to that.
Yes, I think we should do something like that. I trust your judgment to formulate that. Same.
Okay, so on the Commonwealth's and paper 63, I think I cover almost all of this, at least on the first page, second page. So it does make sense to ask about, as the defense requested, suicide, mental health, in general, postpartum, even. I can formulate some questions related to that. Training and experience with mental health issues. I don't know, is mental health going to be a issue? Well, it's going to come up at some point, right? Even on a limited basis.
I think it's going to be very tangential. I think it's really more about, and actually, my brother and I just hatched out an agreement that the way that this was served, as they all are, is without an affidavit. It was just served. The order was served, and I think we have a stipulation that we can just admit what was served, the restraining order, and the terms of the restraining order are what we both, literally we just discussed this, what we both are interested in utilizing. So I think that will probably cover the issues that we both are concerned about without opening too many doors on either side.
So I guess the question is, do you think I should stay away from 8, 9, and 10? 10 and 11, or do you, that being on the Commonwealth's request, or do you think that those things are worth asking about?
So I have an objection to 8, 9, and 10 because I think it's kind of suggesting things that aren't going to come up. You know, mental health disorders, I don't think that's really going to be something that's going to be discussed at this trial.
But you folks are asking about suicide, so wouldn't that beg the question? I mean, obviously there's many reasons for that people commit suicide.
Not necessarily. You know, I don't want to invite some sort of wide-ranging exploration of, you know, Ms. Fitzsimmons' medical history. Not to suggest there really is anything that's, you know, awful. I mean, we have postpartum depression. Whether that becomes an issue in this case, I don't expect so. I think she was served with an order that did 4 incredible things to her life and would do 4 incredible things to anybody's psyche. She lost her 4-month-old child completely out of the blue. She's home with her baby in sweatpants having fun. She loses her 4-month-old child. She's betrayed by her fiancé. Her marriage is over, ain't gonna happen necessarily, and you can picture her sort of almost having this realization. Her job's over, her guns are gone. Again, she just got them back. There was a 100-page report clearing her of anything and putting her back at work. She was going on a schedule in 3 or 4 days. And the other thing is that she was completely humiliated in front of her own work friends and colleagues. So I don't think we need to really go to dig up any sort of diagnoses, especially something as common and, you know, expected in a woman as postpartum depression as a reason for wanting to just end it all in a brief, half-hearted minute.
Okay. So the bottom line is you object, the defendant objects to 8, 9, 10. How about 11? Just the training related to mental health.
That one, we're okay with that.
All right, so 8 to 10. So let's just take them a bit at a time. Commonwealth, from your perspective, as to 8, 9, and 10.
Obviously, we cannot predict how the trial is going to proceed. However, based on counsel's representations here and prior public representations, it seems like the defense is going to be that, based on the confluence of those 4 factors, the defendant claims that she was attempting a suicide attempt. I don't know how you divorce suicide from mental health issues. I think that the two are one and the same. When someone hears suicide, particularly in a jury pool, they're going to think mental health. I think it's going to come up that why did Justin have it? It's not guaranteed to come up, but the fact of the 209A order suggests that there was a reason why a neutral magistrate determined that Mr. Aylaian should have custody of the child. So I think mental health is an integral part of the case. The Commonwealth is not shying away from that. I think that we need to ask the jury about it because depending on how this trial goes, it could be very narrow. It could be a 1-day long trial. It could be much longer depending on how things go. So I think we need to really probe the jury and find out any biases that they may or may not have with respect to mental health in general.
Okay, mental health is an easier concept broadly because it's been raised somewhat by the suicide request by the defendant, but as for specifics related to postpartum, so does the Commonwealth believe just in your case in chief that would somehow come out?
No, but I mean, there are signs outside talking about postpartum depression is not a crime. So it would be.
And in the end, how come I remember? I'm surprised that this, Mr. Grado, the postpartum depression is controversial from the defendant's end because I thought I read it in some submission somewhere that was a fact from your perspective, right?
So as we're evolving kind of towards trial, Your Honor, you know, it occurs to me that the case is really doesn't matter much about why the person got an order, what was going on with these people. The police are serving an order. That's their legal duty. It doesn't matter what the order says or how it was gotten or whether it's based on truthful information or fraudulent information. They have a duty to serve an order.
Okay, but let me ask you. Tell me the facts about the service, the actual service of the order, and that is that does the Commonwealth believe that the evidence will be that the defendant read the order and understood it before, in other words, processed it somehow and before the shoot?
Yes,
Okay.
You process the order, not the affidavit.
Because the affidavit wasn't there. All right. So Mr. Brado, presumably, and you said this, is that your client's state of mind is significant, right? Because she has to have intent, right? And there was some mention in some filings about perhaps she was pointing the gun at herself. You asked about the suicide attempt. So I'm failing to see how just asking a question about postpartum depression somehow prejudices the defendant.
My thought
I'm not suggesting that it would be admissible or not. It's just a question.
Right. I mean, I'm concerned about the degree of disclosure, and I feel like, the second it gets mentioned that the government's going to allege that we've opened the door to something and that all of her prior incidents are relevant and now they have to come in about postpartum depression. So, where I have an order that did those things that I just recited a few minutes ago, I don't really think that, we don't even gild the lily here on, and on top of that, she has a bit of postpartum depression. How far do I have to go? Those things that I said are eye-popping. To have that happen to anybody out of the blue on a nice summer day when you're home with your baby.
Especially if they're suffering from mental health.
I agree. I agree, but I don't want to open the door. And if
you're not, so let's be clear.
Okay.
We still need to drill down on, at least I think we do, on what is admissible broadly in this area. All I'm addressing right now is the simple yes or no question related to postpartum depression, and that is whether they have any experience. I could use something similar to Ms. Moriarty. Were you in the Brito case? Where there was a significant mental health issue or issues, and it would just be yes or no. It's not. I would never say there'll be evidence that the defendant. No, it's just their experience with that.
You're giving me a comfort level, Judge, and I'm okay.
Okay, but the other thing too is just understand this: is that I'm going to take the information that we gleaned, that we discuss now, put it in a draft of a questionnaire that we'll go over before it's disseminated, and you'll have an opportunity to see exactly what it is I'm asking. I was hoping that would be today, before they're disseminated. Before I forget, while we're talking about, so give me an opportunity to put that in there.
I'm okay with it, and just give me a comfort level, Judge.
Okay. You don't need to be comfortable. All you have to be comfortable is that it's going to be in the draft, and you'll have an opportunity to see exactly what I want to ask, and that's for all of these questions. But can I hate to float around, but one of the issues I have is related to the draft of the juror questionnaire. Is I think that there's obviously media attention to this case. There's public attention. The public and the media have a right to and the defendant to a public and fair trial. I'm concerned about having a draft of the juror questionnaire getting out there by mistake or et cetera. So I'd be inclined to simply impound it, disseminate it for your eyes only, obviously provide show to your client, and just impound it until we get to And then we can talk about what we do with the final one as well. Any objections to that from either side?
No, I think it's a great idea.
Okay. All right. So that's the way Mr. Aylaian just have to remember that's the way we'll handle that. All right. So I think that does that cover everything. I think firearms related questions in Second Amendment type of stuff that I typically ask in a firearm possession case would be pertinent. Again, why don't you folks just with an open mind take a look at what I write, what I draft, and you can object or take it out. Let me just look at the rest of this. Yeah, all of the rest of the questions would be included.
Your Honor, if I may add one that was not written.
Sure.
If you are going to reference, at least how defense counsel has it phrased, there may be references to suicide attempt. I think that is a way that gets the jury comfortable with the defendant's theory of the case. The Commonwealth would ask if that's the way it's phrased.
No, I'm shaking my head because it's not going. It won't be phrased like that. At least initially, when I drafted it, I think that all of these questions have to be neutral. They have to be used from both sides, in fairness. But more importantly, again, it's not. I don't like asking questions that are case specific. The evidence may show because it may not. So the issue is whether they have a personal experience with suicide. All right. Again, from the defense perspective, and that's what they'll be asked, something like that.
I would just like to raise the point of suicide suggests that the person committed the violent act themselves. The Commonwealth, one of the Commonwealth theories, may be that it was an intended suicide by cop. So that.
Oh, okay.
So I just think that if Your Honor can consider that when drafting your jury questions.
Oh, so in other words, you'd like to perhaps a question that would cover so-called suicide by cop?
Yes, sir.
All right, so
thank you.
I'm not sure that I'm that creative. I'll have the ability to artfully draft something like that, but we'll put a placeholder in there. I'll do the best I can, and then you folks will.
Just to chime in on that, sure. I'm not crazy about that because it's too specific, too suggestive, and it just adopts the Commonwealth theories. So I think the topical reference should be where it begins and ends. Just put my position.
Okay, so it seems to me that they're going to be asked, like in any serious case, whether they or a person close to them have been a victim of a violent crime. So typically I ask that, maybe, or been accused of perpetrating a violent crime. Maybe it needs to be shooting related, that question, or firearm related or something. But again, I'll draft a few questions that I think are appropriate. You folks will weigh in and we'll hammer them out. Anything else just generally on voir dire? On the jury questionnaire? Nothing. And then, all right, what else did I want to say about I have to tell you, from my perspective, you folks tell me you know your case better than I do. I think that the impanelment will take 2 to 3 times as long as the trial. I'd really urge you folks from taking a look you probably have at the rules of professional conduct as it relate to trial publicity, and just do your best to make sure that we can get from the start a pool of potential jurors that are indifferent to the extent that we're able to. But I hope I'm wrong, but I really think that the panel will get 14. I don't know. Anyone disagree?
I think that just depends on what he potentially opens the door to. So.
really understanding that, but I'm not sure that I need to. Let me talk a little bit about scheduling. So I'm going to assume that we start handling on the 23rd. We get jurors here in Lawrence on Monday, Tuesday, Wednesday, Thursday. We get the most jurors on Monday, and then the amount that we get are less than each day. I think that we should assume that it will take through Thursday, and that the trial, I should tell the jurors, perhaps even in the questionnaire, that the trial would start on Friday or even the following Monday. I know you tell me.
We can think about that only because we only get 6 challenges each. So that sometimes makes a difference. I understand other challenges that we will be dealing with, obviously, as far as people knowing about the case and reading about the case and the like. But
let me raise the number of challenges because I got to get my water from you because the last handful of trials I've been like felonies where folks get more. But my memory is that on the criminal side you get 4 and 1 extra if there's going to be seat extras, any extra seated jurors. Frankly, whatever the rule says, I'm going to give you. I know. Counsel oftentimes tell me, well, in Essex County, judges typically do X amount. I don't care. Whatever the rule is, and I don't have it in front of me. I think it's 5.
But we were just talking. I thought it was 4, and then a challenge for each extra juror.
Of course,
each alternate juror. So
all right. I don't have my but whatever we'll all research.
I agree with that, Judge. And then if there are 2 alternates, we get 2 more. So there's typically 6.
I don't think that's
whatever you want.
I don't think the rule. I think the rule is for any that are over and above the 12, you get 1 more when it's not a light challenge. But again, it will be 5 or 6. We'll figure that out. I need to tell the jurors the start date, and I also need to tell the jurors an expected end date for them to get that, when they'll get the case. So what I was going to propose is that they be told that the trial would start again on the actual trial, the evidence would start on that Friday or even the following Monday, and that they would get the case by the following Friday, April 3rd, which is over estimating the length of the trial on purpose, so that we have built the time.
Sure, I think we have lots of them going away. I totally agree with you. I don't know if it's going to take that many days. Maybe I'm being naive to find a jury.
Okay.
So, but we maybe see where it goes. I mean, I think maybe we say we start on Thursday. And you think about the day.
Okay. Yeah, we can even tell them that we'll start on Wednesday or something. And see. I'm surprised. But don't be surprised when you get a draft of the juror questionnaire that it says that I estimate that the jury will get the case to begin their deliberations. I'm just going to probably just default to April 3rd, which is Friday, because then in the next sentence I'll say that therefore you should be available to serve the following week in case it lasts longer. All right. So let's talk about. In this meeting, we have more motions which we'll address, and this may be the subject of. Let's talk from the Commonwealth's perspective. I'm trying to get a handle on what exactly the evidence will be related to the purpose of the police being there, how much you expect to get in during your case in chief about this custody issue that was ordered, etc.
Well, the underlying facts that I expect to come out is that a restraining order was sought. Mr. Aylaian was at the PD. He gave the restraining order to the officers. 3 officers went over to the house. He stayed back until they called him to come get the child. They called him. He went. Was in the process of gathering things. The officers went upstairs after serving the restraining order and explaining what was happening to the defendant. The shooting occurred. The end. So I don't anticipate getting into more than, or the jury really hearing more than that in the Commonwealth's case in chief.
Okay.
Subject to any of the motions that we have filed.
So maybe it makes sense to let's start with Paper 61 because this kind of segues into that, and that is the Commonwealth's motion to eliminate to prohibit questions regarding custody status. And actually, when you say custody status, you mean both the child custody and the pretrial detention aspect.
I do actually.
Okay. All right. So let me first, before I hear from you, Ms. Morali, is there an objection to either one of these items in Paper 61?
We don't expect to be employing anything down that road about custody.
About either custody, about the custody issue related to the child, and about their client's detention?
Only to the extent of the contents of the order that's being put in front of her, and that to the extent that it's just an obvious part of the whole thing is that she's packing the bag for her baby, she's giving the baby to the police to give to the father. Just what's in the order. I think we're probably in good shape on that in the sense that we're both agreeing we're going to stipulate to the order. I think as an exhibit, and the order says what it says, and we're going to both use what it says on the order.
Okay.
So I think that's the extent. That's the extent that I.
All right. So obviously, you can argue and question witnesses based on reasonable inferences from the order, but doesn't the order mention custody, temporary custody? Do you folks have? Is there a copy of the order? And I thought I saw it in the file.
So I think just the custody post June 30th, 2025. So insofar as the child is still with Mr. Aylaian, I don't see how that's relevant. That was really so the fact we're not disputing the fact of the matter is the 209A order granted Mr. Aylaian custody of the child that day. We just didn't want there to be additional on direct or cross of any witness, the current custody status of the child.
Okay. I can't imagine you want that.
We don't.
Okay. All right. So, and then do you anticipate, Mr. Bradel, that you would raise your client's pretrial detention status?
No.
All right. So then it seems to me that I can allow without objection, as it is narrowly tailored. All right. So just. Paper 62, Commonwealth's motion in limine to preclude questioning regarding current duty status. So let me be more specific. My understanding is that Commonwealth is seeking to preclude evidence regarding the Officer Noonan's now current status with the North Andover Police Department?
Yes.
And what is the status?
The Commonwealth's understanding is that he is on leave.
All right. So you would want to preclude any mention about that Officer Noonan is on leave?
Yes.
Okay. What do you say, Mr. Bradel?
Judge, I think that we're just talking here about perhaps putting this in abeyance until we get the IAD files, because we have a lot of information that I think I think we have more information than the Commonwealth, frankly, about his status, that it may direct this debate in a better way.
Yeah, maybe I just defer ruling.
I think that makes sense, and we can address all the issues kind of simultaneously.
Okay. So that brings us to paper 64, defendant, Commonwealth's motion in limine to admit prior bad acts if they become relevant. There's also some good acts on another motion, but go ahead.
With respect to the prior bad acts evidence, Your Honor, as captioned, the Commonwealth recognizes that those are not relevant to the Commonwealth's case in chief. However, in abundance of caution, the Commonwealth wanted to alert the court to evidence it had in its possession about prior bad acts in case they do become relevant based on opening, cross, or the defendant's case. So we can really hold those aside for now, but the Commonwealth just wanted to alert the court. And obviously, if the Commonwealth believed that a door was open, we would come up to sidebar before any questioning related to any of these issues.
Okay, so, and I appreciate that you're being careful. So the bottom line is you're not seeking, the Commonwealth is not seeking at this moment to admit other acts, but you may argue, as either side would argue during the course of the trial, if it arises that the door has been opened, and we'll have to address it at that time.
Yes, sir.
All right, so I'm not going to take any action on it. No, that's easy. It will be deferred until it's necessary, which brings us to paper 65. This is Commonwealth's motion in limine to preclude questioning regarding promises, rewards, or inducements. And I'll hear you comment on that.
And this is the subject that we touched on last time we were just concerning the request for a promise, reward, or inducement. And so I think we're kind of in a slippery slope, because if the counsel is able to ask the witness concerning post-event accusations, because these accusations that the defendant has made in unsworn statements and the like is going to muddy the waters. One thing that
but which accusations are you talking about? The accusations related to Mr. Aylaian allegedly breaking into the house, or the accusations about purported favorable treatment of officer? Remind me of his name.
I'm sorry. This is the alleged breaking and entering. And because it is post what we're talking about here, the Commonwealth has stated on the record we're not pursuing that, and we're not pursuing that. It's based on our prosecutorial discretion, but honestly, with our prosecutorial ethics. These are allegations that were made by the defendant in unsworn statements that the Commonwealth believes many of them are just false. Mr. Aylaian was a resident of that home.
All right, hold on.
Yep.
I'm hoping that we don't have to relitigate or even litigate for the first time the alleged conduct. The bottom line is the Commonwealth is seeking to preclude mention, Mr. Bradle, of the events of this breaking and entering. Okay, and do you object to that?
So I don't expect this trial to go down this side road. But to the extent, I don't think Aylaian really is a relevant witness in the case. Granted, he's on the premises, but he has marginal relevance. And I think that
it's kind of that's what Mr. Kubikosi said at the last hearing, but you didn't seem to agree. So maybe you rethought it.
He's a dangerous witness, I think, for both sides. Let's put it that way. And so it's a complicated scenario, Your Honor, that if he does testify, that opens cross-examination. That might open some other doors too. But, I mean, if it was me, I don't think I would call Mr. Aylaian, because it opens up all kinds of cans of worms, and he has testimony that's only duplicative of other people. And, you know, the fact that he's there on the premises, let's put that aside for a minute, that they let the guy who gets an order to have someone stay away from him, they bring him to that premises. Let's put that aside for a second. But it's sort of, he's like a straw man. There's nothing that he adds to the trial, and I'm going to cross-examine him, but I don't want to open up certain doors. So he's a very complicated witness. He's one of those kind of mistrial witnesses. So I don't know why they're calling him, frankly. But if they could, this is, I guess, my position. If they call him, then all bets are off.
So I can't imagine that you're asking me to preclude the Commonwealth from calling.
No, it's not.
The Commonwealth has a burden of proof, and they're going to, within the rules of law and evidence, they're entitled to try to prove their case, just as Ms. Fitzsimmons is. The issue is, do you intend to ask Mr. Aylaian, if he testifies, isn't it true, Mr. Aylaian, that on such and such July, whatever date, you busted down Ms. Fitzsimmons' door, went in and, you know, stole things and et cetera?
Yes.
Yeah, okay, you intend to ask that. And that's, again, understanding that some of this depends on what he says during direct, and I totally get that.
Yes.
But just from a 10,000-foot view, how is it relevant?
So he's getting special treatment from the government, Your Honor, and you know he's been coddled and protected by the government from before the service of this order. There's all sorts, and then talk about opening doors.
But why in using your theory where he's this background witness, why would the Commonwealth be motivated to do that? And when I say the Commonwealth, the Essex District Attorney's Office be motivated to give him special treatment?
He's in with the right people, Your Honor. We would be able to prove that he's in with the right people. I don't want to give you too much, but I hope you're satisfied with the direction that would go at this point. And he's in with the right people. They knew this was coming. Ms. Fitzsimmons was at the police station the morning of this event, being treated fine. Brought the baby to the police station, took a CPR class to refresh for her upcoming appearance on the duty schedule. She was treated wonderfully. She saw her friends. She did the training. She passed the training. She had the baby there. People are taking pictures with her. At the time, police administrative officials knew what Justin was doing that day. They knew he was going to do this. We have information, Your Honor, that when one of the gentlemen in the department said, "Oh wait, we got to give Kelsey her radio for July 4th," one of the administrative people said, "Oh no, just hold off on that. You don't know everything that's going on right now." They knew they were conspiring, to use the appropriate word. They were conspiring with Aylaian before this service for this whole thing. And there's an entirely other...
They were conspiring... Oh, I thought...
With Aylaian, too.
I thought you said Aylaian.
Yeah, I'm sorry, with Justin Aylaian. They were conspiring with him that he was going to go get this order, he was going to communicate with them, they're going to serve this order, and, you know, not to put too fine a point on it, but there were many people in that department that didn't want Ms. Fitzsimmons to go back to work. And this served the police department's ends as well, to blow her up by serving this order in a certain way. So you see where I'm going. There's a lot of doors here, Judge. There's a lot of doors.
The doors are easy from my perspective because it's about the rules of admissibility of evidence. So it seems to me that, again, the narrow issue here is whether you get to cross Mr. Aylaian on the fact that these facts related to his alleged breaking and entering, And from my perspective, it would only be relevant when you say special treatment is if somehow he's changed his story, right? So maybe some of this we'll have to hear his direct, but there would have to be some basis to cross him on it that he's somehow trying to curry favor by changing his story.
I think it also tends to explain the unorthodox manner of service of the order, Your Honor, in the sense that they let him go into the house. Okay, he's an adversarial litigant against the owner of that house. He just got an order against her. Keep her away from me, I'm scared of her. The police let him into her home. So there's all kinds of bias. There's all kinds of special treatment. You know,
I have to say this from my perspective again. That reading or listening, reading the transcripts of these calls that Mr. Aylaian was making to the North Andover Police Department, to say that he was in with the right people, maybe he was on one date, but he was pretty pissed off on the date he was calling, and why?
Because he wasn't used to getting this special treatment he always gotten, and it fits the story entirely.
Because during those calls, he's saying that repeatedly that he's going to take it to a higher level. Meaning, I think somebody even asked him, "What do you mean by that?" And he said, "Talking to the chief or something." And how he was complaining that the North Andover police failed to protect him. All right, so I'm not sure that we hear from the Commonwealth. I'm not sure.
A lot of that is just the tip of the iceberg, Your Honor.
I'm not sure that I can rule on this right now. You can tell what my present thinking is.
Sure, and I agree with that. I agree. He made a statement. His testimony is going to be unless the defendant opens the door, very limited as to the presentation I made a little earlier. If his testimony changes significantly because of that, then it may open up to something different. But having said that, the Commonwealth decided not to prosecute. We're not promising anything. We decided not to prosecute for a specific reason because we believe there isn't a basis to do that, a good faith basis to do that. I can't reiterate that enough, but having said that, what does any of this have to do as to what happened in the room up there? Because if counsel is up here 1 minute saying it should be very narrow, very short case about what happened in that room between Patrick Noonan and the defendant, and then all of a sudden wants to litigate a different case about the corruption of the North Andover Police Department, Mr. Aylaian's favorable treatment. Well, you can't have it both ways. It's either one or the other. And so that's what I'm a little nervous about now, is that, okay, we start this trial one way, and the representations have been made, and now we're taking it to a different place. And that's why the Commonwealth has filed that motion previously.
Okay, so here's the thing. I think where I come out is I have to defer ruling until I hear the direct, or if the Commonwealth were to otherwise open the door. So what I would say is just come to sidebar before you ask those questions, and because I don't, generally speaking, I express my view of it, but it wouldn't be fair of me to Ms. Simmons to completely preclude it without hearing the director any of the cases. So that's my ruling. It will be deferred until. Sure. Yeah, sure.
Can I just say, just in response to what my brother said, I was actually going to use that against him, that they can't have it both ways. If I'm going to call the witness, I get to cross-examine him.
I want to use that's why I tried to start the hearing with the agreement that I saw. That is that Mr. Gubitosi saying it was a simple case, Mr. Gradle saying the narrow issue here is it's a simple case, and I want to hold both sides to it.
I agree, and I just have a concern about opening doors, and I agree that it should be a simple case. I hope it's going to be a simple case. It should be a simple case. Judge, we're even thinking about making it simpler, and I know we still have to go with all this jury stuff. We talked about a possible bench trial. I don't know yet. I'm just saying, everything's on the table still. But,
you know, if they're going to call too many witnesses, I got to cross-examine too many witnesses. So, you know, it depends on where they're going to go with him. And, you know, he's going to have his comeuppance in family court, and I don't think I really want to get into it too much here. And if the Commonwealth wants to call him, it's going to happen to the extent you are lesson. Thank you.
Okay, all right. So I'm going to, on paper 65, I'm going to defer ruling until trial, really until after Mr. Aylaian testifies, and the defendant should come to sidebar before asking questions related to that. Let me ask on something that Mr. Brado just that I wanted to ask, but let's just march. I think we have one more motion. Commonwealth's motion to admit prior good acts. Yes.
Again, I think this would come up more in redirect than in direct of Patrick Noonan. So I would just ask to alert the court that this exists, and if we feel it becomes relevant, we'll have a sidebar prior to redirect.
Okay. So I'm going to defer on that as well. And let's just talk just generally. Do you folks, are there any exhibits that you folks think are going to be the subject of strenuous objections in litigation? And if there are, if you can let's just get out in front of them. All right. I'm sorry. Something that Mr. Brado just raised. I wanted to follow up on it. I just can't recall. We'll come to it. All right. So what that leaves is paper 73, which is that was filed this morning at the motion to modify the pretrial conditions. All right, so it's paper 73, defendant's request for change of address. All right, so let's just make sure that we're on the same page, Mr. Brado. And that is that you're seeking, there is an order in place now that the defendant reside at a particular address in Noonan, with Lauren and William Page. So you're seeking what?
So, Judge, can we put a sidebar on some of these issues, Judge?
Sure, absolutely. And if we're going to do that, Ms. Fitzsimmons is going to come up as well.
Thank you very much.
Thank you. Well, let me just go back just because we were at sidebar. The Commonwealth objects. This would mean changing the conditions to basically two conditions. One is to reside at a particular location in the Noonan, and second, to reside with Mr. and Mrs. Page. As far as I can see, those are the two conditions that this would impact. And Commonwealth objects to both. Does the Commonwealth object to both, or to one, or to all both?
Well, there was a long hearing and a long history to this case, and one of the conditions that the defendant was placed under was that she would specifically live, I don't care what house it is, but with her family, with her mother and her stepfather. There was a colloquy with her mom that she would take custody of her, and that she would oversee what she was doing, and that she would report to probation if there were any problems. Now she's asking to live on her own. which I think is a marked change to what we've been doing for the past few months. She, in her affidavit, it's basically.
Well, so in fairness, all I wanted was a yes or no. No, that's fine. Because I want to give Mr. Brady an opportunity to argue this motion before you. I just wanted to make sure that there is. So it seems like you oppose both, or is it more the supervisory role of the parents?
Well, which resident, if they could move the entire the family to another house, I don't care about that. Okay. You know, as long as probation is fine with it.
So, Mr. Brady, I'll have
Yes, Your Honor. Thank you very much. So, Your Honor, Ms. Fitzsimmons is a 28-year-old adult. She had this order at a different time in the case, and I'm not going to get into too much, okay? But this order was entered in very suspect circumstances, and I know what you're going to say.
No, it's just not helpful because. Let me ask, Commonwealth, are you objecting to me hearing this motion?
Well, I don't think there's any changed circumstances, so I am in that regard. Okay. So,
but the concept of me ruling on the motion in the sense of whether there's changed circumstances, you folks don't object to that. No. Okay. All right, go ahead.
So, Judge, she and there's actually another aspect to this that we're asking too that kind of go hand in hand, sure. And that is that we're asking also. I'm asking you to lift the restriction from the Superior Court, something I've never seen, where the Superior Court justice said that she can't go to family court and do anything. It doesn't matter what family court says about custody or visitation. The experts that do this, that's their core function.
Where does the order say that?
The order here is that she has to stay away from the child and that she, regardless of any probate court orders. I can't point it to you this very second, but it is in writing in one of...
No,
yeah.
It's here.
Okay.
I want to make sure that we're on the same starting point. Right. So we have a written motion at paper 73 for Jazz after the change of those other two.
Right.
Orally, you're moving to vacate the order, so much of the order that says, let me see, have no contact, direct or indirect, with own child.
And only to the extent to stay subject to deferring to probate court. So subject to probate court orders, that's all.
Well, there's also a restraining order out there that has never been challenged at this point. So,
but if in other words, if I were to vacate that and make it, she's already, Ms. Fitzsimmons is already ordered to obey all court orders.
I would leave that up to the court.
Okay.
As far as leave that to your discretion.
Okay. All right. So that's easy. I'm going to vacate so much of the pretrial conditions that requires no contact, indirect or direct, with the child. And again, only because since the passage of a long time, we now know, because the Commonwealth provided dockets, that there is ongoing, at least a case has been opened related to the well-being of the child in the probate and family court. They're the experts. But I want to say that all that this initially did when it was entered was essentially ordering her to comply with the restraining order, because the restraining order it wasn't Judge McCarthy, it was the probate court judge that had granted
the restraining order.
Right, okay. So I will vacate that.
Thank you. And I could just tell you, just so you know, Judge, the motion for temporary orders has been filed, and the hearing on that is 4-2. So it's probably after this trial.
Can I ask something more out of intellectual curiosity? The Commonwealth in your motion provided the docket entries of the custody parenting case, but it didn't mention, those docket entries didn't mention the restraining order at all. Is that because it was taken out under a different docket number?
Correct, Your Honor.
Okay.
It's a separate case. I actually represent Ms. Fitzsimmons on the restraining order in family court, and my colleague, Ms. Hess, represents her for the custody.
It's a completely different docket number. That's why I wasn't seeing it on the document. All right. So
and that date, Judge, just so you know, 4/14 is for the restraining order itself.
All right. So I'm going to vacate that, and Mr. Boyd, just remind me I need to. So you've docketed the orders the order of pretrial condition at 74 and this GPS at 75. So I'll need to just change those. But let me wait until I decide the other issue. Let me hear you on that.
Thank you, Judge. So Ms. Fitzsimmons is preparing to be able to offer the family court a viable, good situation for whatever custody visitation she can get. And she needs to do that in advance of the 4-2 and the 4-14 hearings, so that she can go to family court and say, you know, I now have a home, I have a good, you know, that's the first question the family court judge is going to say. Well, if I give you something, Ms. Fitzsimmons, where are you going to be? Where's the baby? And we want her to be able to say, not that I'm at my family home in my high school bedroom. I want to be able, for her to be able to say, I have a wonderful townhouse, plenty of room, fenced-in yard, great situation, and I'm ready to go, Your Honor. And you know, we'll also proffer Dr. Zeisel's report that we have here for you, that this is a good thing for her, that this is something that is consistent with her very bright future, that's something that is appropriate. You know, this was a 4-month-old child who's now a year-old child, over a year old, and that this needs to happen for so many reasons, Your Honor, that I won't get into, but she needs to have a situation that's ready. And I think we have expert clinical evidence to show that in the present circumstance, she's ready for that. And we were asking the court to get on that bus and help her in this sense, so that she's ready when this is over with. She's ready. She's in the best possible position she can be in to go to probate court just a week or two later with this in place. If it's not in place, God knows it's a nightmare scenario, Your Honor, because I'm sure you know the probate court dates are like, you know, they'll without batting an eye, they'll set up an August 8th, you know, and Ms. Fitzsimmons will be sitting here. August of what year? You know, that's a good point. So it's a very difficult scenario. We're just trying to get all of our ducks in a row as best we can, and this would be something that I don't think asks too much. And you know, she's agreeing, and you see in her letter and in my motion that she's saying, I don't want my lawyers to disturb any of this other stuff, you know, about house arrest and scram and, you know, the 2-hour notice, which we appreciate very much, to come see us. She doesn't want to disturb anything else. She just wants to change her address and live like a grown-up.
So can I ask something, Mr. Gradle, that so there was much litigation prior to my involvement related to the alcohol testing, smear testing. And why isn't alcohol use mentioned at all in Dr. Zeisel's report? I think in either of his reports.
So, because it's something that, and I'll give you my real answer.
That's all I want.
It's something that was imposed on her to stick it to her, to punish her, Your Honor. There's no alcohol whatsoever in this case. There's no pattern of anything. It's a total red herring, and it never should have happened. And I am furious about it. It is absolutely beyond the pale that she was tortured with that scram device, Your Honor, and I'm furious about it, so I'm sorry, but talk about, you know, you got me on that one. I'm furious about it. It's baseless, is my answer. Sorry.
All right, so leaving aside your argument about whether it's baseless or not, I mean, I can tell you that I've read all of the impounded documents that the judge relied on in fashioning the order, and alcohol was mentioned by Ms. Fitzsimmons' own friends that were at that. So now, let me say this.
At one party.
So my only point is that it's. So your position basically, actually, you answered it. You're basically, Dr. Zeisel didn't weigh in on it because he presumably doesn't think it's an issue.
And he's here, Judge, like I said, if you want to put him under oath and hear from him, I'm sure Dr. Zeisel will echo everything I'm saying about how there's no evidence, nothing's evident about any alcohol issue in terms of, you know, at a bachelorette party, a week or a few days earlier, whatever, fine. But as a basis for long-term, you know, monitoring is outrageous to me. And the only other thing in the record, Judge, talk about a reach, 2018 in like Myrtle Beach or something.
Yeah.
And that
this isn't helpful.
And that was expunged.
I realize that I kind of opened the door.
I'm sorry. He's here, Judge. If you want to hear from him, you can get some more evidence on it. You know, the alcohol issue really is not.
Nice to see you.
Thank you. I've been well. How about you?
I've been excellent.
That's great. I should say one last point, Judge, I think you're missing. Ms. Fitzsimmons was breastfeeding at this time. She's not drinking. She doesn't have an alcohol problem. She's raising her baby. She's a wonderful mom. And this whole thing is inferior. Sorry.
No, there's nothing to be sorry about, Mr. Grado. You're an advocate and a good advocate for your client. And the judge asked you and you answered. And when the judge asked you, then you didn't want to hear the answer. I get it. But the point is, really, in all seriousness, the point is you're not seeking to change the scram.
Right.
And so, can you just tell me, how does the scram work? Is it random or is it probation? Hi, how are you?
Good morning, Your Honor. Well, good afternoon.
Yeah, come on up. And you are again?
Alexander Hunt for probation.
I'm sorry?
Alexander Hunt.
Okay. And do you want to swear her?
Could you raise your right hand? Do you solemnly swear to make true answers to such questions put to you by the court or upon its directions, so help you God? Thank you.
I'm sorry, I don't think you've met before. Before this morning at the other hearing. Officer Hunt, are you supervising Ms. Fitzsimmons?
I'm not, Your Honor. It's P.O. Scrunchy in Salem.
Who is it?
P.O. Scrunchy.
How do you spell that?
SCRENCI.
All right, another officer that I'm not familiar with. So what is the report back? Has she been in compliance?
She has, Your Honor. She was 7 minutes late to curfew on March 10th, but she had informed Elmo ahead of time, and points show that she was stuck in traffic coming back from an attorney's appointment. She also missed 2 scram tests, but then passed the immediate on-demand test. So she's passed all her scram tests.
Okay.
So other than those minor incidences, she's been in full compliance.
And the scram, how does it work, or how is it working in this case? Are they random?
They are random.
Okay, so what happens? Does something go off on the device or something?
That's correct, Your Honor. A noise alerts her that a test needs to be taken, and then she has to take the test.
Okay. Is that something that, again, this is more intellectual curiosity because I haven't really had the opportunity to learn about how exactly the scram device works, but I think it's important for me to know because it's one of the more significant parts of the pre-proclamation work. But what happens for the notification? Is it the GPS monitoring bracelet that goes off that tells?
Those are separate, Your Honor, but Elmo supervises both of those.
Okay, so what happens, how does Ms. Fitzsimmons know that it's time to do a scram test?
It alerts her, a noise goes off.
So, and what is this device? The device is a breathalyzer or something?
Essentially, yes. Okay. Yes, Your Honor. There's a straw that she has to blow into. It takes her picture so it knows it's her. Okay. And that's how, and then via like Wi-Fi essentially. So
does that mean that she has to have that with her when?
At all times.
Okay, so when she leaves to go to doctor's appointments?
Yeah. So Judge, I got it right here. It leaves from 7 a.m. to 11 p.m. all the time, and she blows into it, and it took her months to be able to blow into it without a lot of pain, and she can do it now because her rib is healing up. Her rib was blown apart in this shooting, and she can breathe now, and she can do it. And it gets on her from 7 in the morning till 11 at night. And it also has a GPS component to it as well. So she's on double GPS.
Roughly, I know it's random, how many times a week do you know that it asks?
I'm not positive of Ms. Fitzsimmons, but I believe probably does around 50 tests every 2 weeks. I believe she has many random tests a day, as ordered.
Judge, I think it's for Ms. Fitzsimmons, I think it's about 4 times a day it goes on.
And pass for flying colors as far as we...
Correct, Your Honor.
All right, Mr. Brady, is there anything else on, anything else on Officer Hunt that I should know about her performance on pretrial conditions?
No, Your Honor, she's been in full compliance and in communication with probation.
All right, so she's been a great probation judge. I appreciate you inquiring about that on your own. And you know, it's just a step in the right direction for her. It's not a lot to ask. It's something that I know based on my interactions with her over the last 9-10 months, that you know, she's very motivated to not do anything in contravention of the court.
So what is actually, I'm not going to ask you this because I know what the answer is. Mr. Gubitosi here, or Ms. Moriarty, what was the purpose of ordering Ms. Fitzsimmons to be in a custody, or to, really doesn't say custody, to reside with Warren and William Page? Go ahead.
Well, I can't speak for Judge McCarthy, but I was there. This is not something that I agreed to, I encouraged, or anything like that.
Right.
It sounded like that because of the situation in its entirety, including the statement from her high school friend that she's had an alcohol problem and an aggression problem since then.
I saw that.
That the judge thought it was appropriate for the mother to monitor her, so she made sure she does everything, including making sure there's no weapons, no dangerous weapons, nothing in the house that would be considered dangerous. And so that is what Lauren Page, the mother, had sworn that she would do. And I think that answers your question as best as I can answer it.
Okay, and tell me about your objection.
My objection is, we're all glad she's doing well, but why are we going to mess with it at this point? We have a trial in 10 days, which is going to be a very stressful time in her life, I'm sure, that we're coming upon. There have been no change in circumstances to suggest that, no real change in circumstances to suggest that this is an appropriate reason to change anything or a time to change anything. I think all that could happen here is we mess something up and it messes with the trial date. Or she hurts herself, or she hurts someone else. That's what this is about. These conditions were put in place for a reason. I would suggest they were ultimately fair. I just don't understand why, if in her letter to the court.
By the way, Ms. Marie, did she sign that?
Yes. Okay. Her primary reason for this request is in preparation for my identification of my child. We're talking 2 weeks. 2 weeks from the time of today to basically, I mean, we could be finished if it's a streamlined trial. If it's not broke, let's not fix it.
Well, but from her perspective, it is broken. That's what she
said. In my perspective, and from the unbiased, really, look at this, it's not broke. She's doing everything the court has asked her to do, which she should be doing. And so, what's the changed circumstances at this point?
Mr. Vale, the changed circumstances.
I point to Dr. Zeisel's report, her letter, the passage of time, the fact that we're in a trial posture. It's sort of, maybe, why don't we analogize it to, when someone asks you to remand a guy from Pittsfield to Essex County House. It's like counsel for the Commonwealth is answering my own question, which is, it's a stressful time because she's in a difficult situation, and it's hard for her to prepare. If she has her own home, it's much easier. She can come and go. She has the whole place. She can focus on other things when she wants. It's just I don't want to make too much of it, Judge. She's just going to go to an appropriate home, and it helps her in her family court efforts. That, you know, like I said, I don't want to get pushed off months and months if we're not ready on that occasion. So,
I'm sorry, but
I'm alluding to what I mentioned earlier, Your Honor, about how on the 2nd and the 14th of April, we're going to be in family court, and I want to be able to say that she's been in her house for a couple of weeks. She has a great situation. She's been setting it up, and, you know, it'll just take a lot of the, you know, it'll uncap the tea kettle, and a lot of steam will escape here if she can just kind of be in her own place.
Right, but that wouldn't be grounds that would support my revising or modifying those two conditions. But I can say that I think the teachings of the SJC's cases under 58A often are that the passage of time can be a change of circumstance. And here, there is arguably a change of circumstance because Dr. Zeisel has said that her mental health has improved significantly, because my memory is that in the first report that Dr. Zeisel wrote that's in the file that's impounded, he did imply or mention that she didn't contest that she had been suffering from mental health concerns at the time.
Yes.
And directly afterwards. So I do see, I guess the long story short is I do see a sufficient change in circumstances. The question is whether the supervision by her parents is something that I would change on this record. And so does Ms. Fitzsimmons have an address in mind?
Yes, Judge. It's all set. Even the lease is signed.
When would she move?
As soon as you're ready, Judge. She has custody of the place. Whatever the work is, she's ready to go. And it's in Essex County. And certainly will give you the address, obviously.
Right. And she's amenable to having probation inspect the place prior to her move. Yes.
Yeah. Oh, absolutely. I think that's amenable.
And how about if I were to order visits to
no objection
to ensure compliance with the no weapons and et cetera.
No objection.
So, I'm sorry, Officer Hunt again. I'll come back up. So, tell me, if I were to order some kind of a visit by probation before the defendant were to move into the location to make sure that it is a place that, at least from what is observed, that doesn't have any weapons. To see what the words after. No weapons brought into home. So weapons being pretty broad. Is that something that the probation department can do?
Absolutely, Your Honor.
And how about, I know that home visits happen all the time when someone is on post-trial probation. Is it something that you folks see occasionally, at least on pretrial?
I'm aware of one case we've had where we have done it, so I believe it's possible, but I would like to double check with the supervisor. As for the home visit, that could be done. The initial home visit to check, we could do that by the end.
Is Officer Scrunchy available for, at least maybe even for you to communicate with about that aspect?
Yeah, I can contact her right now.
All right. So it seems to me that, and again, I don't want to go back and forth on this. I read all of what the original judge had before her, and all of these orders were well supported. They were orders that I would have issued at the time. They're orders that a single justice affirmed. They're orders that the SJC affirmed. I don't want to relitigate that, but I also believe that there's sufficient grounds to consider allowing the move and allowing the termination of the supervision, I guess, or the residing with the parents, so long as the probation department could monitor and it would be by surprise monitoring. Officer Hunt, I don't know if you heard that. So I'd want these visits to be a surprise.
That's no problem, Your Honor. I also just spoke with my supervisor, and she said as long as it's a court order, we can do it.
Either side want to be heard any further?
Judge, I just should say that her PO is aware of this request and it's been discussed. And I shouldn't say that she agrees with it. I just said that she's fine with it in the sense of whatever the court order, she's happy to implement.
Anything else, Kamala? Okay. I'm going to allow the change, subject to an inspection by the probation department prior to the move, Ms. Fitzsimmons' move being physical move into the new place. And the inspection will be for weapons and also alcohol. You may as well look for that. And it will be subject to inspections, random inspections by the probation department. I think what it may make sense at this point is for me, which would also mean that the GPS supervision conditions would need to be changed. I think it makes sense, Officer Hunt and counsel, for me to just issue a new order and rather than write on this, I would carry over all of the orders. No, you know what? I don't think it's necessary. Do you want to come to the sidebar of the address? Or is it something that you can provide?
I just provided to probation, Judge.
Yeah, but I need to keep sure. Everybody come on over to the sidebar, please.
Hey Nick, how you doing? Good to see you. Long time. Hope all is well. Thanks for the raid. Thanks for raiding in. Hope you're doing well. Are you familiar with this trial at all? Because we're wrapping our heads around it today. It's scheduled to start tomorrow. Fast forward here. Oh. Okay, here we go.
All right, so I am going to allow that modification for the reasons that I've already described, both open court and at sidebar. I need to just write it out. We'll impound the new address. I'd ask all counsel, as I said at sidebar, to continue to keep in mind that we want our jury pool to be as made up of as indifferent of a group of folks as we can, and that's what my expectation is going forward. All right, so I need to change that, which I'll do. Anything else, folks?
I filed another final certificate of compliance, so I'm expecting any moment counsel's reciprocal discovery.
So, when you say, is that something? So, is it something that I need to weigh in on, or are you just making a record?
Just making a record.
And I'm sorry, I missed it, Judge.
Mr. Gubertosi reported that he filed a final certificate of compliance under Rule 14, and that he's hopeful that...
I think we're there. There's a couple little things, but I'm not going to make any sure.
All right, so...
Thank you.
All right, but also I need, I appreciate the sending of the joint witness / prominent names list, but there's a bunch of names on there that don't have towns or cities associated with them.
Yes, as counsel said at sidebar, there's a safety concern in this case based on things that have happened, so I will get those to the court before the trial date.
All right. So, but how do we handle? I want to provide enough information for the potential jurors to look at that list and say whether they know a person or not.
We'll get a town.
Okay. And then, but are you suggesting that that be impounded?
No.
Okay. So, all right. So the missing, you folks will get. Will run down the missing cities and towns of the folks that don't have them on that list.
I have them, and I'll supply them to the court.
And Mr. Brado, given how close we are to the trial, when you said that something to the effect that there was a couple of little things that perhaps, the bottom line is, are you prepared now to disclose whatever it is that you're required to disclose?
Yes.
And I'd ask you to do that as soon as possible so we can keep the trial on schedule.
Sure.
All right, and let me just see if there's anything else on this, Mr. Wayne. In a perfect world, we reconvene to talk about the juror questionnaire. Could
We move the trial to a pretrial conference.
So are you folks, would you folks be available Monday afternoon? By then I've disseminated the draft of the juror questionnaire. That's all that we would go over. And you can appear by Zoom if that would be easier for you folks.
So if we're only doing the questionnaire, yes. That's fine.
Available, yes, sir.
Okay. All right. So in other words, no surprises from the Commonwealth.
No, I'm not expecting any.
Okay. I can't. We'll all be surprised if there's surprises. All right. So that means I have some work to do and get that out to you. Mr. Boyd, you have their email addresses.
Yeah. Judge, did you say 2 o'clock Monday?
Yeah, 2 o'clock. Whatever Mr. Boyd said.
Yeah.
All right. So I need to. I'm going to step off. I need to write up the change conditions, which I will do if you want to just hold tight.
Thank you.
2 p.m. This Monday is the 8th. All right. All right, so we'll stay at recess and see you then.
Court all rise.
That's it. All right, so that was the hearing from March 12th. So then the next one we're going to hear is where she asks for a bench trial. So that's going to be the next one. That's from the 18th. So that was just last week. So let's pop over to this. Like, who is that? Is that her dad, maybe? Do you guys know who that guy is? Do you know who that guy is? Let me know if you guys know who that guy is. All right, she seems pretty happy there for sure. That's what I was wondering. Is that her dad? I wonder if that's her dad. Hey, rock and roll, how are you? Because they kept showing him. They kept showing that guy. I'm just wondering if that's her father. Somebody she knows. Obviously. Think another attorney, Lori? Yeah, maybe is that like maybe her custody attorney, maybe? All right, I'm gonna end this and then let's go watch. Oh, and there's Aiden. There he is. That's Aiden, you guys, a.k.a. Turtle Boy. No, that's not her ex. No, she would not be, Debbie, she would not be giving hugs and kisses to her ex. So, her mom's in black. Okay. Kathy, that's her mom right in front of her? Okay, that makes sense. So okay, so you think that's her dad? So her mom's right in front of her. That's her mom. We're just trying to figure out who that guy is. Her stepdad. That's her stepdad, Kathy? Okay. That's her. She has a dad and stepdad. They are all close. Okay. Thanks, guys. Yeah, I didn't know any of that. So that's her mom and her stepdad, or that's her dad? Wait, hold on a second. Let me rewind this. All right. Those two people right there. That's her mom and her stepdad or her dad? Suit and tie is stepdad. Okay, so that's her stepdad and her mother. That's her dad and stepdad is... Okay. All right, hold on. Hold on. The tall guy is her dad. Okay, so that's her dad, mom and dad. Okay, so that's mom and dad. Okay. Purple tie is stepdad. Oh my God. All right. Shorter beardy guy is dad. Okay. Shorter beard. All right. Striped. All right, hold on. The guy in the purple tie is her dad. Barry's saying it's a stepdad. Granny's saying that's dad. All right. It's too confusing. All right, let's just land on that's her mom. Can we all agree that that's her mom? We'll just say that's her mom. All right, let's just agree. Purple tie is dad. Okay, purple tie is dad. Turtle Boy has a channel. He was very big in the Karen Reed, Debbie. He was huge with Karen Reed. And Mr. Bradle represents him. So Mr. Bradle represents him. That's probably why he's here. He's been doing all kinds of backstory on this case as well. So Turtle Boy's Aiden Kearney. He's been following this case for a long time, and he's got a channel. He was big with Karen Reed. All right. So in any event, that's her mom, either her dad or her stepdad. All right. So let's move on. All right, let's move on. Okay, so here is the hearing from the 18th, just a few days ago, last week. And this will be the last hearing we play, and then I've got a couple little news clips I want to play for you guys. We still have a few news clips, not a lot, but this is the bulk of it, of what we have today. All right, so this is from March 18th. This is March 18th. Hearing from March 18th, 2026. All right. So this is the one where she requests a bench trial. All right, so this is the one where she requests a bench trial.
I'm sorry, her name again?
Ms. Healy, Courtney Healy, Your Honor. Our paralegal.
Okay, yeah, that's fine.
Thank you so much.
Okay, so we're on to discuss the juror questionnaire, the draft of the juror questionnaire that I emailed you folks on Friday. I did have some preliminary questions. If you don't mind, I think these are fairly quick. So let me just ask about trial readiness. Are both sides ready to begin impanelment on Monday and then start the trial the morning after we get our 14th juror?
Yes.
Okay.
Judge, on that point, I don't want to waste a lot of the court's time. So just a suggestion is, could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end, Because we may not do it. It may be a moot point.
Okay. I actually, that's one, you're ahead of me on my agenda because I was going to, let me just skip to that item, right, what you're speaking about. So what I was going to say, mention to you is that I believe at the last hearing you mentioned, Mr. Bradle, the possibility of Ms. Fitzsimmons waiving her right to a jury trial.
Yes.
And what I was going to say to you, and we'll give you some time, we'll take a break and give you some time to talk about it, but what I was going to mention to you is that I really want to, it appears to me that the law, both the statute and the rule, give me some discretion as to whether I would grant the waiver. And the only reason I would, well, let me just tell you my thinking is I would like to do everything possible to avoid having to bring 70-ish jurors in on Monday if it's going to be a waiver. So what I was going to say to you is I would need a decision by Friday, but it sounds as though maybe you'll want to talk with your client about that even today. So we'll pause.
We were going to ask maybe for like 5 minutes and then...
when we get to that point, you'll take as much time as you need. All right, a couple other quick things. So the trial, we're trying to coordinate having the trial be held in courtroom 2 on the 2nd floor, just to accommodate more audience and media members than we can fit in this courtroom because, as an example, the camera that is set up is actually, I think, either in the jury box or just too close for comfort. So our hope is that the trial will occur, whether it's bench or jury, down in the courtroom number 2. We are still working on some logistics at our end, and you folks, especially the Commonwealth, may have some logistics that you'll need to go over with Mr. Wayne. If the logistics cannot be overcome, then they can't be overcome, but at least that would be my preference, is to have a bigger courtroom than a larger courtroom than is here. All right, so that's that. And also, I will need, if there's going to be a juror questionnaire, I'm still missing Dr. Zeisel's address, which used to be in Brookline, I'm assuming. Is he still in Brookline?
That's another development, Judge. We're actually not going to call Dr. Zeisel.
Okay, all right. But, so would his, well, we'll get to it later. I'll also need, when and if we get to it, I need an address for Charles DeChara. Is that Commonwealth's witness or the?
No, it's the defense put him on there, but I'm working on that actually, because
you're working on the address?
Yeah.
But the defense, it's a defense witness?
It was an independent investigation that was done by the North Andover police, and they created a report. Oh. I wasn't going to call him. He put him on the witness list. But I think I probably have better quote-unquote connections to get an address. So.
Yeah, just the town or the name of the business, something sooner than later. All right, so those were the only 2 items that I missed. And by the way, I did take out Ms. Fitzsimmons as being listed as a witness. So you're going to actually see on the next version that in order to save me having to renumber, I just put number 20 intentionally omitted. There's no reason to, and I know why you did it, both sides did it, but there's no reason to put Ms. Fitzsimmons. There's going to be plenty of questions about knowledge about Ms. Fitzsimmons and the case. That her name won't be necessary on there. A couple other questions. One is on the scram device. Is that probation?
Yes.
Yes. Hi, how are you?
Good.
Could you mind just stating your name for the record?
Yes, Your Honor. Probation Officer Tony Kidder.
Okay. And Officer Kidder, well, everyone, let me just think out loud for a moment. I'm concerned, or should I be concerned, that Ms. Fitzsimmons is going to be alerted during the trial to blow into a scram device? Yes.
Yes, Your Honor, I did speak to my supervisor in regards to the scram earlier this morning, and I was going to contact electronic monitoring to make did not go off during the time that she was in the courthouse.
Okay. All right. I just, I don't know what I don't know. And all I know about the scram device is what the probation officer at the last hearing told me about. So I just want to make sure, I'm sure that you folks are out in front of this, but let's just make sure that it's not visible to jurors and that she hasn't seen lugging it around or going into it in the courthouse. It's still a small courthouse, right? So if probation can do something to shut it off during the court proceedings, that would be great. Actually, better yet, during the time when Ms. Fitzsimmons will be near in this building, and again, near even coming from parking, I just don't want to take a chance that a juror is going to, a potential juror is going to see her blowing into the screen.
Yes, Your Honor, I will make sure.
All right. All right, and then last thing is, so I'm already thinking about jury instructions, whether it's jury instructions or whether it's instructions to myself. And so there's two theories of assault, right? Or two ways an assault can be committed. An attempted battery, threatened battery. Is this one, the other, or both? Or what is this? Both. Just that's all I wanted to know whether I needed to. Okay. So really, I don't have anything else. There is, Commonwealth filed a motion. So is that something that you want to do before we break? Does that make sense?
Yeah, the Commonwealth filed the motion to eliminate on Friday, I believe, or over the weekend, I'm sorry. The Commonwealth filed a motion to eliminate, seeking to admit a number of text messages between the defendant and her ex-fiancé, Mr. Aylaian. The text messages that we would seek to introduce span the day of the shooting, so just the day of...
I'm sorry, just let me interrupt, all right? So just setting it up for the record, so you're referring to paper 82, which is the Commonwealth's motion to eliminate to admit the defendant's text messages from the day of the assault. I did have some trouble reading them, but then I was given a better copy. But let me just ask, just yes or no, Mr. Bradle, is there an objection to the motion?
There is, right?
Okay, all right, so now I'll hear you. Thank you.
So the Commonwealth suggests that the one thing that I think everyone can agree upon in this case is that the defendant's state of mind on June 30th, 2025 is the most relevant issue before the jury. And what more insight into the defendant's state of mind on the question can we get than her text messages with Mr. Aylaian? I would suggest the Commonwealth is not seeking to admit over the weekend, over a period of time, but literally it is from the morning of June 30th through the afternoon, approximately sometime after 2 o'clock on June 30th. I would suggest that generally they're not particularly prejudicial, but they are relevant because they show that she is angry, upset, at times despondent, and clearly having a conflict with Mr. Aylaian, and this is prior to the service of the restraining order by the North Andover police.
So your theory is they show what? Anger? What else?
They show her state of mind.
No, I know that, but you gave me a laundry list of what the state of mind you say can be gleaned from these.
From a Commonwealth perspective, she's angry at Mr. Aylaian for not. Mr. Aylaian has clearly is not at the house, has separated from her for a period of time, and she is angry and is trying to get him to come back to the house and trying to reconcile. So I would suggest that that is consistent with the Commonwealth theory that this shooting happened when the defendant heard Mr. Aylaian in the house.
Shooting happened when?
The defendant raising her gun towards Patrick Noonan, and Patrick Noonan, in response, shooting the defendant happened at the time when Mr. Aylaian was in the house.
Okay, so I'm sorry, are you saying that it's the Commonwealth's theory that Ms. Fitzsimmons heard Mr. Aylaian in the house and then reacted to it, or?
That is one of the Commonwealth theories, yes. And I think the testimony would be something to the effect of the defendant said, keep him away from me.
Like in this exchange in the bedroom or near the bedroom or whatever?
Yes.
All right. I'm sorry, anything else?
No, I would suggest that it's certainly more probative than prejudicial if you just look at the text. There's nothing particularly outrageous in the text, but it does go to show her freedom.
So, and how would these be admitted? They'd be admitted in this format?
Yes.
Like just, and how are they, how did the Commonwealth obtain these?
The Commonwealth prepped Mr. Aylaian on Friday, and he provided them to the Commonwealth on Friday. So they'll be provided, they'll be authenticated through Mr. Aylaian. And he would explain that he received them on his phone, and that this is a fair and accurate depiction of the screenshots he took from his phone of the text messages he had that day with the defendant.
And is this all of the text messages that they exchanged on that day, or is this a portion of them?
No, that is from that day. That is all of them.
All right, and the other thing that if we can just flag it and we'll circle back, is that I provisionally impounded, so I was out on Monday when this was filed, I believe, and I provisionally impounded the motion and the exhibit being the text messages because I saw that Mr. Grado had requested it in an email or something, so I just want to, because it's provisional, I want to just discuss how we do that. All right, and all right, so let me hear from Mr. Grado.
Thank you very much. Judge, so evidence has to have a rational tendency to prove a proposition in the case and for relevancy, and it's not a rational connection to say that because Kelsey was supposedly mad at Justin on this day, that she's going to shoot her colleague from North Andover. It's like if I'm mad at Charlie from Mass Live for reporting, and then I run into the law girls later on, I'm not going to do anything bad to the law girls because I'm mad at Charlie.
You must be the law girl. I am not on social media or any of that. So don't assume I know who the folks are, but welcome. And you referred to another member of the media?
Yes. This is the law girls. They have their own blog. And it's just a rational thing. I mean, it's just, there's no, this just opens the door to the Justin stuff that is completely irrelevant to whether or not she assaulted Noonan in the bedroom when it was just the two of them. There's no relevance to it, to this charge, and there is prejudice, there is unfair prejudice to show that she's in a fight with her boyfriend. Nobody wants to be judged on that, Proposition A, when Proposition B is completely different that we're here for trial on. So I just don't see the connection. There's no, her state of mind about Justin is not her state of mind about Noonan. And there's just no possible rational tendency in terms of relevance that because she's mad at some totally different guy, that she's going to hurt her colleague and friend from work.
Well, here's the thing, is perhaps I need to do a analysis under Rule 403, but I mean, it's relevant in the sense that the Commonwealth has to prove intent. It is a general intent, and it's also relevant because I think that Ms. Fitzsimmons has put her state of mind somewhat at issue because there's information, at least that I've heard, that she wasn't, that if she had the gun, she didn't point it at the officer, she pointed it at herself because of her mental state. So wouldn't this be evidence, again, just not for the truth, but for just to show her mental state at the time of the incident?
So my strategy on that, and I'm happy to share it, is just that there's enough from the content of the restraining order that without having to open the door to mini trials about who was right between her and Justin, and what are they fighting about, and what's going on, and what are the details of that. She just received a restraining order that said, you know, as I said the other day, I won't go into it again, you know, all the things that order implied were horrible, tragic, and awful. And that prompted her to have a sad, brief moment of intent to self-harm. And thankfully it didn't happen.
Let me say this. I read these text messages, and I arguably thought that they helped you, frankly, because
sure.
I know that the Commonwealth sees anger in them, and yeah, I think it could show that, but
I agree.
But they also arguably show. It's what they don't discuss, I guess. I'll just leave it at that.
And that's my point, Judge, is that it's opening doors. It's like opening more doors about this when we're not intending on opening that door. And, you know, I don't want to have that thing where, oh, well, this helps us, but then that might hurt us, and then this might help us, and then we're having a mini trial about Justin versus Kelsey.
But Mr. Bradle, with all due respect, you folks put Mr. Aylaian front and center. Maybe you've changed your mind about that. It sounds like maybe in the last year and a half you have, which you have a right to do that, obviously, but he's been pretty prominent, and their relationship has been pretty prominent from the defense's perspective, from what I've heard, all right, and seen.
So if I can speak to that, I don't need to talk about it.
No, go ahead.
Sorry. So, Judge, we have to play both sides of that street because the government is pushing that. The government wanted to put, you saw that prior motion limited where they had these 4 things that are like, you know, this is judgment day for Kelsey's entire life. You know, the government wanted to open this case up to Justin and Kelsey and what happened in Maine and all this other stuff. You know, and I think the government's backed off of that. But the government started that fight, and I have to match it. I have to be ready if, out of an abundance of caution, if the government was going to go down that road, I got to be ready. So that's, you know, the Justin stuff has to be vetted, and I have to be ready if he's called and if he is a witness. You know, I have to be ready on both sides. My preference is that we have an economic trial here where, you know, the issue is Kelsey gets this restraining order full of horrible nightmares. She acts accordingly on it. The government puts their case in, we put our case in, and the fact finder decides. You know?
So, but don't these text messages help your client show that? Because I'm not, again, listen, the Commonwealth, you know your case, both sides. I only know what little I know from the file.
Sure.
But when I read these, yes, maybe there is anger, maybe you could say that, but there's also an absence of any concern for her mental well-being by Mr. Aylaian. Any comments made by Ms. Fitzsimmons that would lead one to believe that she was suffering emotionally at this time, which would so I guess that's part of the analysis of when I'm doing the 403 analysis is on the prejudice to the defendant. I'm not sure that I see a lot, but I can tell you this is that there is one passage in here that I thought I saw where he said something about her allegedly hitting him or something. And
it's on the first page, Your Honor. It's the 4th bubble on the right.
So I give you a proper on that. And so I appreciate what you're saying, Judge, about on its face, though, the general gist of those text messages would help in the sense of the distraught mindset. However, if that's where it sits, I can live with that in terms of but we'll talk about the hitting thing. But I'm looking at this like, I feel like the government's going to try to say that this opens more doors. And I don't want to go down this road of like going down, you know, Justin versus Kelsey and everything in Kelsey's past going back to 2 other ex-boyfriends. Like, that's where I want to guard against.
Commonwealth said 2 hearings ago, this is a simple case. You said at last hearing, and it will be a simple case, but it's still simple in the sense of what happened in the bedroom.
Right.
And it seems to me that what Ms. Fitzsimmons was thinking at the time is absolutely relevant, and then her state of mind in the hours leading up to it would be relevant too. And again, let me say this. I'm making an observation about what I say that they could arguably help the defense or hurt the Commonwealth, but that's only because, again, when I'm weighing the potential prejudice to the defendant and the probative value, that's all I'm really getting at under 403. So
Judge, if I could just invite the court to just focus on that one bubble about the hitting in terms of the 403. And that's really all I'd be concerned about. So there's more to the story, of course.
All right, so let me just, in Commonwealth, what would you say if that was redacted? So that bubble and just...
I just think the first sentence of that would be fine to redact, but I do think that the second sentence is not about what you can leave anymore. We need to be the best parents possible, and I cannot do that in the house at this time. I think that's relevant.
So, Mr. Brady, I don't know if you've heard that. So the Commonwealth is suggesting that... all right, so let me just back up. So my ruling is that the probative value of these, generally speaking, of the proposed exhibit outweighs any... really almost any potential prejudice to the defendant, except that the devil is in the details as to some of the content, and that one of those items being this particular passage where Mr. Aylaian is alleging that Ms. Fitzsimmons struck him in the face, even though she denies it right there in the response. So the Commonwealth is suggesting we simply just redact the first 2 sentences of the bubble of Mr. Aylaian's text about that.
Should that be agreeable to the defense? Thank you.
Okay. And so that would, and the rest of that would come in starting with, it is not about what you need anymore?
Yes, sir.
Okay. And if you folks remind me at the time that I can tell the jury that it's common that things are redacted or struck from items just in case it's somehow visible that in other words, if the jurors can glean that something's been removed, I'm happy at the request of either side to tell them why, which is basically I rule that it wasn't even missing.
And Judge, also while we're on these, I would waive the request for impoundment.
Okay, waive the request for impoundment.
Correct.
So let's talk about impoundment. What's the Commonwealth? I'm just concerned about jurors just knowing, but I don't know.
Your Honor, this is, I do not see a good faith reason for the Commonwealth to ask for this to be impounded, given the nature of what is in the public already.
Okay, all right. So both sides say it shouldn't be impounded, so I'm going to vacate the, and I'll do this, Mr. Brain, in an endorsement, but I'll vacate the provisional impoundment of that. What I'd like to do is this Commonwealth. So I have 2 versions. One's a vertical, and one's a horizontal. Is that right? Is that the way to explain it?
Yes,
so
I think the first version was too small really to be
So can we just give this back to you, and then you can shred it, and this will be this landscape, right? That's the landscape? Okay.
And that's exhibit 1 to
the landscape will be the official exhibit. It will, and it can be docketed in the normal course. Public, maybe, strike that, docketed to the public docket. All right. And I'll have to also endorse, I will endorse it that I'm allowing it subject to that revision. So just, And, all right, so do you folks want to take a break for a few moments? Okay, all right, we'll do that. Just let Mr. Ruiz know when you folks are.
All rise, please.
Thank you very much. Yeah. If I want to run. Okay.
Zoom through this while they take a little break.
Of course, this is a brief recess.
Oh, quite a long break.
We filed two things, Judge. We filed a waiver.
We're back on record on the matter of Commonwealth versus Kelsey Fitzsimmons. All counsel and the defendant are present.
Okay. Mr. Bradel?
Thank you, Your Honor. We filed two things, Judge. We filed a waiver of the right to a jury trial, and Attorney Coakley and Ms. Fitzsimmons are prepared to engage in a colloquy with you on that.
Okay.
And then the second thing we did file was a supplemental witness list that I explained to my brother a little bit. Some additional names. I would say most of it is probably abundance of caution stuff that probably they won't be called. There's one name on there that did warrant some explanation to counsel for Commonwealth, which I gave them, and I don't expect it to really add much to the trial.
All right, so let's table that, but I do want to, if the Commonwealth wants to be heard on these additional witnesses, absolutely.
No, I just, if I may put something on the record.
Sure.
As far as the jury waiver goes.
Well, before you do that, I was going to ask, all right, so we have a waiver. I was going to ask whether the Commonwealth takes a position, so you may...
My only position, well, I have no reservations with your ability to be fair and impartial in this case. In an abundance of caution, I wanted to create a record. At some point, I don't think it was last hearing or one of the press conferences the defense gave outside, a person asked about you, and Attorney Bradel told them and the world, I guess, that he worked together in the DA's office some time ago. And so I think there's a perception out there, for whatever it is, that the defendant had put out there. Like I said, I have no reservations, as is your ability to be fair and impartial, but I think I needed to create a record about that.
No, that's a very good point. So, I don't, let me say this. I said before when I was joking with our media representatives, I don't pay attention to social media. I'm not on social media purposely. I don't read or listen to or watch or whatever media accounts of what happens in cases that I preside over or that I potentially could be involved in. So I know nothing about that, but I think it does make sense for me to say a couple things related to that because it strikes me that I did discuss those things with you folks, but I did it at sidebar. All right, so I'll just state for the record that Mr. Bradel and I, all right, so we worked together, well, Mr. Bradel and I were in the same starting class of new assistant DAs in January of '95. Mr. Bradel, I have a picture of all of us, including Mr. Hagan, Judge Hagan, who like me back then had a lot more hair. So Mr. Pretrial and I were in that class, starting class together. My memory is that I was assigned ultimately after the class. I think we met for a couple of weeks. We were a training class. I was then assigned to Roxbury District Court and Mr. Bradel to Dorchester District Court. And so that was 95. I left the DA's office in 2001, and at that time I was the chief of the domestic violence unit, which was a superior court unit. So, Mr. Bradel, you can correct me. I don't think that we ever worked together in the sense of worked in the same courthouse, worked on the same trial team. I'm not sure I ever even had a beer together back then.
I agree, Judge. I don't recall one, and I think that I put you kind of in the same boat as Judge Deacon down in Middlesex, where we always had a respectful cordiality at work, but nothing past that. And I appeared in front of Judge Deacon, and never been a problem. And I left the office in 06, Your Honor, so I was there for 5 more years after you, and I haven't seen you in probably over a decade. And I think the comment that Commonwealth Counsel is referring to, I recall it as just sort of a generic comment that I thought your rulings were fair and that we appreciated your rulings, that I had known you a long time, something to that effect.
Yeah, I don't think that Mr. Gubitosi was objecting. You just want to make sure that this trial, I've always strived that all of proceedings, whether it's this case or other cases, that there's a level of transparency. And I think Mr. Gubitosi's point is well taken. So I think I've described on the record what the nature of our relationship was. I'm not, again, I can't say that we weren't friendly, but it seemed like I was maybe you're the crew of people that you more gravitated to were from the Dorchester District Court, and I was in the Roxbury District Court. But I'll also say this, is that for complete transparency, I know I had a murder trial years ago with Mr. Gubitosi. I found Archangel Morales, I don't know if you remember that, and I found working against you was you to be a really good prosecutor and really fair, and I respected you. I continue to respect you. That's what I was referring to at sidebar. I probably spent.
I was going to say maybe I'm not that memorable because we did 3 first.
We did?
Yes.
Who else?
I can't remember the name. One was with Ms. Ronan in front of Judge Lowy in Salem.
Oh wait, all right. So
and then there was another one here.
In front of Judge Welch. I wasn't counting the ones where you were second seating another. You were like second seating a more junior attorney, but I do remember one in which the 2 of you prosecutors beat me up pretty good. It was here in this courtroom. I had made a mistake and opened the door to something, and it was Mr. Gubitosi's fault, because all of a sudden that sidebar, you hadn't said 2 words during the trial, but raised the issue. But in any event, listen, I respect both of you folks. I said on the record, I don't know Ms. Coakley. I don't believe professionally. I think that you may have been the chief of a unit that in Middlesex at the same time that I was the chief of the domestic violence unit. I think we may have traveled in the same circles, though that would have been decades ago, but I don't think that you ever appeared before me. I don't think we ever had cases against each other. Again, I respect you as much as I know you, and in any event, I think that that's full disclosure. I'll also just say, as for Dr. Zeisel, you said Dr. Zeisel is not going to give you.
Correct.
Okay. So, because I think I already mentioned it, he was someone that I used and used often when I was in practice. So, but it's been years since I've seen him. All right. So, is that sufficient? Did I address? Okay. All right. And the bottom line is, I am confident that I can be fair and impartial. I would not accept the waiver, frankly, if I thought that there was some risk that some favoritism would potentially come into play, or if I thought that I couldn't divorce myself from information that may not be admitted at the trial. Okay, so I'm very good at compartmentalizing. I will only consider evidence that's admitted at the trial. All right, and then we'll talk about mechanics and all that afterwards. Let's go through the colloquy. I'd like to, before we have the colloquy, can I see counsel and Ms. Fitzsimmons at Sapphire?
All right, so now she has decided that she wants to do a bench trial. So they took the break, and obviously they talked to her over that break. And now she's going to do a colloquy of, I want a bench trial. I don't want a jury. Wow, this is long. So, yeah, interesting. I guess they talked about it after this whole. The last two hearings have been talking about jury instructions, how they're going to voir dire the jury, how long it's going to take, and they must have clearly they talked to her about that.
Okay. All right. Attorney Coakley, is Ms. Fitzsimmons ready to proceed with the colloquy of the waiver?
Yes, she is.
All right. Why don't you folks, why doesn't she take the witness stand? And we can pull a chair over for you, Ms. Attorney Coakley, if you'd like.
I can stand.
Please.
Ms. Fitzsimmons, could you raise your right hand? Do you solemnly swear to make true answers to such questions put to you by the court or upon its directions to help you God?
Yes. Okay. Good afternoon. You can have a seat.
Good afternoon, Your Honor.
You can put yourself right up to that mic. Okay. So as you know, I'm Jeff Karp, and I'm a judge here at the Superior Court. And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge. I need to just ask you some questions to make sure that you understand the right that you're giving up and that you're doing it voluntarily, okay? And that you know what the consequences are. Now, so I'm going to have a lot of questions for you. If at any time you don't understand something that I say to you, it's perfectly fine to interrupt me and tell me I don't understand. If at any time you'd like to take a break and speak with Attorney Coakley, we can give you that opportunity. We're in no rush here. It's very important that you understand all that I tell you. Yeah, okay? All right, so first thing I'd like to do is, where's the indictment, Mr. Boyne? Can I just grab that? So you understand that you're charged in a single indictment with the crime of assault by means of a dangerous weapon. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that, have you discussed with your attorneys what the Commonwealth needs to prove at the trial for that charge?
Yes, Your Honor.
Okay. And do you feel as though you understand what they've told you about that?
Yes, Your Honor.
And do you understand that that charge, assault by means of a dangerous weapon, carries up to 5 years in state prison if you're convicted?
Yes.
Okay. Attorney Coakley, either you or Attorney Bradle have gone over the elements of the charge with Ms. Fitzsimmons?
Yes, Your Honor, we have.
Okay. All right. So I need to just ask you some background questions, get some background information. Some of this I already know, but I still need to I need to ask you formally. So if you could state your full name.
Kelsey Fitzsimmons.
And how old are you?
I'm 29.
What is just your month and year of birth?
11/18, November 18.
And where were you born?
Concord, Mass.
How far did you go in school?
I got my bachelor's degree and I went to half of law school.
Okay. You went to what?
Half. I did
half of law school? That's enough. Was that enough for you?
No, I'm going to go back.
You're thinking about going back?
I am.
And you said you got a bachelor's degree in what?
In criminal justice.
Criminal justice, and where from?
Where am I from?
No, where did you get the
I'm sorry.
degree?
I'm nervous, I'm sorry. Fisher College in Boston.
Okay. All right, and totally understandable that you're nervous. All right, and again, some of this I know, but I have to ask, what are you can't be presently working, right? You're not working now.
No, you're not.
Right. And your last job was with?
Patrol officer with the North Andover Police Department.
Okay, and how long were you there? roughly?
About a year and a half, if you count the academy.
Okay. So you went to the police academy, and
yes.
Then what else? And just normal job duties as a patrol officer in North Andover?
Respond to 911 calls, emergencies, medical emergencies, calls for service in the town.
Okay. All right. And did you take any prescription medications, over-the-counter medications, or drugs in the last 24 hours?
Yes, I have.
Okay. And what have you taken in the last 24 hours?
In the last 24 hours, I've taken fluoxetine,
okay,
hydroxine,
okay,
and lorazepam.
All right. And do any of those medications, or have any of those medications affected your ability to understand the proceedings today here?
No, Your Honor.
All right. Did you consume any alcohol in the last 24 hours?
No, Your Honor.
And have you ever been treated for any mental health condition?
Yeah.
Okay.
Yes.
Do you feel as though that you're suffering from any mental health condition today? In other words, that like right now as we're going through this, that you're feeling some effect of any mental health condition?
No.
And do you feel as though your mind is clear today?
Yes, Your Honor.
And have you understood all that I've discussed in open court with the attorneys about, up to this point, about even like the motion to admit the text messages? Have you understood all of that?
Yes, Your Honor.
Okay. So I'm just going to go over your constitutional rights. So you have a constitutional right to one trial of the charge. And you have the right to choose whether to have a trial before a jury or a judge. At a jury trial, the jury decides whether you are guilty or not guilty of the charge. And the judge's job during a jury trial is to rule on legal issues that arise during the trial, to instruct the jury on the law of the case, in other words, what the Commonwealth has to prove, and to impose a sentence if the jury were to find you guilty. So that would be the judge's job during a jury trial. But the jury would decide whether or not the Commonwealth proved that you are guilty beyond a reasonable doubt. All right? You understand that?
Yes, Your Honor.
And at a jury trial, you'd have the right to a trial here with 12 jurors. These are people selected from the community. You'd have the right to participate in selecting the jurors, and you could not be found guilty at the jury trial unless the Commonwealth convinces all 12 of those jurors that you are guilty beyond a reasonable doubt. So do you understand all of your rights and how a jury trial works?
Yes, Your Honor.
All right. And also, you could choose to have a trial by a judge instead of a jury. And in such case, the judge cannot find you guilty unless the Commonwealth convinces the judge that you are guilty of the charge beyond a reasonable doubt. Do you understand your right to a judge trial?
Yes, Your Honor.
Do you understand that by waiving your right to a jury trial, the judge will be me? I will be deciding whether the Commonwealth has proven the charges. Do you understand that?
Yes, Your Honor.
Okay. And you understand that by waiving or giving up your right to a trial by a jury, I just already told you that. So do you generally understand the difference between a judge trial and a jury trial?
I do.
Okay. And do you have any questions at all about the difference between those two types of trial?
I do not.
All right. Now, I'll just hand you this. And I'm showing you a form called the Defendant's Waiver of Jury Trial and Consent to Trial by a Judge. Did you read that form?
I did.
Did you discuss it with counsel, with your attorneys?
I did.
All right. And did you sign that form?
I did sign it.
And do you understand that the form says in writing what you and I have been talking about thus far about giving up your constitutional right to a trial by a jury?
Yes.
Okay, did you sign that form voluntarily?
Yes, I did.
And by signing the form, are you saying in writing that you know about and understand your right to a jury trial, which is explained on the form, and that you voluntarily give up that right?
Yes.
And do you now willingly and voluntarily waive your right to have a jury decide your case instead to choose? You think that I have never done this before. Maybe I'm the one that's nervous.
I'm nervous.
Let me start over again. Do you now willingly and voluntarily waive your right to have a jury decide your case and instead choose to have a judge, that being me, decide if you're guilty or not?
Yes.
Okay. And do you understand that your waiver of your right to have a jury decide your case is final, and you cannot change your mind and ever ask for a jury trial again in this matter? Do you understand that?
Yes.
Has anyone threatened you or forced you in any way to waive your right to a jury trial?
No.
Has anyone promised you anything in return for your decision to waive your right to have a jury decide the case?
No.
Have you had enough time to fully discuss your right to a jury trial and the difference between a jury trial and a judge trial with your attorneys?
Yes.
Do you feel as though your attorneys have acted in your best interest and that they have fully and adequately explained your right to a jury trial and the difference between the two types of trials?
Yes, Your Honor.
Have you been confused by anything I've said thus far during this colloquy?
No.
So as I understand it, then you're waiving your right to have a jury decide your case, and you're choosing to have me, a judge, decide whether or not you're guilty because you want to and because you believe it's in your best interest to do so. Is that correct?
Yes, Your Honor.
All right. And the defense, any additional questions that I should pose? Commonwealth?
No, thank you.
None? Okay. All right. Does the defense or the Commonwealth know of any reason I should not accept the waiver?
No. No, Your Honor.
Okay. All right. You may step down. Thank you very much.
Thank you, Your Honor.
All right. I'm going to make the following findings. Yeah. No. Mr. Rowan can take that. Thank you. So I'll make the following findings. I find that the defendant, while she is presently or has taken medication, prescription medication in the last 24 hours, I find that that medication has not affected her ability to understand and participate fully today. I also find that although the defendant, Ms. Fitzsimmons, has reported that, or at least, I don't know if she reported it, but I do know that, at least in the past, she's suffered from mental health conditions, and that perhaps some of that medication is related to that. I do find that any mental health condition that Ms. Fitzsimmons may have had or has not affected her ability to understand and participate fully in the proceedings here today. I further find that Ms. Fitzsimmons understands the nature of the charge against her and the consequences of waiving her right to a jury trial. I find that the decision to, I find that Ms. Fitzsimmons' decision to waive her right to a jury trial is made with the advice of competent counsel. And finally, I find that the defendant's waiver of her right to a jury trial has been made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge and understanding of its consequences, and accordingly, I accept Ms. Fitzsimmons' waiver of her right to a jury trial. All right. With that in mind, so we'll anything you folks want to go over, but I anticipate we'll just start on Monday morning. Are you prepared to? Because maybe you're not, given that I had said that.
Sure, I hope to be. I mean, that wasn't the plan for all our witnesses, but we'll reach out today and make sure, or ensure everybody that we can have is available Monday.
Okay. All right. And so let me say this. I realize that from both sides' perspective that trying a case, whether it's jury or not, is like trying to it's difficult herding all your witnesses together. I usually try to make a joke about it. It's like herding fish or something, but Mr. Kubitosi's heard that probably 300 times. But in all seriousness, we will, Mr. Rowan, we're going to go full days. And to the extent that you folks, you run out of witnesses on a day, it's just life, that's fine. Do you expect now with this new, let me ask, with the new kind of schedule where the trial is, the actual evidence in trial is going to start earlier, do you expect any witness availability issues?
Well, everybody was free for the week, so no. I mean, I don't anticipate whether somebody is available Monday in particular.
Okay.
We'll find out. But.
All right. So it is my anticipation that whatever however we proceed, that the trial will be over by Friday. Is that a good, fair schedule or fair belief that I hold, I guess?
Yes. So.
Okay. Okay, so we'll just start up on Monday morning, all right? I'll see you folks there.
Yeah, sorry, I just wanted to point up something for you that you were talking earlier about jury instructions and instructions that you would take into account yourself. And there's one slight, maybe a curveball. There's a Code of Massachusetts Regulations. Okay. I just want to give you the citation. It's 555 CMR 6.05 parentheses 3 close parentheses.
All right. So let me say this. I don't know exactly what you're referring to, but maybe it makes sense for me to just explain. So what I will ask is that you folks submit. They can be in the form of jury instructions, but just instructions that I will use when I deliberate as to the law of assault by means of a dangerous weapon. So whatever it is that you're referring to, Mr. Brady, you should just put in that document again, whether it's however you want to title it, it's fine. But
it's from the post-commission regulations, Judge, and it's a CMR that states that an officer is not permitted to use deadly force to someone who is a danger only to themselves. And that's really the central issue in the case.
Right, but again, without having it in front of me, what does that have to do with whether the Commonwealth will be able to prove that the allegation is that Ms. Fitzsimmons committed the assault by means of a dangerous weapon. So I'm not following.
I think it has sort of a general import where if the court has a reasonable doubt as to whether or not Ms. Fitzsimmons was engaging in conduct that was harmful only to herself, it does not, by law, excuse the Officer Noonan shooting her.
Frankly,
I'll spell it out.
I don't understand, but
I'll spell it out.
So let me just hold on one second, Mr. Brado. What I expect is that perhaps at the end of the evidence and even before closings, we'll have a charge conference. We'll treat it just like we would in a jury trial, and you folks can make your pitch on the law. But I will want some submissions on the law that I should be, again, as it relates to the charge and the elements and things of that nature. If there's some defense that you're asserting related to that, you can, perhaps that would be a mechanism for raising that. All right, but right now I don't understand it, and I'm not sure that I need to at this point. All right, and anything else?
Your Honor, do you start at 9? 9 a.m.?
Yes, I'd like to. We do our best to start at 9. Mr. Wayne and I are always ready. But
I know Mr. Wayne wakes up early because if we get emails from him.
But Mr. Wayne and I are seem to be the only ones that are ready at 9. But yeah.
And just folks, 9 to 4 is a full day for the court. I'm just
right.
Okay. Thank you.
It is. And like I say, if you folks can disclose to one another what witnesses you think you're going to be calling on a given day, and that would be.
And with your permission, I think we should be able to pre-mark a number of exhibits.
Yes.
Okay.
So you'll work that out with Mr. Wayne. That would be great. Also, if we need to take a defense witness out of order, I certainly would hear the Commonwealth if there's an opposition to that, but even for a jury trial, I typically would allow that. Again, if it's a scheduling-related matter, not a strategy-related decision, but if there's some scheduling conflict, that will help it proceed. All right, so we will see you folks Monday morning. Thank you.
Thank you.
All right, please.
All right, so we heard a few things there. We heard a few things. We heard that, we heard a lot of things. That Kelsey's going to take a bench trial. But more towards the end, they're going to start at 9. She's taking the bench trial. Some text messages. It seems like text messages are going to come in, but they're going to be redacted. What else? Aaron found some photos that I'm going to show you guys. Aaron found some photos of Mr. Justin there. There's old Justin smoking it up. And then here's another one. There's another one of him. I wonder if Kelsey smokes too. I wonder if maybe that kind of was part of the problem where he's just smoking a lot and Kelsey's just like, I'm just not into that, I just wonder. I wonder if that's part of their problem, Anyway. All right. I want to play the presser. We have a press release after that. And then I've got a few more things I want to show you guys. And then Aaron found something that we're going to save for tomorrow because we want to wind down our day just a little bit here. But we found some things that we'll play tomorrow for you guys. So definitely join us tomorrow. It's going to be good. We got some more things to show you tomorrow. All right. So here's the press release after the hearing. So this is the same day. This is the press release after that hearing.
Kelsey Fitzsimmons has just wanted the truth to come out about what happened on that day in June. And she's wanted a fair trial. She has decided, and we've talked with her about it, that trying to get to that fair trial, an option with the judge is the most efficient and the best way to do that. And so, as you can see, the judge made a full inquiry of her. Everybody has a right to a jury trial, but they also have a right to a judge trial. And we are prepared to start on Monday and move forward to make sure that the truth comes out, and we're confident that it will.
Why did you decide this was the better venue for the truth to come out? Like, why is the judge a better person to decide that than a jury?
So it's not a question of better or not. It's a question of knowing this case, the facts of this case, unusual facts, by the way, with 2 police officers involved. There is a certain amount of credibility that the fact finder has to make. And we thought it was important to make sure whatever we did with a jury or a judge, that we would be able to stick to the facts of what happened on that day. Kelsey has been transparent about what happened. She's spoken about it. there is sometimes in these cases a lot of excess noise around it. And it's important to her and to us, her counsel, to make sure, as we always do, that when we go to trial, we are going to have a fair finder of fact. And we just felt, all things being equal, really, that choosing a judge trial, what we call a bench trial, made the most sense in this case.
Is there a very specific question that needs to be answered in this case? Is that maybe a judge could do that more efficiently than a juror who might start to get cloudy if they're bringing in text messages from that day? And can you kind of elaborate on that?
Sure. Well, the judge's job in a jury trial is always to keep out extraneous information, to make sure that whatever comes in, whatever the decision is based on, is relevant and not too prejudicial. You heard some of that today in the judge making those decisions. But because there is, in this case particularly, we think unusual circumstances, that keeping the focus, a laser focus on the facts, what does the evidence allow in? What's relevant? What's probative of what happened? And where we have two somewhat conflicting stories, shall I say, we felt that making sure that we could have a trier of fact who would focus on that. And look, I have a great deal of respect for judges. Both Attorney Bradel and I have tried a number of jury cases, and they are interesting and they are important. And some cases are just better suited, we believe, for a judge to make a determination. As we've said, it is a simple case. We want to keep it simple, we want to keep it to the facts, and we believe with this option that's what will happen.
Do you think it's still going to be a 3-day trial?
It could be. If we start Monday and we go full hours from 9 to 4, it is quicker with the judge, just because jurors sometimes are late and they need to take breaks, and that's not a criticism of them, they're people. But we think it can probably move a little more quickly, and so it's hard to know, but I would think maybe 3 days.
I think so.
You never know, but probably it'd be quicker than trying to impanel a jury. As the judge noted, impaneling the jury could take longer than actually trying the case. And so we'll be able to start Monday, we'll get right to it. The Commonwealth also does this, tries bench trials all the time, and so it's not that unusual that we're doing this.
Kelsey, how do you feel about this approach of the bench trial?
I made a good decision with it. I chose the judge to be the fact finder of the case, and I think that's just makes the most sense in my case.
Do you think, did you make the decision during the motions process? He seems like he has been definitely accommodating, he seemed very impartial going through all the hearings. And when did you guys make the decision, if you're able to say?
So Bob, lawyers are always very jealous about their decision-making process, their, kind of how you make the sausage, so to speak. But, bench trials, in Martha's, in my experience, you know him when you see him. And this is a good occasion for a bench trial. We're excited about it. It's going to be economic. It's going to be efficient. Kelsey and Martha and I and Courtney as well, we always have an ongoing discussion. We always joke that we're talking about 4 things at once, and it's just an ongoing thing. And we felt that Judge Karp has been extremely fair. We have not been happy with the pretrial process up until landing in Lawrence, and now we're pleased and we feel heard. We feel like we have a good seat at the table, and we're going to go from there.
So on the docket, it lists a new judge for the jury trial. Is that just a mistake, or?
I think there's a lot of computer static that happens on those lists, and that's why I didn't want anybody to read too much into it.
Do you think that social media affects, or what effect does it have on, the choice of a bench trial versus a jury trial? Do you think it's more difficult for attorneys in that way now?
I'm sorry, I missed your question.
Just, how social media affects, your decisions in cases, whether you want to do a bench trial versus a jury trial. Does it have an effect?
I don't think so much in this case. It might in others. It certainly requires extra precautions by both counsel, by the judge, who's trying to get a jury that is not aware of or has reached a decision about a case is a little harder, obviously, with social media. In this case, it's not going to be an issue because it's jury waived, but that was not one of the deciding factors for us, frankly.
Was the public's general sense of skepticism for law enforcement playing a role at all? Kind of coming off of Reed with that investigation, finding a jury versus a judge. Did that weigh in at all with, obviously?
I don't think it did. And I watched that trial very closely, obviously, as many of us did. Different set of facts, different dynamics. Here it is much more simple. It is something that happened one day. There's 2 police officers involved. It's just a different dynamic. So I don't think that entered into our decision making at all.
And also, Bob, don't forget, we got a law enforcement lady right here.
That's what I was wondering.
So, I think there's just as much support for law enforcement as there is skepticism, and it's really more about the actual facts of this case. And, we've never shied away from that. We've been eager to get here. So we're glad we're here. I know Kelsey's glad we're here. And, she's been on the job. She was a CO. She's a patrol officer. She's served restraining orders. She knows this arena very well. So we're comfortable here, and we're pleased to go forward in this, right, Kels?
Yes, absolutely.
How you feel Monday? It's Monday. You've been waiting so long.
Again, I'm eager. I've said from the very beginning the truth will come out, and it will.
Thanks,
Speaking
Kels.
of eager, it seemed like you smiled when you told the judge you were, excited to maybe restart law school. Are you looking forward to getting back into it?
A lot of my life was put on pause very unexpectedly, so I'm looking forward to getting back into everything. Most importantly, being a parent and mom to my son. But going back to school is definitely in the cards.
Thank you, everybody.
Thank you.
Thanks for being here. We appreciate it. Have a good day, everybody.
All right. So one more thing. I just want to play you one more thing, and then I'll do a quick high-level recap, and then we can call it a night. Here's Justin's interview. We've heard all about Kelsey. Let's see what Justin has to say. Let's see what
It's an exclusive.
Let's see what Justin has to say here. I want to hear. Let's see what he has to say. All right. So this is Justin's side of the story.
Tonight, as we are hearing from the former fiancé of Kelsey Fitzsimmons, the North Andover police officer who was shot by a fellow officer, Fitzsimmons contends her fiancé broke into her house days later to steal evidence in their ongoing child custody case. NBC 10's Robert Golston brings us the exclusive one-on-one.
Kelsey Fitzsimmons' estranged fiancé, Justin Aylaian, sat down with NBC 10 Boston to share his side of the story. He did not want the interview recorded. He admits this is him with 3 others, forcing the door open to the home where he lived with Fitzsimmons until they're falling out. Aylaian and his attorney shared documents they say prove he still lived there, and he told us, "I had every legal right to get into my own home, to get my belongings, and more importantly, my son's belongings."
He has no rights to that house whatsoever.
Fitzsimmons' attorney Tim Bradel says when Aylaian requested the restraining orders days earlier, he signed an affidavit that said he no longer lived there and lied to the officer when he asked for an escort.
He says that he still lives there. Completely contradicts what he already swore to the probate court judge, family court judge, to get the restraining order.
Bradel argued Aylaian is not being charged because the DA needs him to testify against Fitzsimmons in the criminal case. He is on the witness list for Fitzsimmons' criminal case, but not a key witness.
He might be a background witness. He heard the shots, but as far as what happened in the bedroom, he has no idea.
Aylaian told us he did not touch any of Fitzsimmons' stuff on the day in question, and he said he even called police when the alarm went off. He also told her father that day, "I tried to do everything to help your daughter." Fitzsimmons' criminal case will be back in court on Thursday with a trial scheduled to start on March 23rd. In Lexington, Robert Goulston, NBC 10 Boston.
And be sure to stay with us on the air and online for continuing coverage of the case against Kelsey Fitzsimmons. Once her trial gets underway, that's going to be on March 23rd. We're going to bring you live coverage over on our sister station, NECN, as well as on our YouTube channel.
Yeah, that seems a little, breaking in like that. I don't know. That seems a little dramatic, if you will. All right. For those that have been looking for a high-level overview, we've got Kelsey Fitzsimmons. She was involved with Justin here. Justin Aylaian. Is it really Aylaian? Anyway, so they were engaged to be married. They had a baby boy. She is an officer, and he's a firefighter. So they apparently separated. We still don't know what caused them to separate, but she on June 30th, let me go back to here. On June 30th, Justin calls her and says, "Hey, meet me at a playground." So she goes to this playground with her child, baby C, son, boy. She waits for 3 hours. Justin doesn't show up. So she comes back to the house, and I think she's laying down. She might be feeding the child. She's just hanging out, whatever it is. It's like almost 5 o'clock in the afternoon. 3 officers knock on her door. Now, she knows one of them. That is Officer Noonan. She had gone through an experience with Officer Noonan the year before, literally the year before, so that was in July, that they went to a call, and there was a woman who took her own life and then took her infant's life and then took her own life. So she said her and her partner, Officer Noonan, experienced this traumatic event together. And that's obviously still sticks with her. So when Officer Noonan is one of the 3 officers that comes to issue a restraining order on her. That restraining order says you have to give up your child, you have to give us your firearm because she's an officer, she has firearms, and you're going to lose your job pretty much. So she is very distraught. She has postpartum depression. She's mentally just not there, right? She's just unstable. She's her world basically just exploded in the matter of 10 seconds. So I didn't know this before, but now I know this now. Justin he came to that house. So he was in the basement collecting his things while they were upstairs. So she said, "Okay, let me go get stuff for the child." So she's going around, she's collecting diapers, clothes, food, all this stuff for her baby to hand over to Justin. So in the meantime, it's her and Officer Noonan in her upstairs bedroom. She says she pulls out her firearm, she points it to her temple, and she proceeds to pull the trigger. However, it just clicked. Now, what Officer Noonan is saying is that he's telling her, stop, don't do it. He shoots her. He shoots twice, but he only hits her once. So he shoots once. I guess it misses her because he says she's trying to load the pistol. She tries to get one round in. He shoots her right here in the chest. Her rib explodes. She has a collapsed lung. And then the officers did find there was a round in her firearm. That's what they're saying. She's saying she was in such a distraught situation, emotionally disturbed. She wanted to take her life because basically her entire world was just exploding. So she wanted to take her life. She says she never once pointed her firearm at the officer, at Officer Noonan. So that's pretty much it. And then here we are. She's going to do a bench trial, and that's it. That's it. All right. How is my audio? I feel like my. All right, my audio is not too bad. What happened to my audio? I feel like I got to turn my audio up. Okay, hold on. I feel like my audio is like. All right, I guess it's okay. All right. So with that, maybe I'll just bring it closer. I had it far away. All right, so that's it. That's what I got. So good night, guys. We're going to wrap it up here, 6:10 on the East Coast. We heard them say tomorrow, 9 o'clock start, 9 to 4. They think it's going to be about 3 or 4 days. So with that, I will leave you with said kites. We got a little Super Ball over here. That's a good girl. Super Ball being a little munchkin over there. Oh, with her little murder mittens. Little Super Ball being all perky over there. I got little Houdini over here. This is Houdini. That's a good girl. Yeah, it's a good girl. Oh, Super Ball's coming to say hello. Yeah, that's a good girl. You want to say goodbye? Say goodbye. Hey, come over here. Look over here. Yeah, say goodbye. Say goodbye to the good people out there watching us. Here, look over here. Yeah, say goodbye. That's a good girl. All right. That's a good girl. All right. Super Ball says hello. Have a wonderful evening. Thank you guys for spending your day with us. We really appreciate it. Thank you for the super chats. Thank you for the memberships. Thank you for the cups of coffee. Really appreciate that. That just helps us maintain, providing this content for you. So we really, 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 really do appreciate that. We love the fact that you guys just hang out with us. You drop knowledge on us. We try to educate you. I love it when you guys educate us back. We don't know everything, and it's nice to know we have a collective group that shares knowledge amongst each other. I really, really appreciate that. Nick, thank you for dropping in, doing a raid. Really appreciate that. I'm going to go check out you did a pretrial catch up as well, so I'm going to go check that out. And thank you to our mods for keeping our space, a kind, courteous, respectful place that it is. And finally, thank you to Erin, who does all kinds of things on the back end. She creates graphics, she does shorts, she maintains stream integrity. So really, thank you so much for Erin and all that she does. She found some really good stuff. So tomorrow she found some great stuff. She found documents, she found all kinds of stuff. Anyway, so we'll save that for tomorrow. So with that, have a fantastic evening. We will see you guys tomorrow. Take care of yourselves. Enjoy the rest of your Sunday. And we will see you tomorrow at 9 o'clock Eastern. Take care, guys. Bye.